Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we are here to watch day 7 of the Brendan Banfield trial. Day 6 was tough. Oh my word, with the defense asking the detectives the same 700 questions over and over and over and over. Okay, so I think the cat's out the bag. There's people in chat already giving spoilers and all that, saying that they heard. I didn't hear it. I was listening into some of the jury instructions, which we'll do our best to watch now. Some people heard that he's going to testify. I don't hear it myself yet, so we shall wait and see if he will. If Brendan Banfield's going to testify, that'll make the day more interesting for sure. Okay? I must also confess that in my scramble to try to hear that, I now forgot to turn on closed captions. Sorry about that. I got a flood of emails about it, and I was scrambling around looking at that, and I'm like, I can hit go live before I put the closed captions on. It'll be available on the replay, but not for the live stream. Sorry about that. Okay, so are we ready to start day 7? Welcome everyone. Please like, share, so everyone knows we are live right now. And let's see where this day leads us, shall we? Okay, so we've got this. Where the judge, let's just see where the judge started. Got to boost it.
The disagreements are primarily in the charging instruction, and the Commonwealth has 2 versions at this point in time, depending on what.
Okay. Well, let's see what we have.
We're going to watch this faster than normal. That's why we're starting like we are. I'm going to put it on 1.25 speed, okay?
Yeah, that needs to go. Yeah, that needs to go.
Can you? I'm sorry, I could say.
Do you have a preference as to whether we're numbering or lettering?
No, it doesn't matter to me.
Okay. So, may I just chat with her? Maybe I can narrow this down.
All right.
I mean, he has to.
So
He has to take the stand to try to explain himself. And if he tries to blame it all on Juliana, someone could buy that. Someone could say, he could say, she was obsessed with me. I don't know. Yeah, we were inappropriate, but I didn't know she's going to plot all that. Don't you think it could create reasonable doubt if, like the detectives said in their messages yesterday, huh? They initially thought Christine had been stabbed before Joe even got there. Yeah, I feel like if Brendan Banfield goes down that route of trying to explain what happened, that almost like Juliana set him up, I think it could get interesting.
Judge, this is going to be a waste of the court's time.
I'm sorry, but this is when I set it for, and I told you 2 days ago, so we are doing it now.
I understand, and I'm happy to do it now, but if we have 2 minutes to discuss with each other,
No,
we would be
it
able
was
to.
10 o'clock. You could have discussed at 8 o'clock. You could have discussed at 9 o'clock. It was 9 o'clock now, but you discussed at 8 o'clock. You had time yesterday. I told you 2 days ago, so we're doing it now. So let me have a copy of your instructions.
Ooh, this judge doesn't play her with time. Judge, we need 2 minutes to discuss it
Judge,
with
I
each
would
other.
note
No.
that we will have another set that will be final, again, depending upon what happens
I understand.
with testimony.
This judge. I love this judge. Oh my word. Okay, flappity flap flap.
I just gave her mine, so I'll number judge.
All right.
So just a reminder, the court isn't normally on a Friday for this trial, but the judge has asked everyone to come in today to have a full day because there's a snowstorm that's hitting many areas in the USA. I hope for all of you who live there that you will stay warm, that you will stay safe, that you will be okay. This will mean that the trial after today, it'll be delayed for a few days. The judge anticipates maybe until Thursday. So we shall see if the defense is able to rest today. If they're able to rest today, the state said they have about 2 rebuttal witnesses. Whether they call them or not, we don't know. The judge's goal is to see the evidence finished today and then to come back for closing arguments. That's the judge's hopes and wishes.
Your Honor will be instructing the jury that they will have, and I think already has instructed the jury that they will have all of the evidence back with them, so we can skip the model that tells them that they'll
That's
get.
fine.
Okay.
Do you have a copy from Mr. Carroll?
I'm sorry.
Do you have a copy from Mr. Carroll, so we can?
He was emailed.
He already has a copy.
Yeah, he has the digital
Perfect.
copy.
All right, so that's yours? All right. Thank you.
When there's fluff like this, I'm going to go forward. That's why we started late, so we can just...
Detective Bryant has been released by...
Yep.
Judge, on an unrelated matter, Detective Bryant has been released by defense. He was their subpoenaed witness. May he join us in the courtroom for the duration of the trial?
Any objection to that, Mr. Carroll?
No, Your Honor.
Okay, that's fine. Thank you. Do you think we could remove the gum?
Oh, I'm sorry, Judge. One second. Hold on.
I really like this judge. Look at her, look at her. Did you see how she threw a pin? Oh my word, Judge. She is a grizzly. This judge is a grizzly. We claim her. She's not amused. Sorry, let's go forward. See, so much flapping of papers. Okay.
All right.
Okay, we'll catch up in no time.
Let's start with the Commonwealth then. You have a copy of the Commonwealth?
I do, Your Honor.
Okay, great. So then first instruction, instruction A is just that the defendant is presumed innocent. I assume you have no objection to that instruction?
Judge, I have 2 versions of it. Would it be the bold one?
I have one where it says Brendan Banfield is presumed to be innocent. You shall not assume Brendan Banfield is guilty. There's no burden on him. And it keeps going down. There's no burden on him to produce any evidence. It's the same as your instruction 1, except they put his name in it. And it doesn't, yours says the defendant and his,
Okay.
theirs says Brendan Banfield. Other than that, it
I
appears.
don't have an objection. That's number 1?
No, that's their
Or-
instruction A.
A, sorry.
So then you'll withdraw instruction 1 then?
I will, Your Honor.
Okay, 1 is withdrawn. Here, you keep a track of that for me, Shannon, thanks. Okay. Instruction B is, from the Commonwealth, is that Brendan Banfield does not have to testify. Any objection to that?
No.
Okay, B is, I'm sorry.
If I might, it might be easier to just go through his. They're duplicative in a number of locations.
Let's just start with yours, and we'll be able to see that when we get to them. Okay. Instruction C is, okay, well, I do have instruction 3 from Mr. Carroll that it doesn't have to testify, so we'll withdraw 3, correct?
Yes.
Okay. And then instruction C is any fact that may be proved by direct evidence may be proved by circumstantial evidence. Any objection to that, Mr. Carroll?
Sorry, Judge, I was just speaking.
It was a direct evidence versus circumstantial evidence instruction.
Same as the Commonwealth's.
No, this is instruction C,
Yes.
which
No
is your
objection.
instruction
No
H.
objection. That appears to be a model.
Right, so you want to withdraw instruction 8, it's the same.
Yes.
Okay.
Withdraw.
So the big rumor right now, which is semi-confirmed, I'm not comfortable yet saying, yes, it's definitely happening, because it's just, I can't. My brain can't. It will get too excited, okay? Just wait for it. The big rumor is that Brendan Banfield will take the stand. If that is happening, I'm already updating the thumbnail. I'm making one in case we actually see him pull up that diaper of his and get his ass on that stand. Oh my word. Can you imagine?
Instruction
Instruction
A.
8.
Oh,
8.
8.
8. 8. Instruction C will be given. Instruction D, you are the judges of the facts and the credibility of witnesses. It's the same as your instruction 9. So any objection to D?
No, Your Honor, it appears to be a model.
We'll withdraw 9 then. Instruction E, if you believe that a witness other than the defendant made a previously inconsistent statement, which is your instruction 11. So any objection to E?
No.
E will be given, 11 will be withdrawn. Instruction F is the firearm charge. That it just gives the elements of the firearm charge. Do you have any objection to instruction F?
No, Your Honor.
Does he have any charging? Okay, so F will be given. G is just a definition of a firearm. Any objection to that, Mr. Carroll?
No, Your Honor.
Okay, G. H is the child abuse or neglect charging instruction. Any objection to that? All right, H. I is the willful act done with a bad purpose or without justifiable excuse, or without good ground of believing of the term. So it just defines a willful act. It's a model instruction. Any objection to that?
No, Your Honor.
That's I. Did he have one?
He did.
Trying to pull
willful
him as we get
act.
to-
His was number, this hour, 20.
Yes. Law and crime. Kathy Russon says breaking. Defendant Brendan Banfield will take the stand in his own defense. We're going to hear that with our own ears, but like what? If we're still busy with this and he takes the stand, we will just skip ahead. We'll skip ahead and finish this later. How about that? Because we cannot. We have to watch that live. Oh my word.
Did you have an instruction for definition of willful act?
I believe I did, Judge. I don't have an objection to.
All right, we're just finding which one we have to withdraw from yours.
Judge, I found it. It is
27.
I found it's.
I have 27 as a definition of willful, deliberate, premeditated.
that
Okay,
matches.
so we'll withdraw 27. All right, J is the charging for aggravated murder.
Thank you,
You said
Ginger
you had two of
Snips.
these
Judge, I
instructions?
think we may have skipped one. J should have been the instruction for child endangerment. Did I miss a letter?
I don't have that. I have instruction in
J
J.
is aggravated murder. And yes, there are two. There's one for Joseph Ryan and one for,
So J and K.
yes, ma'am.
I have, I'm sorry.
Their J and K is crime of aggravated murder.
Okay, I have, in the order that they gave it to me, the next one was crime of child endangerment.
But it's not what I have. I have
So
J.
skip down one more. It's okay. Just go to the next one. You'll see it.
I have,
No, I know, I definitely see that. I'm just saying this is in line.
right.
Okay.
It's supposed to say Joe Ryan.
So I have,
Joseph Ryan and the aggravated murder person.
J is,
I know they switched it on you, okay? So they have J now as the crime of aggravated murder with the same act or transaction. And then K, they
Yes.
have the one with the 3-year period.
Where are the duplicates?
sorry, Judge, I see J.
They're in the non-sign.
Do you see the two instructions for aggravated murder?
I do, I have J and then K.
And you have one,
In reverse order on the victims and then same act or transaction. So the
Gonna
first
take my
one is
thumbnail.
Christine and Joseph. The second one is Joseph and Christine.
I don't have those. I only have 2 for aggravated murder, you should have 4.
I understand.
Sorry, Your Honor, we do. I have them in our.
They're in a separate file.
They're in a separate file. We have documents with sites and documents.
And Judge, these are the ones that we intend to replace when we understand. We have a waterfall instruction as well that we haven't produced today because we have yet to determine how far we're waterfalling based on what the defendant does. So the charging instruction would be replaced under it. These will not be the final.
I don't know what to do, so we'll just pass on the charging instructions for the moment, I guess. You had one as well.
I do
His
have,
waterfalls include, there is no scenario where we would waterfall a second degree. They are missing some elements, so I don't believe that his are the appropriate instructions either.
So let's just skip the charging instructions for aggravated murder. We'll come back to those, okay? So we'll pass by J and K.
are they still J and K
That
that we're
yes,
passing?
yes.
Okay.
I assume there's going to be more.
Yeah.
We'll see. Instruction L, I think actually that was your instruction 17, willful, deliberate, premeditated. Definition, you have any objection to that?
No.
Okay, so L. Instruction M is you don't have to prove a motive for killing. Any objection to that?
No.
Okay. M, N,
I am monitoring the other court feeds, okay, just to make sure that if he takes the stand and we're still watching the instructions, that we will not miss a thing. Don't you worry about it. Okay, Lexi and the liar said he might put the heat on Juliana for the FetLife account and luring Joseph, but there's no way he can put her up as a murderer. I mean, I think he could, because he left the house before her. So if he takes the angle of, I don't know, she stabbed Christine, then left the house with the little girl, stayed in the cul-de-sac, had Joe come over, then called to say there's this intruder. I feel like he could go that way. You know? And especially because the detectives said yesterday that's what they initially believed happened, that Christine was stabbed before Joe even got there. So that's going to be very interesting. If you see me looking to the side a lot, I'm monitoring all the court feeds, I'm looking at all the emails, I'm looking at what's going on. Don't worry, I'm right here, I'm listening, and I'm right here with you. I'm just highly anticipating, as I'm sure you are. Oh my word, we survived yesterday, everyone. Wow, that was hectic. So if he takes a stand today, it's definitely going to be such a huge change of gears, as the defense likes to say.
And the fact that the defendant's been indicted by grand jury is not evidence, and I assume no objection to N?
Okay, I haven't yet, and no objection.
Okay. Instruction O is a concert of action instruction. Any objection to that?
There you are.
Okay. P is if anything is rejected by the court, you can't consider it. Any objection to that?
No objection.
All right, Q is a malice instruction, which also goes into heat of passion. Do you have any objection to that?
I don't have
Well,
it
if
in
you're
that
giving a
order,
heat of
Judge.
passion instruction, then wouldn't you be second-degree waterfall?
The next instruction after,
I'm just asking a question here.
I'm sorry, Your Honor.
Your instruction Q has the definition of malice and also heat of passion.
Yes.
So if we're giving a heat of passion definition, that's a second.
And again, Judge, it depends upon whether or not the defendant testifies. There would be a replacement for malice that does not include heat of passion.
Is the defendant going to testify, Mr. Carroll?
yes.
Yeah, excuse me?
There it is. There it is. Oh my word. Is the defendant going to testify? Yes. Sorry, what? Is he going to testify? Yes, he just said it. He just said it. You get your ass up there, baby boy. Oh my word, we heard it with our own ears. Skybird56 said justice for Christine and Joe. Yes. Melody Bradley, thank you so much for your sticker. Thank you, Skybird, for yours. Carrie said, but Christine was alive, but dead like the cops thought in their text. Doesn't matter. If they could convince any of the jury members, and I'm not rooting for the defense, I'm not rooting for like Brendan Banfield, I'm just saying he's presumed innocent unless proven guilty in a court of law. Okay, number one. Two, if he gets up there and he frames it a certain way, I think he could create some reasonable doubt. I think he could. I think it's possible. You better be careful with that. I'm sure he thought it all through. That's probably why he's been scribbling around. But yeah, he's going to take the stand.
Okay, then presumably depending upon what he says, this
Okay,
would
so
stand.
Q, so you don't have objection to Q then?
That's Q's malice.
Malice and heat of passion.
I
Tracy
believe
said,
that's
I
a model
knew
judge.
Okay, that's fine. It is. Okay, Q. R, that's inferring from a deadly weapon. Any objection to that? Inferring malice from a deadly weapon? It's a model instruction as well.
No, Your Honor.
All right, R.
And that's
Instruction-
R?
That's R. Instruction S is that you've been instructed on more than one grade of homicide. Any objection to
Presuming
that?
there's a waterfall.
Right. Any objection to that? It just goes down the different,
Yeah, it was just a little out of order on this.
okay, that's fine.
I don't have an
All
objection
right,
to that.
S. Instruction T is just you may infer that every person intends the natural and probable consequences of acts. Any objection to that?
Yes.
And again, I'm going to say, do not panic. I'm monitoring all the other court feeds, okay? If I see this guy lift his ass and even start walking, we're switching over immediately. We have about 20 minutes left of jury instructions, but we'll just skip over that, go to when he's testifying, and then watch the rest of jury instructions later, right?
No.
All right, so those are the Commonwealths that we have now. So what we're missing from the Commonwealth is the chargings for the aggravated murders, the 4 counts of aggravated murder, and the 1 of child abuse, correct?
Yes, ma'am.
Okay, so we're set on those, so I'll just put J and K to the side because it sounds like they're going to change anyway. Okay. Now let's just go through the rest of Mr. Carroll's just to see what we can add to that stack as of now. All right, I have instruction 2, the Commonwealth bears the burden of proving beyond reasonable doubt the identity of the defendant as the person who committed the crime. Any objection to that one?
No, ma'am.
All right, 2 will be given. You may consider the character of the defendant when proven by evidence, whether good or bad, along with the other circumstances. Any objection to that?
This was duplicative of our B, which I thought the court had included.
I have B, but B is Banfield does not have to testify, which might be taken off, but might be taken out if he does testify. But instruction 4 is different. Did you have any objection to instruction 4?
I'm sorry, Judge, I thought we were on instruction 3.
Thank you,
That was
Barb
withdrawn.
Murray
Okay, got it.
Byabs, for your
Instruction 4,
sticker.
no objection.
Okay. Instruction 5, the fact that he's indicted by grand jury. Do we already have that one?
Yes.
Okay. So you withdraw 5, Mr. Carroll, since we already have that one. we have it. That was instruction N of the Commonwealth, so I can withdraw 5, is that correct?
Yes, Your Honor.
Yes, okay. Again, 6, rejection of the court, that was Commonwealth's. Do you have it there? Commonwealth's instruction P, as in Paul. So you withdraw 6?
May not
It's the same
consider-
as their P.
Okay. Yeah, I do,
Okay.
Judge.
Instruction 7, I mean, I can get, I mean, it says upon request, any exhibits introduced in evidence, I send them automatically to the juries. I don't think we need that. If you want to withdraw 7?
Withdraw.
Okay. Then we skip to 10, all right, because he's already withdrawn the others. Instruction 10, the statement.
Okay, so because it's such an important day and Brendan Banfield, the defendant, expects to take the stand, from what I can see from the other court feeds, I don't usually want to, I want to just watch live with you. That's what we're doing, right? But I'm lurking a little bit on my other screens just to make sure we don't miss when he takes the stand. Right now, they're putting Detective Brendan Miller back on the stand. So we can just continue to watch this and then we'll skip forward and we'll catch up in no time, okay?
Is presented to you being made by the defendant and submitted for your consideration along with other evidence, assuming he testifies. Any objection to 10?
No.
Okay. 10 will be given. 12, if you believe from the evidence the defendant previously made a statement inconsistent with his testimony at this trial, do you have any objection to that if he testifies?
No, ma'am.
All right, 12. 13, any person sentenced to a term of incarceration for felony offense shall not be eligible for parole upon that sentence. That's a sentencing instruction, Mr. Carroll. I mean, if that's my understanding, the jury's not sentencing, correct?
Yes, Judge, and I just put them
So
all together.
we can
yes.
withdraw
We
that?
can withdraw that.
Okay. And I think 18 is to say, under the charge against the defendant, you may return one of the following verdicts. I guess, would that be the verdict form? Or
That's the verdict form, and Judge.
Yeah.
Can we withdraw that then?
We can withdraw
That's
that.
the jury instruction. I think instruction, I don't know how you have these numbered now.
That could happen too. Jeb Webster says, stall. He won't testify today, in my opinion, next week. I agree with you. I think if he's like, yes, he's indicated he will. I think you're right. They might stall. So we'll have to see. Will it happen today or not? We'll have to wait and see.
13, oh, that was instruction 14, I'm sorry. And this is 15, is a verdict form, so I can withdraw that.
Yes.
Okay. Instruction 16 is the co-defendant has testified she was an accomplice in the commission of the crime. When you find your verdict upon her uncorroborated testimony, you should consider such testimony with great care. The defendant may be convicted upon the uncorroborated evidence of an accomplice. Any objection to 16?
No, ma'am.
16, well given. This is 17 is sentencing instruction, so again, you want to withdraw that? Okay.
Withdraw.
Then your aggravated murder waterfall charge, I'm just going to put those to the side, 18 and 19. Okay, we'll get back to those. Okay. 20 is a self-defense instruction. Again, if he takes the stand, any objection to
No, ma'am.
20? Okay, good. Instruction 21 is also another self-defense instruction, reasonable belief of imminent danger. Any objection to that if he takes the stand?
Hold on just a second, Judge, because
Sure.
I had difference between murder and manslaughter is malice.
Okay.
Are we looking at,
I'm looking at 21. He had a 21, which just talks about the burden of proof for self-defense. And then,
Thank you so much. Is it Dr. Ender? Thank you so much for your $20 sticker.
which you didn't have an objection to, then 21, this defense is governed by the same principles but applied to self-defense. Defense of another person versus self-defense.
okay, I know where those are. Hold on just a second.
Okay, sure.
Okay, so. There at the bottom. Is this if you believe the defendant was without fault in provoking or bringing on the killing?
No. it's-
One more down from that,
Yeah,
perhaps?
this is, yeah, his in 21 is the defendant contends that he acted in.
Act in self-defense of another person under Virginia laws. Okay,
Yes, any
got it.
objection to that one?
Judge, I'm unclear. This is, his cite is the annotated jury instructions defense of another. I don't think that this is the form that instruction is.
I can put it to the side if you want to take a look at it. and
Yes,
make sure.
please.
Okay, so 21 we'll just put to the side.
Got about 10 minutes of jury instructions left. Sharon says, I would find the testimony much more interesting than these jury instructions, but I do understand. And we will get to the testimony. It's not one or the other, right? But don't worry, I understand. It's just that this is an important part of the process. And people get very upset if one leaves this out. You know what I mean? It's part of this whole process. We can't like skip over trial, whatever, processes. So we're watching this together. I have sped it up. It's 1.15 speed now, so that it's not too fast. Ali, girl, thank you so much for your sticker. And do not worry, we're going to get there. At least we can continue to speed up when it's the defense's case to continue to ask Detective Miller questions that have already been asked and answered about 700 times.
For now, Mr. Carroll, okay?
Yes.
All right. 22, again, that's first degree, that's the waterfall for first degree, so I'm going to just put to the side since we're going to go back to those charging instructions. Same with 23. 24 is the same definition of malice and heat of passion that we already have. I just, let's see if I can find which number it was, or letter.
I mean, true. Joe Hoffman says usually nuggets of information during outside the jury's presence. Exactly. Especially, I mean, now we heard that he plans to take the stand. We wouldn't have heard that if we missed this. You know what I mean? Okay.
All right, that's Q. Instruction Q is the same as your 24. Do you want to withdraw?
24 withdrawn.
Okay. 25, the difference between murder and manslaughter is malice. I'll just put that to the side till we get our waterfall instructions, okay? 26 is you may infer malice from the use of a deadly weapon, which I
We
think.
already have that in.
We have
Yes. What number is that? Do you have it just
That
for the record?
was- Thank-
Or letter?
I'm pulling it up, Judge. Local deliberate.
Deadly weapon.
Deadly. R.
R. Okay, so R is the same as your 26. Do you withdraw 26?
Yes, Your Honor, we'll
Okay,
withdraw
withdraw
26.
26. Then we're skipping 27's already been withdrawn, so we get 28. Once the Commonwealth has proved there was not lawful killing, then you may, but are not required to infer that there was malice and that the act was murder in the second degree, unless you want to just put this to the side for the
Yes, please.
charging instructions. Okay, we'll put that to the side, Mr. Carroll. And then we have 29. Again, that seems to be the verdict form, so or actually, that's another charging instruction for second degree. Okay, so we'll put that to the side. All right, instruction 30, that's a penalty instruction, so I assume you withdraw that.
Withdraw.
Okay, 30 is withdrawn. And then you have an instruction for felony homicide. I'll put that to the side with our charging instructions for aggravated murder. Instruction 32, to be in the commission of aggravated murder requires the killing result from an act that was an integral part of an aggravated murder, an act in direct furtherance of an aggravated murder, and an act necessitated by the aggravated murder. Any objection to?
Judge, we already put that in without the word aggravated. The model does not use the word aggravated, it just uses.
Okay,
murder.
which number is
I'm
yours?
looking.
Barbara North, member for 16 months, says like-minded people make me so happy. Thanks and love all my Grizzlies, to the Supermod squad, and especially to Grizzly with the finest, most honest, and carefully researched channel on YouTube. Thank you so much.
To prove the charge of murder, Commonwealth does not have to prove motive. That's the one we're on, Judge, right? That's our M.
It's your N?
M as in Mary.
Mem. All right, do you have any objection to withdrawing yours with instruction M, or would you rather have yours on instruction 32?
I'll withdraw mine.
You withdraw yours? Okay.
Yes.
Instruction 33, to prove the charge of aggravated murder, the Commonwealth does not have to prove a motive for the killing, the presence or absence of motive. We already have that as Commonwealth's.
Oh, no, sorry, Judge. Motive is M. Which one? I thought that's what we were on.
No.
What did he just
Oh,
withdraw?
yeah, motive is 33. The one he had before that, 32, is to be in the commission of aggravated murder requires that the killing result from an act that was an integral part of the aggravated murder, an act in direct furtherance of the aggravated murder.
And Judge, we don't believe that one is appropriate because we are not proceeding under the aggravated murder in the commission of robbery, rape, et cetera, the enumerated other felonies, so I don't think that one's appropriate.
So that would, they're only under subsection 7 or 8, which doesn't,
Right.
so did
So
you
I'll withdraw that.
withdraw that? Okay. And then 33 is the same as
33
instruction
is
M. So will you withdraw 33, then it's the same
Yes.
as instruction M? Okay. Then you have instruction 34, which again is the guilt phase, so I'll assume you're withdrawing 34 and 35?
Yes, ma'am.
Okay, we're getting there. And then instruction 36 is another self-defense instruction. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe the defendant reasonably feared under the circumstances that appeared to him, then he or others were in danger of being killed, or that he or others were in danger of great bodily harm, then the killings will be in self-defense. Any objection to that, 36?
And that's the one that cites 33,800 as
Yes.
the model? That's fine.
Okay, so we'll have 36. All right, so those are all the agreed upon ones that we have for now. Obviously, I'll take the one out. If he does testify, I'll take the Commonwealth's one out that talks about that he doesn't have to testify. All right, but for just right now, for Melissa and for everybody else, let me just read the jury instructions we have as of now. Instruction A, instruction B, instruction C, instruction D, instruction E, instruction F, instruction G, instruction H, instruction I, instruction L, instruction M, instruction N, instruction O, instruction P, instruction Q, instruction R, instruction S, as in Sam, instruction T, instruction 2, instruction 4, instruction 10, instruction 12, instruction 16, instruction 20, and instruction 36. Okay, so that's what I have so far. We will discuss at a later time the child abuse charging instruction and then the aggravated murder instructions with waterfalls after we have more evidence.
Yes, ma'am.
Okay, does that sound about right?
Yes.
Okay. All right, so these are all the ones that are withdrawn. Move on to those. Let me make a couple stacks here. Anything else at this time?
As to the jury instructions or as to anything
Well,
else?
as to anything at this point, I think we've gone as far as we can with jury instructions at this
Yes.
point.
So, Judge, I do have,
Just get a little closer to the microphone for me.
and I'm more than willing to approach if
Oh, that's okay, you can do it from there, that's
Okay.
fine.
Your Honor, I have an expert witness who I've noticed and I've been trying to move around.
Okay.
It's the person that, before we added this extra day, I had planned for Monday. He made arrangements for Monday. I tried to get him when we confirmed yesterday to try to get here today, and he's unable to do it because he's flying in from Nashville. Now, that's much like all the other things, that's an issue relating to the weather. And so he's an expert that we need just based on what's been
Right.
said.
Can you do remote?
I don't know. I didn't think of that as a possibility, but I can. This is my situation, is every time I'm trying to get in touch with him is usually after we've been here all day.
Right.
And then, so I haven't had the ability to do anything other than back and forth on email. So I haven't checked with him whether he can do remote. And I can't rest my case until obviously I get my
Right.
expert in. So I can call him right now and see if I can catch
See,
him.
if you can do remote, we can definitely set him up, and it comes up, and it's very clear and everything.
Okay.
I assume there's no objection to him being remote.
This is the audio expert?
Yes.
Yeah.
Yeah, and I mean, it might be easier anyway, because he might not be able to get a plane flight
Well,
next week at
that
all.
was my worry, is we're all
Yeah.
going to be, I mean,
Right, so-
and I'll tell you, Judge, at the beginning of the week, it didn't look like it's going to be what it is looking
Right.
like now. And
Well, that's
so,
what, yeah, well, why don't you call him now, and if he can just set up remote, we can definitely get it done this afternoon at some point.
Okay, let me see.
Whatever's good for his schedule, we can even break in between witnesses and just get him on his schedule, whatever's available for him.
Okay,
Okay.
when Your Honor adjourns, I'll go out and haul it.
Okay, perfect, I can take a break right now, right? Okay. All
Okay,
right.
thank you.
Right? Stefan says, so your expert doesn't answer your calls? It's a bit odd, hey. Get hold of him. Just stop saying you can't get hold of him. Okay, now we're going to skip to where they are. Here we go.
Good morning again. All right, do we have, able to talk to your
I
witness?
talked to him, Judge.
Okay.
I was waiting to find out some specifications, because he asked me those questions, which,
All we need is his email, and then Shannon can send him a link, and we just need to know what time, or if he's going to be prepared for whenever, we can send him the link right away.
I told him as soon as I had some sense of timing, that I would let him know, and he'd said.
And that's up to you, whenever you
Yeah.
want to, but we can send the link to him now.
Okay.
Do you want to get the email to?
I can definitely do that, Judge. Is it possible? I told him I would give him a call back to confirm that.
Sure, do
Can
you
I
want to do
just
it right
step
now?
outside
Yeah, just
and-
step outside,
Okay.
right now, that's fine. Well, I'd rather get that done to make sure we can get him taken care of.
My word. You're supposed to do it already. Come on, defense. This baby boy, look at him, everyone. He's getting ready for his big, big day. I just do wonder, is it going to be today, or are they going to stall? Yana? Stall. Okay, let's see. See, I'm so glad we started late. Aren't you? We watched the jury instructions and everything.
Yes, sir.
Okay. Stefan said, I bet this expert took a long weekend in the Bahamas. Again, thank you so much all for being here. Let's see how many of you are even here. I don't know how many people are going to come back today after yesterday.
Yes, sir.
Come back and join us, okay? We need to watch this whole trial together. And there will be a trial completion certificate after this, of course. Everybody yesterday was saying, it better be gold. I know, right? This one, you earned it. The hard way. Day 2 and 6, I think, were the most tedious. Day 2 was the cross-examination of Juliana.
All right, we'll go ahead and send your witness the link now.
Yes.
And then whenever you're ready for him, if you could give us a
Oh.
little heads up beforehand so we can get everything set up in the courtroom. We might take a break right before that. Also, Shannon's going to ask IT to be in the courtroom at that time with the help with the remote witness. I know you have been professed as a technology guy, at least self-professed as a technology guy, but I would feel more comfortable if IT was in the courtroom to assist you with any
Yes.
matters with the remote witness.
I 100% agree, Judge.
Okay, good. All right. Are we ready for the jury?
Yes.
Okay, Detective Miller, if you want to come back to the stand.
And the direct examination continues of Detective Miller. Shame. The former digital forensics expert on the case, who was transferred, a lateral transfer, as they said, because he wrote Christine did this, Christine did that, versus Christine's device did this, and Christine's device did that. And that cost him a lot, shame. So it's a lot, eh? He got transferred out and all this.
Good morning, ladies and gentlemen. All right. Your next question for Detective Miller, Mr. Carroll? Yes, sir.
Corluga says, weren't there two? Yeah, there were two. There were two Brendan Millers as well. It was like, wow.
Good morning, Detective Miller.
Morning, sir.
We finished off yesterday, and we had talked about a couple of issues, and I wanted to raise those again with you. Now, when you testified yesterday, do you remember the screenshots that were shown to you?
I remember seeing screenshots, yes.
Okay. And the screenshots were relating, I think you'd called them images, correct? I'm talking specifically about the portable case information.
A portable case is not an image.
But you had referred to it as an image, because we sent you pictures.
I don't believe I referred to it as an image.
Aaron, may we approach the bench for a second?
Playing this at 1.1 speed. We are only 15 minutes behind the live court feed, which is perfect. That was my plan. My plan was to be behind a little bit so we could just speed it up just a little bit. Otherwise, we might all be hypnotized back into a coma where we will need a defibrillator and a couple of Red Bulls, a case of Red Bulls to wake us up. Oh, my word. Is this one that reads notes.
So did you image or acquire all of the devices in this investigation?
Data was acquired from all the devices in this, yes, by
And
me.
did you acquire that data?
Yes, I did the acquisitions for these devices.
And did you acquire the images and all the data that came from these devices in a forensically sound manner consistent with your training and best practices?
Yes,
Did you process the extracted data using forensically approved and verified tools?
yes,
This is the same data you produced to detectives and supervisors during this investigation, correct?
The data provided for discovery would have been the same that I provided to the detectives, yes.
Okay. So, and these were produced from the devices you acquired and they were turned over in discovery as required, correct?
Yes.
There are four open, I'm going to show you four open magnet portable case files with the court's permission on a laptop for you to be able to review. Can you please confirm that these productions are you made for the respective devices, Christine Banfield's laptop, Christine Banfield's cell phone, Juliana Perez Magalhães' cell phone, and Brendan Banfield's personal cell phone? And I'll show you this so you can make that determination. Aaron, may I?
This is fine.
Aaron, may I approach the witness?
Okay, could you show what you're going to show to Ms. N?
Southern Calibre says, way to start out with a question you've already asked him 1,892 times yesterday. I know, right? Stefan says, Gesundheit for the court sneezer. I almost thought that was Brendan Banfield standing up. It's the PI. Okay. Lori Lowe says, here is for coffee with extra espresso to get through the day. Thank you for being UG. You rock. Thank you so much. I will take that extra espresso. Thank you. I've already had 2 coffee balls. Yes, little capsule-free, little Swiss coffee balls. 2, a black tea, and a Red Bull. Need to be awake today. I've got a Coke Zero here too. We're going to do this. Mystery Willow says, it really gives me the icky chills when baby boy stares into the camera for too long. I know, right? Happy Grizzly anniversary. Larissa Harris said, this witness can respond with facial expressions. He appears constantly confused. I think he's just taken aback by the questions that are being asked over and over and over again. Oh my word. Okay, thank goodness we started late, hey?
Look and confirm for yourself. Take your time. There are 4 separate files down here. So if you'd like, you can make sure that you're certain as to what it is you're looking at. I'll step back.
Thank you.
I recognize them.
Okay. And starting with the first one, you tell me what you're on, and we'll go either left or right, depending on it.
I'm on the furthest one on the left, which is titled Christine Lenovo Reparse.
Okay. And what device would that be for the ladies and gentlemen of the jury?
That was the Lenovo laptop.
Okay, and that was Christine's known laptop?
That was the device identified that she used, yes.
Okay. Did you have an opportunity to look at this is a portable case, correct?
Yes,
Okay, and this is the portable case that you provided in discovery to the defense or to the Commonwealth, and then they provided it to us?
yes.
Okay.
Oh boy, I was stuck in yesterday's time zone again. Jonas, thank you so much for the snarky coffee. Nomfik, thanks for being a member for 26 months. Tara Bates, thanks for the sticker. And all of you, thanks for being here. Please like and share so others know we are live right now and they can join us, okay?
And this is what you provided to anyone else who wanted access to it, such as Detective Bryant and Lieutenant Giacchio.
Yes, this was provided for everybody for review.
Was the data that was provided in with regard to the laptop, was that the data that Lieutenant Giacchio was reviewing?
I would imagine, but I can't speak to what he was reviewing at any given moment if I'm not there.
And so when you were talking with him, was it ever discussed as to what it is that he reviewed?
There were many conversations. As far as any particular item out of any one of those conversations, it's hard to pick out, but this would have been one of the things worked off of to discuss the items.
Okay. Let's move on to the next one.
Yes, sir.
I believe in order it would be Christine Banfield's phone. Is that correct?
Yes,
Okay. And same questions. This is a portable case based upon your work extracting from Christine Banfield's phone.
yes.
And did you have enough time to look through that and make sure that that's accurate as to what your work product was?
As best I can in a short period of time. I
Okay.
can't go through every item.
Actually, to tell you the truth, if you need to go through every item in order to be able to say that's what you were working on, we'll have you do that.
This appears to be the portable case generated by me, which would have been provided.
Okay. And that's the item that, or the data that comes from that, or what you provided to the Commonwealth to provide to discovery in our, for the defendants.
Yes,
Okay. And was that, if you know, was that discovery provided to Juliana Perez Magalhaes' lawyer?
I don't know personally what was provided in discovery to her attorney.
Is it fair to, well, when did you provide that to the Commonwealth?
I provided everything to the detectives, and then that was subsequently provided to the Commonwealth.
And when was the time frame for that?
For speculation?
Overruled if you can answer.
I would imagine it would be prior to a discovery order.
Okay, I'm just trying to get a timeline. How long did it take for you, if you can tell from your work product, to arrive at that data compilation?
I mean, I can tell that it was scanned in on February 3rd,
February 3rd of what day?
2023.
2023. Are you certain of that?
So when I'm looking at the case processing details on this page, I can see that that phone was scanned in by me into Magnet on 3/3/2023.
Oh, 3/3, okay, sorry, March.
I'm
3rd.
sorry.
Okay, that makes sense.
If I misspoke.
Let's go on to, and I'm sorry, let me just finish up those questions on Christine Banfield's phone. Was the data that was recovered from your extraction, was that the data that was also provided to the lead homicide detective at the time, Kyle Bryant?
Yes, everything I had was provided.
Okay. And was that also provided to whoever else was interested in digital forensics, like Lieutenant Giacchio?
I would imagine anybody who needed to review it, it would be accessible.
Okay. And did you know that, or was there any sort of protection as to that data in terms of the investigation?
As in, was the portable case password protected? Is that what you're asking?
I'm asking, was the portable case open to every police officer in the police department, or was it open to people specifically with regard to this case, or is it even smaller people that were involved in the case, and only needed to see it. Do you know how it was restricted?
I would imagine whoever needed to look at it would be able to, based on what was provided to detectives.
Okay.
Judge, I am going to object to the speculation if he's imagining he doesn't
All right,
know.
sustain as to speculation.
Now, sir, let's move on to the third portable case that you created. Do you identify that?
It is titled Nanny Phone.
Okay. Would that be a title that you gave to that document in that portable case?
Yes,
Okay, so you remember doing that?
yes.
Okay. And same questions. The data that was extracted from that, was that what you provided to Detective Bryant as part of this homicide case?
Yes.
And was that what you provided to or gave access to? And I'm not going to try to pin you down on who or what, but it sounds like it was available to anybody who wanted to look at it.
Yeah, that would be, once I pass it on, I can't speak to who else would have looked at it and when.
Okay, that's fine. And that was also, I think I may have said this, that was included in discovery or to Detective Bryant, who would have given it to the Commonwealth for discovery, correct?
I would imagine so, yes.
Okay. Now, and just to be consistent, this would be what Detective Bryant could have looked at and Lieutenant Giacchio could have looked at.
Judge, objection asked and answered. He indicated he gave it to Kyle Bryant. From that point forward, it's accessible. He doesn't know who else saw
Asked and
it.
answered is all I need. Thank you. I'll sustain the objection.
Fine. If it's asked and answered, that's fine, Judge. Can we move on to the fourth item that you're looking at there?
Yes.
And what is that?
It's a Samsung Galaxy S23 Ultra.
And who is the owner of that?
Let me look real quick. I believe this is Brendan Banfield's phone.
Okay. And same questions. You extracted data, and this is the source of that data, correct?
This was what was provided to the detectives, yes.
Okay. And describe what a portable case is for the ladies and gentlemen of the jury.
A portable case is a report that is generated through a forensic tool called Magnet Axiom. It is a way for the information that is in Axiom to be put into a readable format, similar to Axiom, but not quite as robust. But it's in a format that someone would be able to navigate in a more user-friendly method.
And once you do your extractions, is this the format that you would rely upon in answering questions that may come up, things like that?
I think that would depend. If there are certain things that are better able to be seen in Axiom itself versus in a portable case, but again, the data is in here.
Okay. Would you utilize that as a resource if you needed to know something about the data that was in there?
Yes, I would use this to search for information.
Okay. Your Honor, I'd move the first file, which would be named 120, Defense Exhibit 120, which would be the portable case for Christine Banfield's Lenovo laptop.
All right, any objection?
Judge, is counsel going to be able to share that with the jury?
You're not publishing it this time, just into evidence, is that correct?
Yes.
Any objection?
Can we approach?
Shame, Detective Miller, shame.
Sir, moving on to Christine Banfield's phone, which would be the second file that we reviewed. Your Honor, we'd move into evidence as exhibit number 121.
All right, any objection?
No, ma'am.
Joanna, thanks for the coffee. You said this is for Grizzly Cat. Please remember, Grizzly Cat has her own coffee link, so that one won't go to Grizzly Cat. I have a coffee link. The mods have a coffee link. Grizzly Cat has her own coffee link, which is in the description box. Okay. Thank you so much. I'll make sure to send her a coffee. But just for future watchers. Just know there's 3 different ones, and it has to be allocated in the right place for you to send it to the right person, right? T. Frey, welcome, and Lisa Longhorn, thanks for being a member for 12 months. Happy Grizzlyversary. You said, hey, Grizzlies, we're off to Tunisia again. Okay, to see Grizzly Ashley. Okay, cool, enjoy that. I thought you were going to say we are off to, I don't know where, on this day again, this court day. It feels like we've teleported back to yesterday? Are we there yesterday? Yesterday it felt like we were literally never going to get out of it. Never, ever. That day was never going to end. It was like Groundhog Day the entire day. Anyway, here we are. There's only a few minutes left as far as I can just quickly look ahead and see that Detective Miller will be on the stand.
Sir, the third portable case that we've just discussed is named Nanny Phone, correct?
Yes.
Your Honor, we would move that into evidence
Any objection?
pursuant to,
No objection.
as Defense Exhibit 122.
122 in evidence.
And sir, the last file, which you've identified as Brendan Banfield's phone, Your Honor, we move that in as Defense Exhibit 123.
Any
No objection.
123 in evidence.
Court's indulgence.
Yes, sir.
Your Honor, I don't have any further questions for
All right.
Detective Miller.
Cross-examination?
No, ma'am. Thank
All
you.
right. I hesitate to ask if he's subject to recall.
Potentially subject to recall,
Okay.
Judge.
All right, sir, since you are subject to recall, just do not discuss your testimony with me at this time, okay?
Yes,
All right,
Your
thank you, sir. All right, your next witness.
Your Honor, I'd recall Harry Lidsky.
Okay, can you retrieve his laptop too?
Why?
Can we
Okay,
leave
sorry.
that there, Judge?
Oh, you need that? Oh, never
Yeah.
mind.
Sorry, did I say that out loud? But why? Thank you, Indy, for the 3 snarky coffees. Not that Mickey. Thank you for your sticker. You said, in my opinion, they're delaying so they can use the time to prep him for the stand during the long break. I mean, shame. Will he ever be prepped enough? Is he gonna? Do you think he's gonna take the stand? He is gonna take the stand, according to his defense attorney. And you can read the pinned comment to check that out if you're watching live with me, right? Number 1. So, do you think it'll be today? Do you think they'll stall, and then it'll be next week after the snowstorm, which will be like 5 days off perhaps for the jury? Do you think he'll testify next week? Or do you think that he'll chicken out last minute whenever it will be? If they can't get their expert to testify remotely today, then the defense's case is going to spill over to next week. And then I think there's a chance they could delay, stall for him to testify next week, right? Or is he going to do it today? Or is he going to chicken out? Right? Oh, sorry, this page here.
Sorry. All right, he's already been sworn. All right. Sir, just a reminder that you're still under oath, okay? Of
course.
All right, thank you.
Sir, calling your attention to what has been moved into evidence as Defense Exhibit 120, 121, 122, and 123. Are you familiar with those exhibits?
I am.
And have you had an opportunity to review those exhibits?
I have.
And state to the ladies and gentlemen of the jury, what did you do in your review as a digital forensic examiner?
Well, as Detective Miller indicated, these portable cases facilitate everybody to visualize the data from the respective devices, ourselves included. We use these, and we're able to look at both user accessible files, like what you would see on your phone. We're also able to see the data behind the data frequently, which can be informative depending on the nature of the investigation.
And do you understand these items to be verified data extractions performed by Detective Miller using appropriate tools and best practices?
I do. I've reviewed his reports and came to the conclusion that he did everything exactly the way he should have and the way he was trained to do it using the tools that are approved by the industry and accepted by the courts.
And do these items, specifically the exhibits, provide us an opportunity to review the raw data extracted from their respective devices in a forensically sound manner?
They do. So the nature of the case, in addition to giving us visibility, bless you, into all of the data on the device, we can't alter anything, and that's what makes it forensically sound. That's what the term, how the term is defined. So anyone using this can't add anything. We can't delete anything. We can't change anything. If there was a virus on the device, it stays sandboxed within the case. It does not spread to our computers. So it's helpful in a lot of ways.
And so is this considered a safe environment in the world of digital forensics?
It is, and that's the nature, the forensic and forensically sound. It prevents, it's not like blood evidence, but it prevents cross-contamination so that what's on here is on here exactly the way it was when the device was either imaged or acquired when Detective Miller did it back contemporaneous to the event back in 2023.
Based upon your review of this data, were you able to draw any opinions related to this case?
I was.
And what were those opinions?
That catfishing did not occur.
And did you produce any demonstratives that you can display to help walk us through your findings?
I have.
Interesting. Okay, let's hear it. Let's hear it. Shame. His answers are a lot shorter today. Thank goodness. So I feel like he reviewed the internet chats where everybody's like, oh my word. The whole chat was like, this guy loves to hear himself talk. It's too long-winded. It's too much. And I was like, you can see he's trying to stick to them bullet points. Tell us, explain yourself.
You display to Karen, can you display to counsel and the witness?
There's nothing on the screen at the moment.
I'm connecting. Sorry.
There you go. Well, I have your screensaver. Okay.
Thank you, Your Honor. Sir, the items that we're about to show relating to your findings, the digital forensics have been identified in the stipulation documents, correct?
They have.
And did that include Brendan Banfield's phone
Yes, it did.
and Christine Banfield's phone
Yes.
and the laptop?
Christine's laptop, yes.
Juliana Perez Magalhães' phone?
Yes, among other devices, but these are the four central ones I reviewed,
Social media records from Google, FetLife, Facebook, among others?
among others, yes.
Video from surveillance?
Yes.
Judge, objection leading.
All right, so take us to leading.
What, if any, items were related to surveillance?
There was some video surveillance. There was electronic and physical surveillance involved in this investigation. That's all that comes to mind with regard to surveillance.
Did you rely on any interviews?
I was made available to the entire investigation. That included videotaped interviews of the co-defendant, Ms. Magalhães, both transcripts of interviews that she conducted with the police, with the Fairfax County Police, interviews of witnesses, as I think Detective Smith testified to yesterday, like neighborhood canvases, notes, things like that. I've reviewed everything in this case.
Okay.
So have I, and I can also interpret it my way and have an opinion. Okay, but that doesn't matter because the data doesn't lie. And if they can't prove who exactly was behind that computer, then neither can you, sir. Neither can you, sir. Okay, sorry. Right? Damn, how much is he getting paid?
I'm going to show you a slide. And Your Honor, we're just trying to determine what our previous number was for it.
What, if you show it to me first, then I
Yes.
can let you know. Let me see.
But he knows things and he's reviewed things, okay? Yeah,
All right,
he's
I
seen
have it as
PDFs.
86.
86. And I believe 86 was.
It's not in evidence.
Not in evidence. Sir, can you identify,
Is it a different number? I'm
this-
sorry, just hold on.
Judge, sorry, I'm scrolling back to 86. I was under the impression this was likely
Okay.
110.
This is your first slide after the
after
the
the
titles page?
title page?
This is the first one
Okay.
you have.
First one,
And that's the first one you started with him when he was originally on the stand?
yes.
Yeah.
Your Honor, if I may?
Yes, sir. Is it-
It's changed a little. This is
Okay.
technically new.
So it is different,
It is
okay.
different, yes.
All right.
Well, then,
Okay,
Will-
so.
apologies.
Okay, so this was not the first one that you had seen?
It's
The second or third?
it's a change of the first. It eliminates the
So this is not
party
85
number.
at all, so if you want to give us a new
I think
number,
it's new.
124, Judge?
let's get us a new number then.
So this, Your Honor, we identify this as Defense Exhibit 124.
Okay, thank you.
Sir, do you see the slide here?
I do.
And what does it reflect?
This is a Facebook message sent by Christine Banfield.
And what, if anything, did you look at to determine this slide?
Even though it's a Facebook message, this was recovered from her mobile phone. So a lot of the data on our phones can occur in multiple places, right? So our email is on our phone, but it's also on the server of our respective email provider. This is a Facebook message. It likely is or was on the Facebook server, but this particular message came from her phone.
And was the phone one of the things that, the portable case that was moved into evidence through Detective Miller?
It was. I believe this was 122.
Okay. Your Honor, I move Exhibit 124 into evidence.
Interjection?
Objection, hearsay.
All right, hearsay?
Sir, Your Honor, I believe this is an artifact of the portable case,
You've
which,
got past the foundation, I agree with you, but now that we're past that hurdle, the next hurdle is hearsay.
and Your Honor, I think this is an artifact, and it's for whatever it is part of the portable
I'll
case.
sustain the objection to hearsay.
Sir, can you look at what would be marked as Exhibit 125?
That's in evidence.
Yes.
Hold on a second, that's already in evidence. Okay, so
This particular,
I think that is in evidence as 110.
No, I have it as 109, and then yesterday he clarified for the record, these as 109.
I'm sorry, I can't,
She said
okay,
this was clarified as 110.
110, that's what I have it as well, 110. 110 in evidence, yes, so it's already in evidence as 110.
sir, what is this artifact, or can you explain what this is?
This is a calendar entry, a saved calendar event from Christine Banfield's mobile device or phone.
Okay, and is there anything notable in that artifact?
The date,
Okay, and any other aspects of the calendar entry?
it's what you'd expect, I think, from a calendar entry. It's a date and time. It was on Mrs. Banfield's phone, and the Gmail account associated with it was the one that I believe was hers, attributable to her.
Your Honor, I believe that was admitted as
It
Exhibit
is, it's already
110.
being displayed to the jury.
Okay, thank you. Is there anything else about that particular artifact, Mr. Lidsky?
Was an estimate for 10 a.m. for Windows. I could talk about why I think that might be informative.
Why would that be informative?
Objection, Judge. Calls for facts not in evidence.
Overruled, I'll allow it.
Well, from the information I reviewed in the case and the testimony this week and last, the window replacement was a topic at, the window replacement at the Banfield house was a topic discussed. I think this reveals that the window replacement project was, number one, dates back to 2021, far earlier than.
Objection calls for speculation. This particular document just says estimate 10 a.m. windows. We don't know if they had other window replacement projects.
I'll sustain the objection.
So in 2021, Christine Banfield was scheduling a window estimate at 10 a.m.
Okay. Sir, I think this might be 111, Judge?
I don't think this,
112.
Thank you, Sylvia. He owes you something at the end of this. All right, 112. And it's not in evidence?
Sir, do you identify this
No.
slide?
No, Judge, this was previously offered and denied.
It's not in evidence.
Correct.
Right.
So
It was previously offered. See what happens. Okay. Go ahead, sir.
Sir, can you identify this?
Yes, these are messages sent by Christine Banfield from her device, excluding any other party.
And what is notable within these messages?
There are discussions about having the windows
Judge,
replaced.
objection. He's testifying to the subject matter.
All right,
It's hearsay. It's
Sustain the
denied.
objection.
What about the date and time?
These are from June 28th, 2022.
Sorry.
You just changed
I know,
things.
sorry. My big fingers.
There you go.
Sorry, did you see that before my fingers caused it to go?
Yes, these are from mid-2022, late June.
And sir, do you see the item on the screen?
I do.
Okay, and what is this?
More messages from Christine Banfield.
Objection as to the hearsay. He cannot testify to what's in the document.
What's notable about the date?
Oh my word. Christine Banfield, she wanted the new windows in 2021. We already know this. But then Brendan Banfield came up with, according to what we've heard and seen, he wanted to make them soundproof. The order was already in motion and the window guy testified. Brendan was like, let's get them all soundproofed. And then Juliana testified that Brendan was in the bedroom practicing what it would sound like if he screamed at the top of his lungs and Juliana was outside and could she hear him. So like, do they think the jury is going to forget that? I don't forget that. Do you forget it? Anyway, let's carry on.
And the time on this particular message?
Was this 114?
It should be, Judge.
I just want to make sure, for the record, it's okay, this is 114.
114.
These are from December 3rd, 2022.
Your Honor, may we just approach for a moment?
A bit of sidebar. Skip right over there. Okay. I like watching the judge's face.
Objection, hearsay.
All right, I'll sustain.
Hearsay.
All right, I'll sustain.
Wait. We want to hear the last sentence here. Wait. Okay, somewhere around here. Happy Friday, everyone. Thanks all for being here. Lisa J, welcome to membership.
Your Honor, I'd move to enter defense exhibit number 114.
Objection, hearsay.
All right, I'll sustain the objection.
And sir, as to the windows, did the information that you received as an expert in forensics, digital forensics, did that inform your opinion?
It did.
Okay, and what is your opinion about the window replacement without getting into the hearsay statements?
That the project originated.
Objection, Judge, calls for speculation. to refer to it as the project assumes that he is correlating this information with what occurred that's been admitted into
You
evidence.
want to rephrase?
I'll rephrase.
Yeah.
With regard to the subject of windows, without specifically talking about a project, what does this indicate to you and what conclusions can you reach?
That Christine Banfield contemplated or explored window replacement in 2021 related to issues of age and condition of her existing windows.
Judge, objection, he's testifying to the content.
All right. He gave his opinion. All right.
Yes, yes.
Next question.
I think you.
Okay. Do I just say it again? Even if Christine wanted new windows, which they're saying she did, her and her husband had discussed new windows. Okay, even before Juliana arrived. Because that plan was already in motion to redo the entire house's windows because it was more energy efficient, as the window guy said, at some point, Brendan Banfield said, to the window guy, I want to add another like $10,000 onto that and make it soundproof. And the window guy said it's not that common to do that. So, and then I think Juliana's testimony also adds weight to that.
Just have, what's essentially, you can't go with the writing that's on there. Thank you. Now, sir, I'm going to show you what will be marked
125.
Your Honor, I believe defendant's 125.
Okay.
You know what's sickening as well is how Brendan would have convinced his wife why they should invest in soundproof windows. Because she was a pediatric nurse, and he would have said, like he would have likely, I would assume he would have said, come on, it'll be so nice. You know, you could get such good rest with these soundproof windows. And you need your rest because you work so hard. Oh my word.
Sir, do you see the picture on the screen there?
There's no picture.
It's text. But yes,
You see that?
I do.
Okay. Does Your Honor see it?
No, you have to go to the next slide, I think, is what you're trying to get to. I mean, all we have is writing. Is that what you're talking about? Or
Yes,
You want a
yes.
picture?
It's a picture of writing.
Okay, it's writing. Okay, that's what I said. Okay, 125, okay. Yes, we can see that.
Okay. And you just see that, correct?
Correct.
And was this something that you reviewed in discovery to inform your opinions relating to the date that it shows on there?
This is something I reviewed from discovery. I read it after my opinions were formed.
Okay, so let's just make that clear. And I think you had testified before. In what order did you review the items in evidence versus Detective Miller's findings?
I performed all of my work first before looking at Detective Miller's findings.
And so is this something that you looked at after you had arrived at your conclusions?
Yes.
Okay. And is this something that you relied upon in arriving at your conclusion today?
I didn't rely upon it. I have it here because Detective Miller said it in a way that it was both accurate and succinct. I couldn't do much better, so I copied his work.
Okay. And in terms of how would you characterize, so what is this part of, this particular statement that's before you?
Objection, if he's going to testify to anything that's contained in the document, regardless of whether or not he copied it, it's hearsay.
All right, I'll sustain the objection.
What document is this part of, a part of that you're looking at?
This is from Detective Miller's executive summary.
Okay, and did you hear any evidence in the court relating to Detective Miller's executive summary?
I did.
Okay, and who were the witnesses who were speaking of that?
Detective Miller.
Objection, calling for hearsay. The jury had the opportunity to hear the
All
testimony.
right, I'll sustain the objection.
Do you recall who, well, okay. Is it fair to say this was mentioned in court?
Yes.
Okay. And sorry.
126?
Sorry, Judge, I just,
Oh,
a little premature, I was
All right.
getting it ready. So to avoid hearsay, because this is a written document, can you tell the ladies and gentlemen of the jury how how this affected your conclusions as a result of your examinations?
This didn't affect my conclusions other than to corroborate them after I was done, seeing that our findings were aligned.
Okay, and do you agree with what you see on the screen here that's hearsay that the jury can't see?
I do.
Sir, do you see the next slide on the screen?
I do.
And if you can describe what you see there on the screen.
Judge, I'd object to any description of the content, hearsay.
There are pictures there, Judge.
So if you could just maybe limit it to the pictures.
Okay, let's start with the pictures. Do you
Okay.
recognize those pictures?
I do.
And are those pictures that you were able to identify independently within the data that was provided in discovery for the defense?
Yes, I was.
Okay, and if we can look at the first picture, do you have any idea based on digital forensics where that picture was taken, or actually not where that picture was taken, where that picture came from?
The picture on the left.
Yes.
The picture on the left came from Christine Banfield's phone.
And the picture on the right?
Also.
Okay, and what processes did you utilize in order to reach those conclusions?
Well, as I was reviewing the data from Ms. Banfield's phone, I found them. They were familiar to me because I had seen them from other sources, such as search warrant returns from FetLife. I'd also seen one of them in Facebook returns that a return is data provided by a service provider in response to a warrant. So I'd seen them both from multiple sources.
And the one on the left that you've identified, is there any way to know the timing of that based upon your analysis?
I believe it was January 17th, around 8 p.m.
And January 17th is significant in this case.
Objection,
what?
counsel's testifying.
Sorry. What's the significance of January 17th in terms of the issues in this case?
Yeah, and the photo, I believe, was actually closer to 7:30 or 7:20. January 17th was the day that the FetLife account, which is obviously important in this investigation, was created. That is the user profile. Somebody set up an account on FetLife, and one of these pictures came into play.
So let's take this opportunity to talk about the accounts that were set up that were alleged to have been run by Juliana Perez Magalhaes in her recant. What were the accounts that we're talking about?
So there's 3 accounts. There was the Gmail account, there was the FetLife account, and then the third would be the Telegram account.
And can you explain to the ladies and gentlemen of the jury, what's the significance of those 3 accounts and how are they linked?
So each account is linked to at least one other account, and that's significant for me as a digital forensic examiner, because it's sort of a one or done. And the way the accounts were set up, so the Gmail account was set up first. The Gmail account was used to set up the FetLife account. So you couldn't set up the FetLife account unless you knew about and had access to the Gmail account. To have access to the Gmail account, you'd have to know it existed, A, and then you'd have to have the password to log into it. So the Gmail account sets up the FetLife account. The FetLife account was used to move conversations over to Telegram. So all three accounts are linked, and anybody that had knowledge of any one of the accounts owns all three of the accounts. You couldn't use one without the other. You couldn't jump into a Telegram conversation without knowing first how it began from FetLife, and you couldn't get into FetLife without.
Judge, I'm going to object to the speculation, wouldn't be able to, there's no foundation for that.
All right, I'll sustain as to that, just that part.
Okay.
I just want to turn the boost off to see if you can hear well enough, because my goodness, it's just, he's eating the mic and it's just too loud, okay?
In terms of the objection relating to foundation, what did you
How's
rely
that?
upon in order to inform those opinions that you're telling the ladies and gentlemen of the jury?
The content of the data within the accounts and my knowledge of how accounts work in the FetLife responsive documents from the Fairfax County Police Department search warrant. It says right in there that the user email associated with this is the Gmail account. So the user connected the accounts. The Telegram connectivity is based on the content from the FetLife messages. Please contact me. Do you have Telegram? Please contact me there.
And that's fine. But do you have proof who created the Gmail account? Do you have proof who created the FetLife account? Telegram account? No. Neither do the digital forensic experts, because they don't have surveillance footage of someone doing it. What they do have is Juliana's testimony that then explained, gave more context, more information to that. And she had a lot of knowledge on the account, what was said in the account, who they targeted, why, who they contacted, all that, right? But I understand the defense as to they got to do their bit, but damn, like this is going to go very far down the victim blaming path. This is going to say Christine did it. And what we had heard before the trial, what we'd read from all the documents and preliminary hearings and articles and things, is that within hours of Brendan Banfield receiving a picture of his wife in a swimsuit, it was posted to this FetLife account. So let's see if they bring that up. If they then say that, look, there's a picture she took, and she put it on there, oh my word, shame. Still many holes in this case then for the defense, you know what I mean?
Sir, I'm going to have you look at the next slide. Is this the foundational artifact that supports your testimony to the ladies and gentlemen of the jury?
So this is a picture that Ms. Banfield took of herself on the evening of January 17th.
Oh, okay.
Your Honor, I'm sorry.
Spoke too soon?
Is that 115?
This would be 127.
Oh, no.
127.
What are you going to
Your
do
Honor,
with
move
this
that in
now?
as, Defense Exhibit 127.
Any objection to 127?
No, ma'am.
Okay, 127 in evidence, you can publish to the jury.
And so if you can just explain to the ladies and gentlemen of the jury what the artifact, what's the significance of that artifact and what you took from it to arrive at your conclusions.
So it's a picture, obviously, of Ms. Banfield. I'd characterize it as a selfie in the mirror. The file name and date, or the file name, that's what I'd call a typical Samsung or Android file naming convention. So in line with what I'd expect to see for a picture taken by a Samsung mobile device. At the very bottom of the screen, you can see that it is a Samsung phone model SMG991U. The dates and times, the date and time here that's relevant is January 17th, 2023 at 7:20 and 45 seconds p.m. If you look at the file name 4 lines above, that is the typical Android Android file naming convention, and that's comprised of the date. So we see 2023-0117 underscore, and then 1920, which is 720 in 24-hour time.
Now, the
Scroll down to the file data, exactly.
software and the make and the model, is that
File name. Okay.
significant?
Created. All right.
Does that corroborate anything that you've identified?
Yes, the make and the model is corroborative. This phone was in fact a Samsung SMG 991.
Oh my word. I feel so sorry for Christine, the victim. What the hell are you people doing? Oh, so if this says file name, file extension, okay, 17th of Jan 2023. That's the same day the FetLife account was created. So what was reported before the trial started seems to pan out. That within hours of Christine, how it was reported in the media was within hours of Christine sending her husband a picture of her in a swimsuit, the FetLife account was created. I mean, it could be. It says local time 7:20 p.m. That could also be them using her phone, because they used her phone to create the FetLife account, then used her laptop. We heard that along the way in this trial, right? So if at that moment she was showering, sleeping, upstairs, whatever, and her husband grabbed her phone and they made the account, I don't know, it's possible. Oh my. But it's also like, yeah, someone said Sunny Ways, that's a gym locker room bathroom, looks like to me. Right? And I mean, we also heard that she was taking some like weight loss medication. She was on a health journey. So it might be like progress photos. I don't know. I'm just feeling even more betrayal, I would say, from Juliana and the defendant. Because imagine if it is progress photos. Imagine taking your wife's progress photos and then being like, I'm going to use this. This is the best I could do right now. I'm going to upload this to a FetLife account, which she had no idea about, according to the state, right? Oh my goodness.
Which informs me that this picture was actually taken in what we call native to the device. So it's a photo both contained on the device, but taken by that device rather than one you'd get in a text message or email as attachment.
Your Honor, I don't believe I previously identified it, but I would put it in as Defense Exhibit 127.
This one, it's already been, and it's been published for the last.
Okay, I'm sorry. I just want to make sure I'm covering my bases.
Okay.
Sir, I'm going to have you look at this item. Do you see that on the screen?
I do.
And are those digital artifacts that you relied on in arriving at this?
You could call them.
Describe what you have, what you see in that slide.
So this is part of the responsive documents received in this case from Facebook. And so the information, it is digital, it is artifacts, but it's not recovered from a device so much as from provided by Facebook from their servers.
Okay. And did you create this slide?
I did, yes.
Okay. And what's the significance of the notations on the left side? Actually, Your Honor, I would move to enter into evidence. I think Defense Exhibit 127?
128.
128.
128. Any objection to 128?
No, ma'am.
All right, 128 in evidence published, please.
Sir, can you explain to the ladies and gentlemen of the jury what those markings are, both on the left side of the picture and below the picture?
Yeah, so as I said, this is information that was provided by Facebook. This is where Christine shared this photo with Brendan. Just starting at the top left
There it
and
is.
working.
There it is. This is where Christine shared the photo with Brendan. Oh, the defendant. Okay, the guy who created the FetLife account. Let's get back to that, shall we? Listen, State, can you just get up in your cross-examination of this guy and say, so, but it is possible. So you're saying it's possible that Christine created the Gmail account, the FetLife account, and Telegram. Correct? Correct, yes, correct. Okay, but it's equally possible that her husband used her phone to create the Gmail account and the FetLife account and the Telegram account. Correct? Oh yeah, that's possible. Correct, exactly. How is this helping the defense as well? She sent the picture to the defendant. There you go. Now put that all together with everything else we've heard. Okay. He should be ashamed of himself.
Down and to the right, the author, Christine Banfield, so it was sent by her from her account. It was sent on the service providers, in this case, almost universally, provide us with documents in UTC, Coordinated Universal Time, versus Greenwich Mean Time. So it needs to be adjusted. So this...
Yeah. Body. New bathing suit. That's what she titled it. It says Christine Banfield, Facebook, sent it to... Well, wait, it says sent it to Brandon, but new bathing suit. She sent it to her husband. What the hell? This is some BS.
In February, or January, I'm sorry, we need to subtract 5 hours, so that's why it's appearing as January 18th instead of January 17th. But January 18th at midnight and 20 seconds, midnight and 20 minutes is actually January 17th at 7 p.m. and 20 minutes here on the East Coast. So she sent it, and the body of the message she sent was new bathing suit included, and the artifact below that is just the attachment, which is this photo, and the name that the associated data that Facebook includes with that.
So let's just have a little discussion about UTC time. You called it Greenwich Mean Time, correct?
Abduction, mischaracterization, he said that it is universal, and it is a 5-hour difference. I believe it's been asked and answered.
I think he can explain it, but yeah, go ahead.
Okay. I'm sorry, was that a stipulation that it's a 5-hour difference?
Yeah, absolutely.
Okay. And so we don't need to explain too much now. Why are some items in UTC time versus present time?
My experience and what I believe to be the reason is, and this is universal with service providers, from my experience, Google, Facebook, phone companies as well, they just provide everything in UTC time. So they provide it in one time zone and you have to do the work. Otherwise, they'd have to send records to Fairfax in East Coast time. They'd send them Chicago in Central time, LA, and they're providing records to law enforcement and legal counsel all over the world. So they just send it as UTC. That's, I think, why UTC exists, sort of to give us all something we can all start with and work with personally from there.
Thank you, sir. Can you look at this next slide?
Yes.
Is that something that informed your opinion that you've been telling the ladies and gentlemen of the jury?
Yes, this is a digital artifact from a laptop.
Okay. And is that the laptop, Christine's laptop, that was introduced into evidence through the portable case with Detective Miller?
It is.
Okay. And can you explain, Your Honor, I've moved that in as Commonwealth's Exhibit 129.
Any objection?
No objection.
129.
Sir, can you explain to the ladies and gentlemen of the jury what that is and how that's significant?
Sure. This is a Windows event artifact. It contains the security identifier. So for Windows computers, every user is assigned a security identifier number, and that's the long number we see on the second line down, ending in 1001 on this case. So that just informs us of which user profile was active at the time that the activity took place. So a computer, if you have a shared computer in your household with 4 people, each one will have their own unique security identifier, and that's what you get when you log into your profile, and that's why your things will come up, your information, your email accounts, versus somebody else who might be using a shared computer. It could also be in play with, for work computers that are shared as well.
Oops, sorry.
The time and date are just that. And these have been, this is in East Coast time because of where the computer is located. And down to the bottom, the third line up, just tells us what this event represented, and this is just simply a log on to this device by that particular user with a security identifier of 1001.
Sir, I'm going to have you take a look at this slide. Is this a slide that you created for this presentation?
This is a screenshot of an artifact from the same computer.
And what's the significance? Well, Your Honor, I move this in as Commonwealth's Exhibit number 130.
Any objection?
No objection.
130?
Sir, if you could, go through this. What is the significance of this artifact in terms of a digital forensic analysis?
Similar to the last, this is just another standard Windows event that we often see when a computer is either powered on or logged onto. So the time of this, if you want to compare it to the slide before, is likely within milliseconds. A lot of things happen when we start our computers that go on in the background. The previous slide was the user logging into their account. This is just reflective of the computer probably almost immediately joining the Wi-Fi account for in this case, what I know to be the Banfield home.
Your Honor, with the court's permission, he's referenced the previous slide. I'm going to put it back to the previous slide.
129 is in evidence, so you can go back to 129.
So that's the previous slide. Can you just highlight what it is you were talking about in terms of the timing?
Yeah, so if we look at the created date time.
Judge, the Commonwealth will stipulate that they show the same time.
Okay, stipulation that it shows the same time. Thank you. Sir, is there anything additional that you need to testify to about that slide?
No.
Do you see a slide before you?
I do.
Okay. Your Honor, that would be identified as Defense Exhibit 131.
All right. I'm just making sure we didn't see it yesterday. I'm not sure we did. So we'll make it 131.
I don't think we did, Judge.
Okay, 131.
May have.
Sir, do you see that?
I do.
Okay. And if you could just describe, was this something that you utilized in your forensic analysis of this case?
Yeah, I think there are other images that are associated with this that will come up in progressive clicks, but this is using artifacts from the laptop that I examined, or the portable case that I was using to examine artifacts from within the laptop. This is a sort of sequencing of events in chronological order, and that's, I think as I described before, something we do looking backward in time and following events on a device might help inform who was using the computer, and certainly the time and date and what they might have been doing.
Your Honor, I move this
You
in
don't
as,
know that.
Defense
You can't
Exhibit
prove that.
131.
Any objection?
No, thank you.
131 in evidence.
If you could please publish that to the jury. Sir, can you just explain, they didn't have that on the screen when you were...
Sure. These are the artifacts that I've located on Ms. Banfield's laptop, and this just shows that shortly after the computer was logged on and joined the Wi-Fi, that she opened a browser and navigated to or viewed a Google website and.
He's like, okay, she opened the laptop and she navigated to it. Would you like to get transferred as well? You know what happened to the detective on the case who said she did this and she did that instead of the device, right? We know it's factually inaccurate to say he or she did this or that. You don't know that. The device did this and the device did that. Sir, we went over that the whole day yesterday. My goodness.
Her email
Judge,
inbox.
objection calls for speculation. He doesn't know who it was that looked at anything. He can tell us what the computer did.
All right, I'll sustain objection.
There we go. I spoke too
The-
soon
the person-
again. Well done, state. Well done, state. Man.
Whoever was using the computer opened a Google website and Google inbox related to Ms. Banfield.
And sir, what's the significance of the email, the Gmail account that's identified in the second line there versus other Gmail accounts?
So this one became known to me through my review of all of the evidence in the case as Ms. Banfield's sort of go-to email account. This is not the alleged suspect email account that we talked about as being formed on January 9th.
And what was the alleged suspect Gmail account that you referred to?
That was the one that was used to then set up the FetLife account in Telegram as the account. The alleged suspect Gmail account was the one that received communication from FetLife, both the FetLife service provider and from users wanting to message through that account.
Okay. Sir, I'm going to show you this next slide. Do you see that?
I do.
Your Honor, I'd move that in as Commonwealth's Defense Exhibit 132.
All right, any objection to 132?
No objection.
All right, and evidence can publish?
And so tell the ladies and gentlemen of the jury what this is.
So again, chronologically, this is, it looks like just under a minute later, whoever was using this computer was now able to see the draft email box within their Gmail account, Ms. Banfield's Gmail account, also the sent email box or account messages from Ms. Banfield's account.
Ooh, looking at her work account. She clicked a link and there was a draft email. He must be innocent. The hell is going on here?
And where are the sent emails that you're referencing?
It's the now fourth line down. You can see on the title of the slide, also on the left-hand side for the URL, that's just showing that the sent mail box or tab was open at this time.
Okay, and the draft mails are the one, well, you tell me. I'm not going to.
Yes, the draft is right above it. Usually parenthetically, when there's a number there, for us email users, that reflects the unread messages in the respective accounts.
Your Honor, did I move that into evidence?
That's in evidence.
Okay. Sir, do you see this new slide, which is incorporating the old slide?
Yes, I do.
Okay, and what's the significance of that? And then if you identify it, then I'm going to move it into evidence. So just identify that as a slide, and Your Honor, I'd identify it as Defense Exhibit 132.
133.
133.
Any objection to 133?
No, ma'am.
Okay.
Again, just chronologically, this is more activity shifting away from one service provider to another, from Gmail to Facebook in less than a minute.
And the timing is in the second column?
It is. So this would be January 17th at 10:01 and 10 seconds p.m.
Okay. Sir, I'm going to move on to the next slide. This will be identified as Defense Exhibit 134.
Any objection to 134?
Sorry, Judge Van, just have a second.
Genesee gal says, I confess, I'm not really listening, just waiting for the cross-exam. Well, I hope it'll be a good cross-exam, right? Hey, Brendan, in my opinion, you should be ashamed of yourself. Okay, moving on. Yeah, you get on the stand. Do it today, please.
Judge, I understand that the slides are just successive.
The only new thing is the artifact information.
Right, we're just adding one item at a time.
Is
Oh,
it-
okay,
No
sure,
objection?
no objection.
134.
Sir, as Ms. Sands said, this is a progression of items, and there's a new portion. Can you describe what that is?
Yes, so this is artifact information related to the login of now the alleged suspect Gmail account. So you can see down at the bottom in the highlighted section, this is CBRN 920 at Gmail. That's different from the email that we see at the top of the screen for C. Banfield. So this is significant because now, again, we're talking about a login to the account that's central to this investigation. So whoever was using the computer at this time, at 10:03 and 4 seconds, was clearly aware of the account and had the credentials because this is a successful login.
Is it just like Snarky Friday? Or are you guys also feeling like just rage building up, just like, what the hell? And can you imagine if that's the alleged suspect email? And if Brendan Banfield set it up, how very dare you make it CBRN? Like registered nurse, 920. How, so you're gonna mimic your wife's work email address. And you're gonna use her photo, which is probably a progress photo, or a photo for you, her husband, like, look, I got a new swimsuit. Innocent photo. You're going to use that photo in the worst way, allegedly, okay, based on okay, in my opinion. That is so disgusting. The betrayal in this case is like next level, right? Marincha Grief, thank you for the South African Rands, 14 ZAR. You said her name is Christine. Exactly. Thank you so much. MSC Riddle, thank you so much for the snarky coffee. That's appropriate right now. Oh my word, yeah, rage is building on on this day. I mean, I guess we would all feel a little cranky after yesterday already, right? Like, what are you doing, defense? Okay, also, let me quickly, while I'm talking, say this is public record. It's an exhibit or evidence shown at a public trial. So no one's being doxxed. It's not something that I'm choosing to share. It's what the defense attorney is sharing with the world. They're an exhibit, public record, at a public trial. Okay. Also, I agree with so many of you. The closed captions on the screen are like super distracting. I really don't like it. I was trying to make a solution because it was my error to not turn the CC on today. Again, sorry about that. I'm gonna blame it on trial bubblers. Okay, and so I'm gonna turn it off the screen. It will be available for the replay. And I'm so sorry if you are one of the people that needs CC. Hopefully you can hear nicely. The sound is good, right? Hopefully it's okay. And I'm so sorry if you do need it. It will be there for the replay. Thank you so much for understanding. Just stop it. How long is this still? Wait. Let's see.
Sir, do you see that slide?
Oh, my word.
The new slide?
I do.
Okay, and there's
They're still going to do 10 minutes of this? What else are you going to show?
as said before, there's one additional piece of evidence there. Is this something that you created and something that you relied upon?
It is.
Okay, Your Honor, I move that as Defense Exhibit 135.
Any objection?
No.
135.
Sir, if you can explain to the ladies and gentlemen of the jury the significance of this in terms of digital forensic analysis.
So the content to me is not as informative necessarily as the sequencing. So we had Facebook at 10:01. If we look just above the Google login we just discussed, or the Gmail login we just discussed, we have the Gmail login at 10:03, and now we're back in Facebook at 10:03 and 35 seconds. The significance of the highlighted portion in the last artifact, or the newer one that we're reviewing, is that we're looking at a media attachment within Facebook. Obviously, for any of us who use it, there's a lot of different things we can look at, but in this particular one, we were looking at a media attachment.
Cesar Sky said, I love it that you aren't always perfect, Grizzly True Crime, but you are most of the time. Listen here, I'm trying, okay? I'm only human. And today you guys asked, do you ever sleep? Yes. After a day like yesterday, absolutely. The day started with a Red Bull, okay? Sorry that I forgot that. It won't happen again. I hope not. I've got checklists, okay? So thank you so much.
Sir, if you could look at the next slide, which would be identified as
What is he
Defense Exhibit
writing?
136.
Tell us, sir.
Please explain to the ladies and gentlemen of the jury, is this something that you relied on in your digital forensic analysis?
Yes, it is.
Okay. Your Honor, I move that in as
Any objection?
Defense Exhibit 136.
136 evidence published.
Go ahead, sir. Can you explain to the ladies and gentlemen of the jury what this significance of this in the line of messages?
Yeah, so
If you saw the screen go dark, I just needed a screenshot of this guy. This guy just looking at the back of his head, just looking when he can at his notes. Tell us. I wish you could tell us, what on earth is this guy scribbling? Hi, sir.
As we might imagine, as we do things on our computers, things happen in rapid fashion. And when we slow down and sort of look at what's happening on the back end and visualize it that way, it seems to make sense. So just before this, at 10:03 and 35 seconds, we are looking at a media attachment, what I believe is a photo on Facebook. And then 5 seconds later, at 10:03 and 40 seconds, we have a download of a photo in the Chrome browser that was being used at the time. And this is a download to the computer.
Thank you, sir. I'm going to ask you to identify as Defense Exhibit 137. Can you look at that, sir?
Yes, I can.
And is this something that you analyzed and created as a result of your digital forensic analysis?
It is.
Your Honor, I move that in as Defense Exhibit 137.
Any objection? 137 in evidence. Published.
Sir, can you give some context, or can you explain to the ladies and gentlemen of the jury how you obtained this and what the significance of it is?
Sure. So again, each of these is building on the previous artifact, but so at 10:03:40, we had the photo downloaded to the computer. At 10:04 and 23 seconds, so under a minute later, that same photo is emailed as an attachment from the alleged suspect Gmail account to the alleged suspect Gmail account. And the email attachment, if we look at the file name on the very bottom that ends in 1973_n.jpg, we can see that that's the same file that was downloaded from Facebook 2 lines above it at 10:03 and 40 seconds.
The way he says it as well. Oh, it was downloaded at 10:03. Guilty. In my opinion, guilty. I'm looking directly at Brendan Banfield with this and thinking, how dare he? Maggie said, by the way, regarding noise cancelling windows, Herndon is in the flight path of Dallas International Airport. It would be an easy sell for someone who needs her sleep. Absolutely, right? I agree with you. Yeah, thank you so much for your sticker.
And sir, this is identified as Defense Exhibit 138. Is this highlighting what you just said?
It is. This is just drawing attention to the fact that we're correlating now the same photo. And this is one of the things we do in digital forensics. We can follow an artifact around as it goes, and that can be informative.
Your Honor,
can be informative that if that was Christine Banfield taking that photo, okay, she took the photo. I agree with that. Yes. Why on earth would she need to do all these steps to send it to herself, to download on Chrome, and then there's Facebook? All these places are involved to then make the FetLife account. Wouldn't you just use her phone to make the account and put the profile picture? Also, who would put that picture on a FetLife account? It's like a mom swimsuit. It's a beautiful swimsuit. She's a beautiful lady, but for FetLife, I don't think so. Stupid Brendan Banfield, in my opinion. It's a lot of steps. Why? Because you wanted it to be on her work laptop, right? Because you weren't going to have access to her phone at all times. So you were likely, in my opinion, allegedly the one doing all these things. You and your girlfriend, the au pair, who then moved into the master bedroom after 2 people were killed in there. Okay.
move that in as Defense Exhibit 138.
Any objection?
Samantha says, yeah, it's not a fet pick. Now, I don't know exactly what will qualify as one, but I just can imagine not that. I don't know if the community on FetLife would be all that responsive if that's what one is putting out there. I don't know. I'm not sure. I've never been on there, but I'm like, stupid Brendan. That's the best you could do, bro? Oh, my word. Okay, don't make me rage more. Just get on the stand and tell your side, then we can laugh at it. I mean, hear it.
Noted.
All right, 138.
The ladies and gentlemen just see that. Do you want to direct them as to what the change is in this?
Oh, I'm sorry, yeah, this is just the annotation I described, just showing that these two artifacts are linked. The download,
Sorry,
it's gone.
I
There it is.
my big fan.
The download a minute or so before the email.
Okay, thank you. Sir, I'm going to have you look at the next slide, which will be identified as Defense Exhibit 139.
All right. Jezebel Wright says, I'm a member for a long time, and yet definitely not. Right? I don't know. I mean, one could argue, okay, well, maybe one could. It just makes it less likely. And especially shame the defense. They shot themselves in the foot yesterday with their direct examination of all those detectives, especially that Giacchio guy. Ooh, he said a lot of things we hadn't heard before, which actually helped the state a lot. That was interesting. Do you remember all the things he said, or must I go over it?
What is that?
These are WhatsApp messages from Ms. Banfield's cell phone.
Okay, and what, if anything, how did you arrive at, how did you get these digital forensic artifacts?
From the review of the data provided from the portable case related to Ms. Banfield's cell phone.
And, Your Honor, I move this in as Defense Exhibit 139.
Any objection?
No.
139?
For anyone who missed it, I'll recap 3 things. Number 1, Detective Giacchio said that Christine, in all the history they looked at of her internet search history, thank you, Cynthia, for the 5 coffees, in all her search history, she'd never even visited a porn site. So it's really unlikely that she's suddenly going to make this FetLife account. Possible, but unlikely. Also, they had surveillance from the gym, and they could see when either Juliana or Brendan left the gym early, usually Juliana, and then would be at the home with Christine, and then the device would be used. They actually could corroborate that. Why the state didn't present all that evidence, I don't know. We'll never know. And then also, when Juliana and Brendan went on trips, like to New York, oh, then suddenly the account wasn't being used at all. Oh, my word.
Can you explain to the ladies and gentlemen of the jury of what the significance of this communication, and am I correct, this is all on January 17th?
This is on January 17th, yes.
Okay.
So I think as Detective Miller said rather well, context matters, context is helpful. So we don't, to help determine user attribution, which is always the big question for us in the digital forensics field, we don't just look at one device, we look at everything we possibly can to inform what a person was, where a person was. If someone's device is being used by someone other than the owner, if they're physically removed from it, we can draw that conclusion. So I was simply looking at Ms. Banfield's phone at the same time frame that I was looking at her laptop, so we can see the date is January 17th, and the timing is right around the same time that we were looking at from the computer a moment ago, right around the early 10 o'clock hour.
The early 10 o'clock hour, she was probably fast asleep. Shame. Ready for another long work shift, as a pediatric nurse. Also, just to further explain what I was saying, thank you, Cynthia. I think if someone had knowledge of a fetish life site, I don't know how many people would be like, it's a beautiful photo, but it's like in just a swimsuit, like new bathing suit. Wouldn't you want to express your matches, you know what I mean, for whatever fetish you might be into? I don't know. It's just like, it just makes it less likely, even more. I don't believe that Christine made the FetLife account, but that's my belief based on what I've heard. The jury will have to make up their own minds. You make up your own mind. I think it's so unlikely that Christine made that account. So, and all of this that the defense is showing, to me, it just makes it even less likely, especially based on everything else we've heard, right? Okay, so for everyone that's going to now say, because I know how it goes already from other trials, oh my word, WhatsApp is so sus. It's really not, because everybody outside of the USA uses WhatsApp. That's our primary communication method. But then one might say, well, why did Christine have WhatsApp? To communicate potentially with the au pairs, right? And with the hiring agencies and all that, who knows? And I think it's a useful app either way, right?
Sir, I'm going to move to the next slide and have you take a look at that. Do you identify?
Sharon, you saying what I'm trying to say. Sharon Michalowski said, do you really think a person on FetLife would post such a benign photo as that one? No, but that's all this moron could find to exploit the mother of his child. Right? Yeah, this freaking moron.
Identify that slide?
I can.
And just to be careful here, is the left side of the slide what was on the previous slide, 139? Were those the communications that you were talking about on the previous slide?
Yeah, so,
Do you want me to go back so you can see it?
no, I have them both.
Okay.
Would you like me to describe this?
If you could describe it.
Yeah, so one of the things that the forensic software allows us to do is both look at the artifact in sort of a raw form that might be useful for us, but it also allows us to visualize a conversation just like we would on our devices. So we'd have, sort of a comment bubble or a chat bubble on the right and the left as we talk with somebody.
Okay.
So it's just a visual representation of the same data.
And so without getting into the conversations, were you able to determine that a conversation took place?
Yes,
Okay. And were you able to determine who the conversation was between?
yes.
Okay. Your Honor, I'm not going to present
It's
that.
just ID is 140, that's fine.
140, okay.
Is this a good time for a break, Mr. Carroll?
That would be fine, Judge.
Okay, all right, let's go ahead and take our 15-minute recess at this point. Please do not discuss the case with anybody, don't do any outside research, okay?
He looks even more desperate today. Just stop looking at them like that.
Okay, sir, since you are testifying, just don't discuss your testimony with anybody to include the defense team at this time, okay? All right, we'll come back at 11:45, okay?
We can skip forward, teleport, buckle up, everyone. Okay, and we're back.
Share with me.
Thank you, Annie Kutsia, for the ZAR, South African Rand 1049. I really appreciate it. Vanessa Vermaak says, no need for squats today, I see. We've chosen sparring instead. Yes.
All right, your next question.
Thank you. Mr. Lidsky, I'm going to have you look at the next slide, and if you can just identify it. Can you see that on your screen?
I can.
And is that something that you utilized in your digital forensic analysis?
It is.
Your Honor, I move that in as exhibit number 141.
Any objection?
No, ma'am.
141.
Sir, can you please explain to the ladies and gentlemen of the jury what's the significance of this artifact?
Sure. This ties into the prior slide and artifacts that we reviewed, or the ones from the laptop, 2 slides prior. Again, we're just going chronologically and looking at what the user of this device was engaged in. Of note, and it might be helpful to go back 2 slides to the previous blue one. We're seeing a bouncing between applications and between accounts. That's helpful for me in this case, at least, because part of the information that I was aware of from witness interviews or co-defendant interviews is that when this device, which was the subject of alleged misattribution, removal, and use by another party or parties, that when the laptop was in that possession, it was just, we were just using the account, or it was directed account usage. Here we're seeing a shift back and forth. So we started with Gmail at the beginning of this 2 slides ago. And then we went to Facebook, and then we had a download, and then we saw the suspect alleged account, or alleged suspect email account in use. Then, and now here at 10:05, so this is all within a 5-minute window, we're back into Ms. Banfield's sort of the non-suspect account, so just her personal email account.
Sir, I'm going to have you look at the next slide, which is what you just described to the ladies and gentlemen of the jury. Your Honor, that would be exhibit number 142.
Any objection?
No, thank you.
Sir, can you explain to the ladies and gentlemen of the jury what's the significance of the additional line that's down on the bottom of this slide?
Yeah, it's merely just a continuation. The first line of this demonstrative, or sheet of the demonstrative, is at 10:05 at 17 seconds, and that's looking at a particular email. So that's where we see on the second and third lines, respectively, sent mail. That's the sent mail box and the inbox with a lot of unread messages. The first line is an actual specific message.
Sir, I'm going to have you look at the next slide, which will be identified as exhibit 143. Do you recognize that slide?
I do.
Do you recognize the additional line?
I do.
Okay. Your Honor, move that in as exhibit 143.
Any objection?
No, thank you.
143.
Sir, can you explain to the ladies and gentlemen of the jury the significance of this artifact?
Sure. So this is a Google search for FetLife, which obviously is important in this case. Of note is the timing, again, looking at what's occurring right before this. So at 10:05, 10:06, 10:07, we have activity within Ms. Banfield's email account. And here at 10:07, basically 10:08, now we have a Google search for FetLife. So we've moved, the user of this device at this time has moved from one to the other.
Your Honor, I'm going to move on to the next slide.
All right.
Sir, can you identify what will be marked as exhibit 144?
Yes, I can.
And Your Honor, I move that into evidence.
Any objection?
No.
144.
Sir, can you please explain that additional line and how it relates to the ones that you've already discussed?
Sure. So this is typically after a Google search and relatable. The search results come in, and very frequently users will click on a link. So in the third line down, we have a search for FetLife, and then immediately after, within under 30 seconds, we have a visit to the FetLife site.
Your Honor, I'm going to move to the next slide,
All right.
and this will be identified as exhibit 145. Sir, is that an artifact that you utilized in creating this slide?
It is.
Okay. Your Honor, I move that in as exhibit 145.
Any objection?
No objection.
145.
Sir, please explain the significance of this additional artifact to what you've already described for the ladies and gentlemen of the jury.
So this is a second login to the alleged suspect email account, the CBRN 920 Gmail account at 10:12 p.m. My experience is you cannot be logged into two Gmail accounts at once on the same device. So looking up to the top row of this slide, we're into Ms. Banfield's sort of personal email account. So at that point, this computer was logged into the C. Banfield RN account, and now we're seeing a relog in back to the CBRN 920 account.
And is there any way to know what device that is?
That was from this laptop, from Ms. Banfield's Lenovo laptop.
Your Honor, I'm going to move on to the next slide.
All right.
And that will be identified as Exhibit 146. Sir, is this an artifact, or is this a slide that you created based upon your digital forensic analysis?
It is.
And Your Honor, I move that in as Defense Exhibit 146.
Any objection?
No.
146?
So moving on, sir, can you explain to the ladies and gentlemen of the jury what the significance of the data that's before them?
This is from Ms. Banfield's mobile device. This is a little bit later in the 10 o'clock hour, from 10:43 to 10:46 p.m. And these are just website visits that were performed using her mobile device at the time.
Your Honor, I'm going to move to the next slide.
All right.
And this will be identified as Exhibit 147. Sir, do you recognize that artifact?
I do.
And is that something that you reviewed in preparing this slide?
It is.
Can you please explain to the ladies and gentlemen of the jury what's the significance of this? Oh, I'm sorry, Your Honor, I move that in as,
Any objection?
No.
I think she said no.
Oh, you said no.
I'm sorry, no.
Okay, all right. 147 evidence, sorry.
Okay, now it's on display, so if you could please explain that to the ladies and gentlemen of the jury.
Yeah, this is simply opening the photo app on the Windows laptop.
Your Honor, I'm going to move to the next slide.
Be a light in the dark. Firstly, Moonchild 55, thanks for the 5 coffees for the mods. Be a light in the dark said you can be signed into 2 different devices on one Google account. I have 2 phones that are signed into my Google account. I know, right? I have multiple devices signed into one Google account. I'm like, what the hell is he saying? Surely the jury is like, no, anyone with a Google account would know that, right? Not?
All right.
Identified as 148.
Any objection to 148?
No.
148 in evidence.
Sir, explain to the ladies and gentlemen of the jury what the artifacts are and how they're significant.
So the user of this device at this time, using the Photos app, edited the photo we saw back at the beginning of these slides. So if you remember the photo we saw that was downloaded from Facebook to the device ended in 1973_N. And now we see at 10:47 p.m. a new photo ending in 1973_N edit.jpg has now been used by the Photos app on Christine's laptop.
Your Honor, I'm going to move to the next exhibit.
Damn, he almost rubbed his eye out. Did you see that? My goodness, Brendan.
Sir, do you recognize this exhibit?
I do. It's just a
Identified?
call out for.
Okay, it'll be identified as Exhibit 148.
149.
149. I
Any
apologize.
objection to 149?
Yeah, but that too. Cozy Right says, gee, that's false. You can be logged into more than one Gmail at a time. I keep my personal work emails open in different tabs. Me too. I mean, right now, even on my phone, I have multiple Gmail accounts because I need it. I need one for PayPal. I need one for here, also to prevent if I'm a hacker. Touch wood, never let that happen to me, please not. Okay, if they get in anywhere, you can't get it everywhere then, you know what I mean? So it's for safety, for security, but like literally logged into multiple Gmail accounts or Google accounts at the same time on one device. And also on the computer. Like, what is this guy saying? Just stop it. You can't gaslight the jury.
Well, he didn't make the circle himself, but I don't object.
Okay, 149 in evidence.
And I'm sorry, if you could, the jury now sees that. What were you saying about that?
Yeah, that the circle is just a call out to what I described, just taking note of the file name.
Your Honor, I'm going to move to the next slide. This will be identified as Exhibit 150.
Any objection to 150?
Nope.
150.
Sir, can you,
Yeah, it's just a further call out to the tail end, the 1973_N@JPG.
and when you say call out, what your explanation was?
Yeah, just drawing attention to the, significant part of the file name.
So I'm going to move to the next slide.
All right.
Sir, do you see the slide in front of you?
I do.
Okay, and this will be identified as Exhibit 151.
151, any objection to 151?
Judge, if you could lay foundation for how this slide was created.
All right.
Sir,
Stefan says, this witness is not a digital expert anymore, maybe an expert in BS, that's all. Are we there yet?
what is it that you examined in order to create this slide? Can you explain?
Sure. I reviewed the responsive documents provided by FetLife to create this. I took screen grabs or snippets of those documents, which are rather voluminous, and I consolidated for me, what the salient points were into this slide.
And this is specifically related to this slide, correct? I'm sorry, to the topic of this slide.
Yes, this is the important information from the FetLife documents for this discussion related to this slide, yes.
Okay, Your Honor, I move that in as or Defense Exhibit 151.
Any objection?
Judge, I do. Unfortunately, it's out of context, and I think best evidence would require the full document be used.
Do you have the full document?
Judge, I believe that's part of the stipulations that were put in relating to the FetLife documents.
Correct, and we've admitted the full document into evidence. I think that is the document that should be used.
I don't have it right now, Judge.
All right.
We can move on from
If you can
151.
supplement it with the full document, then we can
Yes.
put it in. Okay.
Your Honor, I'm going to move to what will be identified as number 152. Sir, do you recognize this slide?
I do.
Okay, and I think there's been an objection relating to the full document, but what's the additional information that is on this document?
It's the addition of a photograph.
Okay, and what's the origin of that photograph?
Objection, Judge, asked and answered. We've already talked about this photograph. It's been admitted into evidence.
Okay.
Okay. Your Honor, once we get the full
Okay.
document, then I'll
Sure.
ask for it to be admitted. I'm going to go on to the next slide, Judge.
Okay.
Sir, can you identify the artifacts that were used to make up this slide?
Yes, I can.
Okay, and where did they come from, and what's the significance of them for the ladies and gentlemen of the jury?
These came from Ms. Banfield's cell phone. They are web searches.
If I may just interrupt for a second, Your Honor, we'd move this in as Defense Exhibit number 153.
Any objection to 153?
No objection.
153?
Sorry, I didn't mean to interrupt. Go ahead.
These are web searches or website visits from Ms. Banfield's cell phone from January 17th, from 10:49 through 11:29 p.m. They're informative in that the 10:49 artifact at the top was about a minute after the FetLife account was created, so for timing, it's informative. For the middle column, we can see what the website was, or what was the website that was visited, what the content was. So that can be informative for a digital forensic examiner in helping determine potential attribution based on the content. So is it?
Oh, my word. Women's New Year's Sale 2023 Lululemon. These are all normal searchers. 12-year-old's leg amputated after 10-hour wait, lawyer says. Man dies after hospital ignores him for 7 hours, lawsuit. Wife of William Daniels was devastated by early open relationship. Tickets for Frozen, Broadway tickets. What is the point of showing this, sir? It's also on the 17th of Jan of 2023, same day. The FetLife account was created, and this shows the time that it's around a similar time. So if Christine was upstairs using her phone and Jackass and his girlfriend were downstairs using her laptop, that could explain a few things, but all right. Is that possible? Yes, it's possible. Caroline Fenton says, are we going to go through all her searches? I know, right? Like, why?
Content related to one person over another? Is it related to, in this case, a catfishing theme? Is it related to, or is it what we might expect from a user's normal activity? It's also, I'm sorry if I can add one.
No, please.
Timing also is informative, obviously. If somebody's device is in use and we can assign attribution, then it shows that they're awake and in possession of their device. And obviously that was, for me, that was something important for this investigation to take note of.
Now, if just to deviate for a moment from that, in digital forensic analysis, what, if anything, do you do to try to determine a pattern of life regarding the use of devices?
Yeah, I can typically just looking at use over time, what's normal for a user. I've done that with, mobile device tracking, cell phone tracking when I was in law enforcement.
Sure. How do you go from frozen to FetLife? Do tell us, expert. I mean, some people can. I'm just saying, for Christine Banfield, in this case, in this context, tell us how this gave you insight.
You can infer patterns from the data, from use over time. On Ms. Banfield's computer, based on one of the statements the co-defendant made during her interviews, and I believe, again, a testimony was that she dropped her backpack by the door and didn't touch her laptop after that. I looked backwards for about a year in time of her user activity, and she was frequently using her laptop well into the evening from 10.
Judge, objection is to speculation.
Oh, wow. A year. That matches up to the affair timeline. Isn't that amazing as well?
He can tell us what the devices were doing.
Now, sustain.
If you could just explain what you were explaining as to what the devices were doing at what period of times, in terms of the pattern that you just described.
Sure. Ms. Banfield's device had a history of activity, devices have a history of activity well into the evening for an extended period of time, both
Was
before.
there a time frame that was consistent during that period of a year that you went back?
It was frequently between 10 or 11 p.m. and 1 or 2 a.m.
On her account. Are you sure it's on the laptop? Because you're jumbling words here, sir. If it's on her Gmail account or Google account, if she's upstairs with a phone and the idiots are downstairs with a laptop, yeah, that could make sense then. Okay? My goodness.
Your Honor, I'm going to move to the next slide. Sir, do you see that slide?
I do.
Is that a slide that you created?
It is.
And was it based on your analysis of digital forensics?
It is.
Your Honor, I'm going to identify this as 154.
Any objection to 154?
No.
Or 154 in evidence?
Mary Fryer says, in my opinion, B is used to digging for details as an IRS agent. I think he thought he covered his tracks. Truth is, criminals are stupid and it will get him. Especially when there's two of them involved in a plan, right? One's going to tell on the other, which is exactly what happened here, number one. Secondly, the other one, Juliana phoned 911 way too soon, and he's like, which makes sense because there was a 911 call, and then for 11 minutes they tried to get hold of them to call back, and Juliana and them and Brendan ignored the call. And then they called back after 11 minutes. That is a huge mistake. That says a lot about that day as well. So thank you so much for your sticker. I've updated the thumbnail now to say, he takes the stand, ... Today? Defense attorney said he will take the stand. But will it be today or next week? Because at this pace, yeah, next week or maybe even the week after.
Sir, please explain to the ladies and gentlemen of the jury what the significance of these artifacts are.
So here we have another, the date is still January 17th. The time is from 11:32 through 11:35. These are from Ms. Banfield's mobile device. We have a couple of website visits on the top and the bottom, and in between, we have a number of email email inbox visits with a Google, a couple of Googles in between. Of note here, towards the right, the second to last column on the right, the digital forensic software we use can tell us whether a device was local or synced, among other sources. So we can see where we see local, it means in this case, the two local artifacts were website visits on this device itself. The intervening artifacts that are labeled as synced tell us that those could have come from a secondary device and are being replicated here as a result of Google's ability to sync accounts. If you're logged into your account on more than one device, what you do on one might appear on the other.
Exactly. Lexi and the liar said, what he said right now is not good because it counters what Juliana said. Somewhat, not really. I'll say why. He's talking about the laptop. It has different physical address than the phone. So, yeah, there will be different data connected to it. Does it counter what she said? No. Maybe it was Juliana looking up Lululemon, the articles, and the Frozen tickets because she was, after all, the au pair. So if Christine said, can you take my daughter to see Frozen on this date, and Juliana's looking up Frozen tickets, that makes sense. And sometimes Juliana, Brendan, and the daughter would go on outings while Christine worked. You know what I mean? So it doesn't have to counter it. If it was for about a year, Juliana could have, maybe Christine said, use my laptop if you know, you can use my laptop in the evening if you need to. So yeah, it could just be that. But anyway, it's just, is this helping the defense's case? I don't know.
Now, the January 17th, what was the significance of January 17th again?
The FetLife was created around 10:48 p.m.
Okay, and so the timelines of all of these slides that the jury has seen are significant in terms of this set.
Objection, counsel's testifying.
What's the significance of it relating to the times?
Well, we've just walked through what was occurring on Ms. Banfield's laptop and her phone in the 45 minutes or so before, through the 45 minutes or so after. And recalling the first slides we saw Windows log on to the laptop. So we've seen, the activity that evening began around 10 o'clock when we first started running through these.
And are you, based upon the analysis that you did during this slideshow presentation, are you able to opine as to, within the degrees of digital forensic analysis, your opinions as to what was going on January 17th?
I am.
Can you provide that opinion?
So, again, revisiting the originating slides, we saw a log on with Ms. Banfield's security identifier to her profile, at least on her laptop, around 10 o'clock, joining the Wi-Fi, which our computers do automatically. Immediately, we went into her email account, or the user of the device went into her email account, and then we started seeing other activity. We saw the alleged suspect Gmail account be logged into, and then we were back into Ms. Banfield's Facebook account where we viewed an image, a picture, a digital image. That image was then downloaded, and these are all happening within either seconds or a minute. That downloaded image was brought to the device early in the 10 o'clock hour, I think around 10:05, and then we saw, 30 or 40 minutes later, the Photos app opened up, an image edited, and that image would ultimately be uploaded to the FetLife account during the account creation. All the while on Ms. Banfield's phone, there appears to be certainly user activity. As Detective Miller said, context is hard, and we might need other corroborative data to see who was conducting that, but it's certainly unrelated. I think the website visit about Kristen Chenoweth has nothing to do with the scheme here at hand. So We can infer, and we do, and this is just one event in a timeline of many significant events, but we can draw inferences based on the totality before, after, during, and the content of who might have been operating. What I didn't see was a gap in time where a device that appears to be going in and out of accounts related to the scheme and not related to the scheme was exchange hands, like misappropriated. I didn't see any gaps of time where, where somebody might be using a device and then like go to the bathroom and the device would be taken, potentially somewhere else in a house, used by somebody else and brought back. I didn't see gaps here for this particular event where that either occurred or even could have.
Objection calls for speculation.
All right, let's sustain this last part.
Okay. Based upon the analysis, in terms of the statements that you're making, what are your conclusions?
I didn't see anything here that indicated loss of control of the device. I'm not able to say who was in control of the device for the entirety of this period, but I did see inconsistencies in that the usage was not confined just to the accounts related to this investigation. In this case, that would be the suspect alleged Gmail account and the FetLife account. So interspersed with that, I saw personal account usage with Ms. Banfield's accounts.
All right, thank you. Mr. Lidsky? Sir, do you see the first slide before you?
I do.
Okay. And this, what's the topic that we're dealing with in terms of this particular piece of evidence?
So this is a snippet of a video interview with Ms. Magalhaes. I believe in this particular clip, she's answering a question about the Telegram account creation and the associated activity. I think the deleting of the SMS code that was used to stand up a Telegram account.
Show us the clip.
Your Honor,
Are we going to hear it? Are we going to see it?
I'd
What are we gonna do?
identify this as defense 155 and move this into evidence.
Objection, hearsay.
All right, I'll sustain as to hearsay.
Sir, do you see the slide that's before you?
I do.
And what, if anything, what does this say? Or what, I should say, what's the significance of this in your digital forensic analysis?
So this was recovered from Ms. Banfield's cell phone, and it is the Telegram 2FA code, I think the two-factor authentication code that was described in testimony.
Okay. And, Your Honor, I would, I've identified it as 155?
156?
156. I'd move that into evidence, Your
Any
Honor.
objection to 156?
No, Judge.
All right, 156 in evidence.
Okay. And sir, what's the significance of this particular artifact with regard to the issue of the Telegram setup?
So the relevance here, I think, is corroborative information. Lieutenant Giacchio spoke about that yesterday, and it's important to discern the veracity of witness or co-defendant statements or testimony. This artifact was recovered from Ms. Banfield's mobile device. From my understanding of the investigative materials provided to me, this had been deleted by Mr. Banfield. It wasn't deleted, it was still there. I understand.
Objection as to the mischaracterization of previous testimony.
If you want to approach this. knock this out.
Oh dear. How can you say who deleted what? No one can say that. Oh, Juliana can say it because that's her story, but how do you know? Okay.
Talk slow, my computer's restarting.
Oh dear.
Can you open
Don't you love it when the computer decides, I'm restarting now, it's time for an update? Not mine. The state just said theirs was restarting.
And sir, going back to this artifact, this was related to, I think you said, the Telegram setup and the two-factor authentication?
Correct.
Okay, and what's the significance of that in the context of the Telegram setup?
That is still present on Ms. Banfield's phone.
Okay. Is that significant that that would be on her phone?
To me, it is.
Okay, and in what way is that significant that the notice of a two-factor authentication?
The notice itself, not much. Its continued existence is of note because I find it inconsistent with the theory of the case.
Okay. Your Honor, I'm going to move on to,
Sure.
and I'm sorry, 150.
Maybe a point for the defense. I don't think Christine made the account, meaning the FetLife account. But could Brendan have told her, you know what, you should use Telegram. It's even better than WhatsApp. Sure, he could have. And that could be why it's still on there. There could be many reasons. Right? Lala sells it best place to be for true crime coverage. Gisela, the great. Oh my word. Thank you so much for your $10 sticker.
57. Thank you.
157.
And sir, do you, can you identify these artifacts? And is this a slide that you created?
I can, and it is.
And it's based upon your digital forensic analysis?
Interesting.
Okay. Your Honor, I move that.
Yeah. Ajax 4165 said deleted texts are still technically present, basically just hidden. Oh, imagine if they saying that. If it wasn't like visible, but like in a hidden oh my word, okay.
That is,
Any objection?
No.
Okay, 157.
sir, can you please explain that to the ladies and gentlemen of the jury?
So these are, I believe, the 4 most recent text messages from Ms. Banfield's device over this time period. So from late evening or night of February 18th, 2023 at around 10 p.m. through the morning of the 19th at around 10 a.m. So at 9:58 p.m. on the 18th, we have just a message exchange with who I assume is a coworker based on the contact name. But at 2:19, so after midnight at 1:37, and again at 2:07, we have two FA codes. One of which is the Telegram code we just looked at on the prior slide. But the one before that is a signal verification 2FA code. A signal was not used in as part of this alleged scheme, but to me it's informative that other secure messaging apps were experimented. At least it appears the user of this device experimented with others. The message on the morning of the 19th, again with another coworker, is there only to show sort of bookend activity. The idea that because the 2 FA messages from the early morning of the 19th were not deleted, they would be readily viewable by the user of the account the following morning. And so when normal sort of messaging activity resumed, the idea that to me, as a digital forensic examiner, the 2FA codes, were not hidden or unseen by the user of this device.
And so
Objection calls for speculation. He can't testify as to what someone saw or not.
All right, I'll sustain as to the last part there.
in terms of, you said 2FA, in the event that somebody doesn't know what that is, describe what two-factor authentication is.
Yeah, two-factor authentication, 2FA, is the way a number of service providers just require device possession. It's a way for them to confirm that you're holding and using and have authority, in theory, to use the device that you're registering. So it prevents us from signing each other up for a bunch of accounts. So that's why in this case, Signal and Telegram require you to be in possession of the phone that you're asking them to permit your use on their servers.
And who would have lots of knowledge of, well, I think everybody should use two-factor authentication, by the way. But who in the household, in this case, would have lots of knowledge of how people communicate more privately, how they do that, how important two-factor authentication is? Yeah, Brendan Banfield, an IRS agent, a federal IRS agent. I think he would know about all that. So, yeah.
In a situation or in a case like this with the allegations, would a two-factor authentication code's existence,
Objection leading.
There's a status to leading.
what if any significance would that hold in a case such as this?
For me, based on my experience, both as an investigator and digital forensic examiner, any misattribution scheme, to include catfishing, the name, misattribution is important. You want to hide your tracks. The idea is that the target of your efforts is unaware that they are being targeted, and you're exerting effort, on that plan. So if you leave evidence behind, if you leave something that...
Judge, objection. This is speculative. He's speaking about what people do in catfishing. I don't think he's speaking to what happened in this case, and I don't believe that
It's overruled. Okay, continue.
So the idea is to hide the hand, right? If somebody sees that their device or devices were tampered with, or there's usage that's not their own, they may become suspicious. They might question it. It could certainly raise a red flag. So traditionally, in my experience, one would remove all traces of their activity if, in fact, it is misattribution.
Here, I'm going to move on to the next slide.
Okay.
And Your Honor, I would identify this as Defense Exhibit 158.
All right. Any objection to 158?
No,
158 in evidence.
Sir, do you see that slide?
I do.
And can you explain the significance of this analysis and this slide to the ladies and gentlemen of the jury?
These are unrelated, but I felt informative activity from Ms. Banfield's phone, again, from the day before and the day after. These are other user verification codes or 2FA codes for Microsoft and PayPal, things not related to the scheme, but they tell me that the user of this device was familiar with the codes, knew what they stood for, and was unlikely to ignore a message that
objection
contained...
calls for speculation.
All right, I'll sustain the last part, speculation.
Okay, sir, can you just explain that in a way that doesn't cause you to speculate?
For me, being aware of or familiar with how a certain item works would cause me not to ignore it if I...
Objection, Judge. He's testifying as to his personal experience.
I'll sustain the objection.
In terms of two-factor authentication, how does that reveal itself on phones and devices?
How does it reveal itself? Sorry, I just like the way the question was asked. In terms of two-factor authentication, how does it reveal itself on a device? Okay, here we go.
It's readily identifiable by his face. I mean, we can look at the message and see what they are. Any users or people who engage in 2FA activity typically can identify them when they pop up.
Thank you. Your Honor, I'm going to move on to the next slide. Your Honor, this would be identified as Defense Exhibit 159.
Any objection to 159?
No.
159 evidence.
What does this say, Mr. Lidsky? And if you could explain that to the ladies and gentlemen of the jury.
At 1:34 a.m. or approximately 1:34 a.m. on February 19th, an application was installed on Ms. Banfield's mobile device. We can see the name of it, thoughtcrime.secure SMS. That's the corporate name or the fancy name for Signal, which is a secure SMS messaging platform.
Can I just interrupt you?
And who else would know about Signal? Could Christine know about it? Of course. A federal IRS agent too, especially one that cheats a lot on his wife, because he apparently had other affairs before. That's alleged, that's a rumor, but like, I believe it. Yeah, Stefan's like, that was a hell of a revelation. Guys, these people are changing my mind. He is totally innocent. Makes perfect sense now. As if. Can we get to the part where he gets on the stand? I think they're just going to install until next week, right? Damn it, man.
For a second.
Yeah.
What is SMS?
It's communication, it's messaging. It's just a digital communication platform.
Okay, sorry.
Not all. So Signal was installed on Ms. Banfield's device at approximately 1:34 that same evening. Informative, although even though it didn't play into this case, this investigation, it is, I'd say, a comparable app to Telegram.
Judge, I'm going to object to that statement. I don't believe that the witness has laid any foundation to suggest that Signal wasn't part of this investigation.
I guess foundation is the question. If you
Okay. In your examination of the evidence that has been provided to the defense, does that inform your statement that you just made in terms of Signal?
Yes, my understanding of the evidence I've reviewed is that the suspect Gmail account was in use, FetLife, and Telegram was the secure messaging application that was used. Other similar applications like Signal, I did not see, nor was I made aware of any use by those on those platforms.
Okay. Can you please continue with your answer?
Sure. Signal was installed on this device, irrespective of what its intended use was for. We saw the Signal 2FA code on the slide before, and that's expected of what we'd see with an installation. That's usually when they require us to confirm the device that we're registering. Just given that it was a secure SMS that was installed or at least reviewed around the same time that the Telegram app was also being installed, I thought it might be related, and I flagged it of interest for that purpose.
And is it noteworthy in your investigation the email account that was used?
So the email account that's on here is obviously Ms. Banfield's. That would be the account associated with the device itself in the Google Play Store, which is required to download apps. So yeah, that is the account that was associated with the phone and this resulting download or installation.
Thank you, sir. Your Honor, may I approach?
Yes, sure.
Mr. Grizzly says hi. Are we there yet?
160.
Oh my word. We're still going.
Sir, I'm going to ask you to look at the slide before you, and that will be identified as 160, 160.
I see it.
Objection to 160? Okay.
Sir, what, if anything, did you look at in order to create this slide in terms of your digital forensics analysis?
This is a data location or a location of Ms. Mugglehise's device, her phone, her mobile phone, on February 20th and at 10:46 p.m.
I'm sorry, did you say the co-defendant's name?
Yes.
Okay. And
I'm sorry, whose name now? Juliana, yes, the co-defendant. Also, JHIC6085 said, didn't Brendan and Juliana get rid of their phones and Apple ID so they can't corroborate what their devices were doing or not doing when Christine's device was being used or what was said? Yes! This is one calculated mofo, this guy. He does know things, IT-wise, obviously, especially being a federal IRS agent. He knows things. I think he was doing a lot of calculated things and probably almost, got away with murder. But here we are at the trial. So, yes, they did. He got himself and Juliana new phones. I mean, that's a huge red flag too, right?
what was used to create this document?
This is data recovered from her phone itself.
Okay, and the map portion of it?
The digital forensic software we use, when it encounters a location artifact, it gives us a little map.
And what's the name of that? What's the name of that software?
This is magnets. This is a magnet axiom software.
Okay, so it's the same as what Detective Miller used in extracting these devices and creating the portable case?
It is.
And so this would be identical to what you received from the portable case?
Yes, there's an artifact from within it.
Your Honor, I move that in as Cummel's Exhibit 160.
R-116 evidence?
So we're into it. Well, you tell me, what's the significance of this, and is it related to what you just showed the ladies and gentlemen of the jury?
This, I mean, this was a data point, a geographical data point recorded by Ms. Mugglehise's phone on the evening of February 20th, basically at 10:46 p.m.
And February 20th is significant for what reason?
I believe February 20th, there was significant Telegram conversation, maybe FetLife conversation as well, and was the night of the voice verification phone call between, with Joe Ryan.
Your Honor, I move that in as, oh, I think I may have already done that. Yes, thank you. Your Honor, I'm going to move to the next slide. Sir, can you identify this slide and the significance relating to what you've just testified to?
Now show us the surveillance. You know what's disappointing is that the state didn't put all their digital experts on and show the surveillance and tell us those facts, because now the defense has a lot of room to play in, right? Zengen R said also, federal employees use Signal, so he may have downloaded it to communicate. Baby boy, right?
This is part of a production from I'm sorry, this is a login to Ms. Banfield's, her true name Gmail account from the Banfield residence, also on February 20th, 2023 at 10:58 p.m.
Okay, and is there a timing issue that you're highlighting here?
Well, on the prior slide, I think it was 10:46 p.m. Ms. Muggleheise, or at least her phone, was at Lifetime Fitness in Reston, Virginia. Here, 12 minutes later, we have somebody logging into Ms. Banfield's account from the house.
Your Honor, I'm sorry, identify this as Exhibit 161? And I'd move that into evidence.
Any objection?
No, ma'am.
167 in evidence, 161, I'm sorry, in evidence.
Your Honor, I'm going to move back to the back slide so that
Okay,
there's
you go
context
back.
to what.
160 is in evidence.
Sir, was this the slide you were talking about, and this is the timing that you were talking about?
This is the beginning of a sequence of events and timing, yes.
Okay. And this is 161, the current slide.
Correct.
And it wasn't up for the jury when you were explaining it. Can you go over that again quickly?
Sure, this is just a representation of a login to Ms. Banfield's personal email account from the house from the Banfield residence at 10:58 p.m.
Your Honor, I'm going to move to the next slide, which will be designated or identified as 162. Sir, you recognize this slide?
I do.
And what was it that you analyzed to arrive at the information that's on this slide?
This is a geolocation artifact from Ms. Magalhaes' mobile device.
Your Honor, I move that in as Defense Exhibit 162.
Any objection?
No, thank you.
162 in evidence.
Can you explain for the ladies and gentlemen of the jury the significant aspects of this and why you created this slide?
So on the previous slide where we saw a login to Ms. Banfield's email account from the residence, essentially at the same time at 10:58 p.m., it appears Ms. Magalhaes was on her way back from the gym, or she was at least mobile. She's no longer at Lifetime Fitness in Reston. She's now just on the surface streets in and around Reston.
Okay, and do you have any sense of the distance to the house?
I think it's about a 15 or 17-minute drive, point to point from Lifetime Fitness in Reston to the Banfield residence in Herndon.
Anything else about this slide?
Nope, it's just her location at the time.
Your Honor, I'm going to move to the next slide.
All right.
And is this a slide that you created relating to your digital forensic analysis?
It is.
And Your Honor, I move this in as Defense Exhibit 163.
Any objection?
No, ma'am.
163.
Sir, can you explain for the ladies and gentlemen of the jury what the significance of this slide is relating to February 20th, 2023?
Sure. This is data from two records. The top sort of larger font, which is not done for any purpose. It's not large for any other purpose or any significant purpose. This was Brendan's. I guess it's a swipe, but here his entry to the Lifetime Fitness in Reston on this evening. So they had him swiping in or arriving at 9:18 and 33 seconds. The lower three lines are from, I believe, a T-Mobile record showing Mr. Banfield's position as T-Mobile recorded it, and it's not precise. However, it does reflect the nearest tower, or the tower that was handling the data to Mr. Banfield's phone at the time of the record. So we see that he swiped into the gym at 9:18 p.m. T-Mobile, again, a service provider record, is going to be in UTC, so we have to do some math. But the third line of the T-Mobile section at 3:59 a.m., that would show, that would actually correspond to February 20th, 2023 at 10:59 p.m. And he was still on the same tower. So the reason 3 towers were shown with the Roger Bacon Drive address is to show the consistency. So again, Mr. Banfield logged into the gym in Reston at 9:18. We see at 9:39, with the conversion of the first line of the T-Mobile records, that their tower at Roger Bacon Drive in Reston, which is close in proximity to Lifetime Fitness, handled his data at that time. We see on the next line at, which would now be 10:18 p.m., he was receiving data from T-Mobile on that same tower. And then the third line, which is 10:59 p.m., he's still receiving data from that same tower. So it's just one set of data points corroborating the other, confirming the other.
And so what would you conclude based upon that slide?
that at 10:59 PM, Mr. Banfield was still in or at or
Objection
around.
calls for speculation.
It would be his device, not.
Yes, based upon, okay, I think we have to speak in terms of the devices. What can you conclude based on this regarding his device or devices?
That Mr. Banfield's lifetime gym swipe card was arrested at 9:18, and that Mr. Banfield's mobile device was in vicinity of Lifetime Fitness through at least 10:59 PM all on the evening of the 20th of February.
Your Honor, I'm going to move.
As a reminder, the crime occurred on February 24th of 2023. So they're looking at the days before that. Remember, he had his big boy birthday on the 23rd. Even though the state said in opening statements that the crime happened on his birthday, in fact it did not. His birthday was the day before. Look at him adjusting his tie. Just get on the stand. Is this guy gonna be on all day? Oh my goodness. I mean, yeah, okay.
To the next slide. And that will be 164.
Correct.
Sir, can you identify?
You guys all say, sorry, I don't even care that I paused it there, it's fine. Nap time for everybody. You guys keep saying that you wouldn't be able to watch this trial without me. Oh, I wouldn't be able to watch it without you. We're all in this together. And I really hope we'll see justice for Christine Banfield and Joseph Ryan, the victims in this case. I really hope the state also humanizes them in their closing arguments, because through all of this, the very short state's case, I mean, they rested on day 4, like what the hell? Okay. And then this very long defense case so far. This could get quite lengthy, hey? The defendant might take the stand. That's what the defense attorney said. The defendant will take the stand. Whether that's today or next week, I don't know. The point is, let's hope that the victims in this case, like, can they put a photo up of them or talk about them or something? Humanize the victims so the jury can make the connection and just reiterate the common sense. Because everyone can get in the weeds of all of this. But there's also common sense when you put it all together, right? So everyone can make up their own minds what they think. And we have no influence on the jury either. If you think he's guilty, me too. If you think he's innocent, okay, you're allowed to, right? Right now he's presumed innocent unless proven guilty in a court of law. But here on the internet, you can make up your own mind what you think. I think he's so guilty, no matter what the jury decides. Crafty fella that, huh? Snake in the grass. Freaking, I don't even know. Let me stop. I'm gonna hold me back. I'm getting too snarky now. I can feel it. Let's continue listening to the testimony.
Identify this?
I can.
And was this something that you created?
I did.
And what, if anything, did you use to create this?
Google Maps.
Your Honor, I move this in as Defense Exhibit 164.
The objection.
No objection.
164.
Sir, what can you explain to the ladies and gentlemen of the jury what this created slide says and what's the significance of it?
This is just a visual representation of what I was just describing. So the red dot on the left side of the screen is just the location of T-Mobile's tower at on I think Roger Bacon Drive, and we can see where it's fairly close to the Lifetime Fitness gym in Reston.
And it is the
Going to the gym. Juliana also explained that one would leave earlier than the other and all that. So that's all I think about. If I was on the jury, I'd be like, wait, what did the state say again? Because the burden is on the state to prove their case. So the defense is doing a lot. Sometimes less is more, you know what I mean? But okay, you go for it, so you go for it. Gerda said closing arguments are going to be super important. I agree.
Is there any indication of where the device is at this time?
Well, on the prior slide, we saw where Mr. Banfield's device was on the evening of the 20th between, the 9 and 11 o'clock p.m. hours.
Okay.
This is just showing the tower that the data, what T-Mobile tells us.
Okay. And you created this to be a complement to what you had done in the previous slide?
Yes, just to visualize it. Okay. It's just to visualize it.
Your Honor, I'm going to move on to the next slide, which will be identified as,
And you know we're watching at 1.1 speed, hey? Yeah. Rebecca Barman said, this guy is the most pathetic piece of protoplasm I've ever seen. Thoughts and prayers are with Christine and Joseph's families. Yes. Thank you so much. And thank you, Lisa Longhorn, for spoiling the mods with coffees.
Exhibit 165. Now, sir, do you recognize this slide?
I do.
And is this something you created?
It is.
Your Honor, I move this in as Defense Exhibit 165.
Any objection?
No, thank you.
165.
Sir, if you can explain to the ladies and gentlemen of the jury, what's the significance as it relates to February 20th, 2023?
This is another geolocation point from Ms. Magalhaes' mobile device.
And what does it tell us?
So this is an artifact from 11:06 and 50 seconds p.m., so 11:07 p.m. And this is what, so Ms. Magalhaes had an Apple iPhone, and one of the things that iPhones do is they create significant location visits for us. So places we go frequently, like home, work, gym, Apple categorizes them as significant locations of visits. Doesn't mean anything for us as users, but on the back end, as a digital forensic examiner, artifacts like this can be informative. So in this case, it tells me this is when she probably walked through the door, and you know, her iPhone says I'm home, basically.
Your Honor, I'm going to switch to the next slide, which will be designated as Exhibit 166.
Somebody said, I can't see it now. Wait, there we go. Pearl Harris says, when will this all end? This is painful. Well, technically on February 6th. That is when the trial is scheduled to run until. And now there's also a snowstorm, so there'll be a delay. But it's on the docket until February 6th. Will the defense make use of all their time? I mean, he might actually do that, for all we know. But the judge wanted the defense to, she didn't say it like that, but just like, okay, but you could finish today, right? You know, yesterday she said, you could finish tomorrow, right? And in the state, you've got 2 rebuttal witnesses, perhaps? So we could finish, right? That's why she did jury instructions this morning already. And then she said when they come back, it'll be closing arguments. I'm ready for it, but I don't think it's going to be like that, right? Yeah, Kathleen said, probably shouldn't be speculating. I know. Where's the objection and speculation for every time this expert says things like that? Like she probably walked in the door. You don't know that.
Sir, what is this artifact?
This is a login to a website, a commercial website.
And what's the commercial website?
It's anova.org. It's an ananova.org website.
And what's the significance of having this artifact?
So this is from Ms. Banfield's computer, and I'm aware from the details of the investigation that she worked at ANOVA.
And is the time significant relating to this investigation into Telegram?
It's related to the investigation. I'm not sure
Oh, I'm sorry.
specifically the Telegram.
What's the significance of this?
Well, again, this is there was significance of this date. There are events relative to this date. So what I'm trying to do is determine attribution by looking at all the devices and everybody's location to the extent I can figure it out. So this is just another artifact as we're walking through this evening. This is also at 11:07 p.m., closer to 11:08 p.m. Maybe within a minute of Ms. Magalhaes, or at least her device, arriving home.
Now, in terms of, you used the term attribution. I think Detective Miller used that term as well. Is that a term of art in the digital forensics world?
It seems to be a goal we're frequently chasing.
Okay. So how would you describe it in kind of plain terms for me and the ladies and gentlemen of the jury?
Sure. As Detective Miller said, it's tough for us without a video or being there to put any one of us behind the keyboard, so to speak. Who's holding the device? who's actually manipulating the data. And as he also pointed out, other informative data points can be helpful in providing context and providing corroborative information. Just by way of an example, in this particular case, we have 3 people. Or in any case where if we have 3 people, unsure who's using a device, if 2 people can be confirmed out of the house, and when activity on a device occurs within the house, by relative easy deduction, we can then use those external data points of confirmation of the 2 people out of the house to confirm or conclude that the person in the house was responsible for the data.
But you can't. You can't confirm that. Even if there's gym logins, it's gym logins and there are devices moving around. So, and there's a snake in the grass known as defendant Brendan Banfield, who's was a federal IRS agent. Also, this guy did say, because he's a private investigator now, right? But he said he has some qualifications in digital forensics and mentioned working federally at some point. When? If the state could ask when, firstly, how much are you getting paid for this, sir? Would be a great snarky question for today, don't you think? And 2, how could you possibly say that somebody can't be logged into multiple Gmail accounts or Google accounts on one device and on another device as well? Many devices, multiple accounts. How could you say that? What kind of expert are you, bro? Bring it up, right? And how can you keep saying that Christine did this and Juliana did that and Brendan did this when it's devices? Did you get transferred? Why? When did you get transferred? Lexi says, gee, your snark made my day. Going to take this feeling as my birthday present for tomorrow. Thank you for your work. Mods, chat, lovely community. Love to be a happy birthday for tomorrow. Oh, man. Thanks for spending time with us here today. Let's hear what else is going to be said. I mean, wait, what else should they ask? What else should the state ask to bring this home? One other very important question they need to ask is, so how do you explain that when Juliana and Brendan's device, not just device, they took photos when they were in New York and traveling around as well. There's other ways to corroborate that evidence. When they were out and about on dates, okay, including little trips and sleepovers like in New York, and suddenly then Christine's not using the FetLife account. How do you explain that? That in the time that they're gone, the account's not being used at all. But when they're back in town, the account's back on. Remember, the account was only created about a month before, 6 weeks before the murders occurred. So you have to look at that 6-week time frame. In that time frame, they did travel at least twice. So it really tightens it up. As long as the state could just bring that home, that would be great, Just recalibrate the jury's minds to what the evidence actually shows.
Not much, it doesn't get much easier than that. That's an oversimplification, but that's a goal.
How crucial is the time stamp of these artifacts with regard to your investigation into these types of investigations?
It can be quite crucial. The amount of time, for example, in this investigation, there are allegations or claims of device removal as part of the scheme to facilitate the scheme. So is the timing based on the artifacts facilitate that? Is there enough time for a device to be removed from somebody who's active on one and then be used for any purpose by somebody else without them knowing it? Right? I mean, it's one thing if we take a shower, if it's a 10 or 15 minute gap, that might lend enough time for a device to be removed, used, and put back.
Judge, objection calls for speculation.
Exactly. Objection, speculation as to even how long someone's shower is, okay? You don't know. Could be 2 minutes. It could be 45. Could be an hour. How do you know? How do you know when they're going to use the device, huh? Look at him. He's like, You know you're a naughty, naughty boy. Look at him. He's like, yeah, you're being disciplined now. That's what that look shows me. He knows he's being naughty. Sit on your hands, sir.
All right, I'll see.
Okay. I think we've probably gone where we need to go on that. So
1,000 times over. Sorry. 1,000 times over. You've gone around and around. You've gotten your sort of point across. Sort of. I'm not convinced. Are you convinced?
Move on to the next slide. Your Honor, I'm going to identify it as Defense Exhibit 167.
Okay.
Sir, do you recognize that?
I do.
And what's the significance of that artifact in relation to your investigation?
This is a login from the Banfield residence on the same evening of February 20th to the alleged suspect account, the CBRN 920 account that was used to facilitate ultimately the FetLife and then onto the Telegram and the eventual meeting.
Your Honor, I'd identify this and ask for it to be moved into evidence number 167.
Any objection?
No, thank you.
67?
And once the ladies and gentlemen of the jury and see that, can you please go over what the significance of this is?
Sure. As I said, this is a login reported by Google to the CBRN 920 Gmail account. So that is the email account that was being used to facilitate or to set up FetLife, and then ultimately to the communication, which led to the events of the 24th of February in 2023. This was on the evening of February 20th, and the time was 11:08 and 13 seconds, so 11:08 p.m.
And I'm sorry, did you mention the account that was created or that was used?
Yeah, yes, Judge Aston answered.
I just didn't hear, Judge, I'm sorry.
All right.
If it was, that's fine.
I did.
Okay. Your Honor, I'm going to move on to Exhibit 168. Oh, sorry. Is there anything additional that relating to your digital forensic analysis on 167 that you can explain to the ladies and gentlemen of the jury?
There is, I mean, the timing to me was significant on this particular artifact, but we'd have to point it out, go back to the slide prior,
Okay.
if
Your Honor,
that's possible.
If I may, I'm going to go back to this slide prior.
I know.
Thank you, Janet Murphy. You're like, wait for it.
Your Honor, can we publish that to the ladies and gentlemen of the jury?
Judge, I don't believe it's been admitted.
Excuse me?
I don't believe it's been admitted.
I thought this was the one prior.
It is.
No, that's
He did.
166.
Oh, sorry.
The wrong way, I think.
My big fingers.
No, you had it. No, going backwards, sorry. This one. No, forward one.
Yeah, you go forward one.
I'm pressing too hard.
All right, stop.
Okay, sorry. You were saying to the ladies and gentlemen of the jury.
They know.
Is this one in?
Got a hot mic going on here, hey? I can hear things. Okay, I'm just like, oh my word, what are we hearing? Rini, oh my goodness, thank you so much for your $50 sticker. I really appreciate that so much. Thank you.
166 is not in evidence.
Oh, Your Honor, move it in as,
166.
It's definitely going in the no ad fund. We don't have ads every 6 minutes over here, you know?
Objection.
Okay, there we go. Now they can go back.
okay, now we have context in terms of what you're saying. I apologize. Please explain for the ladies and gentlemen of the jury the significance of this, and then hopefully I'll move forward to the other one so you can talk about that as well.
Right. So this was, again, from Ms. Banfield's laptop, the Lenovo laptop, and this is an Innova.org website, a VPN, so that's a remote access to the Innova website where she worked, and this was on the evening of the 20th at 11:07, and this ties into what we were talking about earlier, the sequencing and the window. So
I'm going to listen now, but now you're adding a VPN in the mix for when Christine's using her laptop? Wow.
the time of this particular access was 11:07 and 49 seconds. I know I've been rounding up and down and saying 11:07, 11:08, but this one's important to go granular. So we have this one at 11:07 and 49 seconds, and now if you could, sorry, jump to the next one. So this activity, which is a login to the suspect email account, was 23 seconds later, 24.
And this is it identified as 167?
It's in evidence.
Yes.
167.
I just wanted to say for the record.
Okay.
Yeah, so 24 seconds later, so that's the window we're talking about here. For me as an investigator with the facts consistent with this case, we've gone from a activity on the laptop that is unique to one person. In this case, to my understanding.
Can't say that. Can't say that. Objection, speculation. Munira Sultana, thank you so much for your $3 sticker. Look at the sticker. That's so cute. Oh my word. You can't say person, device. Now you're adding signal, Telegram, VPNs, virtual private networks. Really? Look, I'm looking straight at Brendan Banfield then. Still. I'm looking at him, shady guy. No, it doesn't mean all those things are shady. It's the combination of those things, the context, the time frame, what Juliana said, what the detective said on the stand when examined directly by the defense. All of that, right? Anyway, carry on.
Objection calls for speculation.
All right, I'll sustain.
Can you explain it in a different way?
We've gone from unrelated activity, related activity on the laptop unrelated to the scheme, 24 seconds later to something central to the scheme. So we've gone from an ANOVA website to the suspect Gmail account in a 24-second window.
And just
That's
so
this
we're
guy.
clear, the Nova website was, what device was that on?
Ms. Banfield's laptop.
Okay. Your Honor, I'm going to move to the next slide. This will be Defense Exhibit 168?
Yes.
Okay, thank you. Sir, what is this artifact?
This is a login or usage of the Telegram app on Ms. Banfield's laptop computer.
Okay. And is there anything significant about the start time and end time, I guess?
The start time is of most significance here at this stage of our chronology. It's at 11:09 and 12 seconds p.m.
Your Honor, I move that in.
Any objection?
No, thank you.
168.
I apologize. Mr. Lidsky, can you explain that to the ladies and gentlemen of the jury to give them context?
Sure. This is the Telegram app in use on Ms. Banfield's laptop at on 2/20/23 at 11:09 and 12 seconds p.m. So now 59 seconds after the suspect Gmail account was in use, also from a Windows device at the residence.
You see this, living story worlds. It's like this is getting into the weeds of things, which I don't think is creating reasonable doubt, not for me. Maybe it could for some, I don't know. But if you just think about, okay, what is the defense's theory? Who stabbed Christine? And why did Juliana then wait in the cul-de-sac? Why did she not just go to the damn zoo? What do you mean? You saw an intruder and then what? And then you went into the basement with a child? None of it makes sense. They failed so badly, actually, at their little plan, that it's difficult to even try to come up with a different way this could have gone. Because Juliana and Brendan Banfield involved themselves that day. And even this changing of the schedule and him hanging around McDonald's where normally he'd be at work at 7:30 every day. Now suddenly he's hanging around, going to work a bit later. He's having breakfast at McDonald's. Why? Buying new phones, going to target practice, buying a gun that she has in her pocket but she's tiptoeing to the safe. Staging the scene. I mean, the cast off on his jeans. So much, right? So Living Story World says, so you want us to believe that Christine catfished the other victim to do what? Or just lured in there or connected with him or whatever, right? Okay, if she really was inviting him over for assumed adult activities, then who stabbed her and why? And why does Juliana then say that we saw an intruder and then I called Brendan and then he came over. Then we went to the basement, we left the little girl there. It didn't even lock the basement door. He went upstairs, I went upstairs. Why did you go upstairs? An au pair would never do that. You'd be then in the basement. You wouldn't even be in the basement with the child. You'd be running to the neighbors, or you'd be in the car calling the cops. You'd call 911, not your boyfriend. And then, and by the way, they're on lunch break now, so we're just a few minutes behind, and then we're going to read some letters, right, to pass the time. Anyway, and so the thing is, why is Juliana, this is where she's messed up so many times. One being calling 911 too early. Two, saying that, and then we got in the room, and then Joseph Ryan was like over Christine. And then Christine said, Juliana called 911 and said, Brendan, he's got a knife. And then Brendan shot him immediately. Oh, well, if Brendan shot him immediately, then who stabbed her? And are you implying that Joseph Ryan arrived and then just started stabbing someone in the neck randomly? Why? Why would he do that? That's not how that works. It's not how that works. You know what I mean? Like, to have a month of conversations and for him to even stop at the Walmart on the way, Joseph Ryan, and be all excited for this sexual experience. Why would you just go into someone's house and then just start stabbing them? I mean, it just doesn't make sense. Their story makes no sense. On paper, I think Brendan Banfield, he even thought academically it makes so much sense, but it really doesn't. It really makes no sense when you think about it. So, and this again, you can't keep saying Brendan did this and Christine did that and all of this. The device did it. And the more we're seeing about the devices, VPNs, Signal app, Telegram app, FetLife account with a different Gmail, all of that, the accounts not being in use when Brendan and the au pair are traveling around, all of that points directly to Brendan and Juliana.
Here, I'm going to move to the next slide. Your Honor, may you just consult with counsel?
Right.
Is this the one that you guys have in? Are you asking if we even need to have it in here? Would you tell your members what we have in so far? But did we put the whole thing in? Yeah, we put the whole thing in. We put the whole thing in, so.
You're going to have to use all your brain cells, Brendan Banfield, to try to work your way around this one. He is a slithery snake, in my opinion, so he's going to try. Because the defense attorney said he's going to get on
Your Honor, I
the
move
stand.
this exhibit in as Exhibit 169.
We don't know if it's today or not. We hope it's today. As the day goes on and they break for lunch, he's still going to have another expert as well. It's not finished with this guy. I don't see it. I see him getting on the stand next week when they come back, which will disappoint the judge. She's hoping for closing arguments on Thursday, okay? Because remember, there's no court on Friday. Maybe she'll ask the jury to come in next week, Thursday and Friday. Anyway, let's continue.
Any objection?
Just confirming with counsel that this is extracted from our previously
Your
admitted
previous
exhibit of all of
Okay.
the messages. No
Prior to
objection.
169 evidence.
Thank you. Sir, what is this?
These are the telegram messages between the account purported to be used by Ms. Banfield and Mr. Ryan.
And does that coincide with what we previously saw?
Yeah, these are just a subsection of the messages exchanged on these two accounts. This relates to the time period that we're reviewing currently. So this is February 20th, 23, beginning, the first blue bubble on the left is at 11:17 p.m., and then 11:18 p.m. for the green, and then later at 11:18 p.m. for the next blue.
Your Honor, I'm going to move on to the next slide.
Even Vicky, you got me thinking now. You said Christine did it to herself and Joe, right? All that victim blaming going on here, right? With this defense, what is their theory? They never even concrete of what their theory is. But how about Brendan, the hero? He's going in and he's like, oh my goodness, there's someone hovering over my wife. And she's like, Brendan, he has a knife. Okay. And then Brendan shoots Joseph Ryan in the head. And Juliana and Brendan think, okay, cool, okay, we're done with that. Now we're going to, I don't know what, all the other stuff happens. But if it was an intruder and you have now disarmed the intruder, you've shot him in the head. If he is still moving, why do you have to shoot him in the chest? Please tell me that. Why was he shot in the head and the chest? What's that all about? You could just call 911 like you did the first time, but it was too early for you two idiots, right? So you waited 11 minutes. What happened in those 11 minutes? According to the state, Christine was stabbed and the scene was staged and Joseph Ryan was shot the second time. Why? Kathy Luna said, hubby asked how's court boring? Then why stay? Because I'm a grizzly. Oh, he asked how's court. You say boring, then why stay? Because I'm a grizzly. Thank you so much, Kathy Luna. I mean, it could be frustrating. It's not that boring, but also sometimes we do go through a lot of boring days, boring parts. Why? Because I know we all want to see justice for Christine and for Joseph, right? And we want to show their families that we've got their backs and that they can feel safe to talk here with us. Because I'm sure they're watching every second of this as well, right? Yeah, Kathleen said because he was writhing. I mean, if it's like, oh, there's an intruder in the house, we don't know who this is. Okay, you already shot him once in the head. Why do you have to shoot him again? And why does she have to shoot him the second time with a different gun that you bought after going to target practice? They're so stupid. Oh my word. If I did closing arguments, it'll be so snarky. I think the jury might like it, actually.
I believe that'll be identified as Exhibit 170.
Okay.
Sir, do you see that on your screen?
I do.
And, excuse me, what's the significance of this item?
These are FetLife messages from the night of February 20th, 2023.
And Your Honor, I move these in as Defense Exhibit 170.
Any objection?
Again, same judge, I believe we've got the entire document in already.
All right, 170.
Now, sir, can you explain to the ladies and gentlemen of the jury what it is as a digital forensic examiner you're looking at in the context of your investigation of February 20th?
Sure. Well, again, on this particular date, we have some key events. On this particular, at this particular time, we've got key device usage or potential attribution and location information for the three people central to the investigation at this point in time. That's Ms. Banfield, Ms. Magalhaes, and Mr. Banfield. This is a subset of the FetLife records that we've been talking about. This is particularly for this evening at this point in time, and these are only the outgoing messages from the account purported to be used by Ms. Banfield. So these, if the messages don't make sense, it's because you're not seeing the entire conversation here. We're just looking at the outbound responses from the account in question relative to this discussion.
And then
Okay, we'll look at that now. Anna Carolina, thank you for your sticker. Crystal Anderson said also, wouldn't you make sure it's not a friend visiting? Why go in with guns? Shaking my head because they set it up. Even that, how do you know it's not someone, like how would you be like, oh my goodness, there's a car I don't recognize in the driveway of my boss's house. He's gone into the house. Quickly call Brendan and shoot him. Why? Why would you do that? Why would you leave the child in the basement? Yeah, exactly. It could be a painter. It could be someone for the windows. It could be anyone. It could literally be anyone. And they're going in there with guns blazing, literally. Wow. Former 50 Girly, thank you so much for your sticker.
name at the top there, what's the significance of that?
So one of the messages this evening was about starting, and this is in the larger, for what I analyzed in the larger FetLife communication, we saw where Telegram was
Hi, don't scroll too far now. Do you have Telegram? You can add me there, Anastasia 920. See if we can arrange something. Give me some examples of what you want me to do. I don't have them as it isn't something I do with my husband. I really prefer to stay private and low key.
installed in a prior deck, I think on the 19th. Now we're seeing where we start to transition from FetLife to Telegram by the person using this account.
Mr. Carroll, is this a good time to take a break then?
Yes.
All right, let's go ahead and take our lunch break at this time, ladies and gentlemen. Again, do not discuss the case with anybody and don't do any outside research.
Noni SA said, please let me be in court when they do the closing arguments. Well, we're all going to watch it together, whenever that may be. It may take a long time. Weeks, months, years. Go have your lunchy, baby boy, and come back and get on the stand, please, for goodness sake. He's probably not going to.
Sir, since you're still testifying, do not discuss the case with anybody to include the defense team.
He's going to get on the stand, according to his defense attorney. We just don't know if it's going to be today. Also, Just a Crazy Jen said, the same intruder that enters under the cloak of daylight and parks in the driveway. Oh my word, these people, this story is so dumb. If the jury or anyone following the case has common sense, it just, no. The defense doesn't even have a theory. They must tell us their theory in closing arguments because their opening statements, that was vague and quite a mess. Like, what do you think happened then? Right? Yeah. Stefan's like, a friend in a new car, for example? Yeah. But they're like, oh, wait, we gotta hang around. We gotta pretend we're going to the zoo. You gotta hang around at McDonald's. Okay, come here. Let's go in with the guns we bought recently. Well, him with his work gun and her with one that he bought for her after taking her to target practice, to the shooting range. What the hell? Okay, anyway.
I'll come back at 2:05 then?
Thank you.
Yes, thank you.
2:05, okay. So what I'm going to do is take off the banner because that's not who's here now. We'll see him back on the stand after lunch. Gonna refresh the feed, okay, so we can monitor it. The time right now is 1:26, so let's make sure court on lunch until, they said 2:05, right? 2:05 p.m. Okay. Eastern time. And now it's letter time, everyone. If you missed the lunchtime yesterday, maybe you want to check it out after because we read the first 12 letters out of 70 that Juliana wrote to Brendan from jail. And one of the more there's 2 points that I think were quite interesting. One being that she continuously wrote to who she calls her mother-in-law, Brendan's mother as well, and that Brendan's mother was paying for her attorneys, and also that she told Brendan that the state showed her that they said, Juliana, you're not the only one in his life. And they showed her pictures and messages that he had with other women. So I thought that was quite interesting as well. Okay, so are you ready to read some letters, everybody, for our lunch break? You can open your lunch boxes. You may indeed. Okay, let me get them. So while I get them, you can open your lunch boxes. Let's go here. So we got to 12, right? Okay, so I'm going to open on this side. Letter 13, 14. Did you do it? Can you open it? Thank you so much. Okay, 15. Stop it, Adobe. Stop being fancy. Just open the letters. Okay, thank you. You get to see how I shout at my computer. Hey. Let's open up to 22 for now. And then we shall see from there where we go. Okay, court on lunch. We've got that. I think we finished number 12, right? Anyone? Documents. There we go. And let's take our frame away. Okay, closing snarkuments. I like that. Yeah, let's do it. We've got some closing snarkuments. That's a good one. Thank you, Indy. I really, really appreciate it. Okay, so now we go like this. Also, I know a lot of places are being hit by the snowstorm in the USA. Please make sure you stay safe, that you stay warm. I hope you guys will be okay. And of course, let's hear what the judge says by the end of today. Like, what is the plan? Because she said they might come back by Thursday. But I do wonder, like, what if it's Tuesday or Wednesday? How do we know? Don't worry. Whenever they're live, we're going to be live. You will not miss a thing, okay? Thank you so much to Grizzly Cat for obtaining these exhibits for us, these documents. You can buy her a treat for Grizzly Cat. I just want to type it in chat for you. There on her link if you want to. All right, so let's go from letter number 12 or so. And it says, Friday, April 12th, 2024. Now remember, the crime happened when? February 24th of 2023. Juliana was arrested in October of 2023. Think about the time between February and October that she had with Brendan Banfield. You know, even the jury thinking about, whoa, so you can look at the behavior before, target practice, you know, going to the shooting range, buying her a Glock, the affair itself, the alleged plotting and planning on FetLife, the trips to New York and other places, all of that. You could think of all of that. And then you can think of the crime and then what happened after. And the after also Speaks volumes, hey? With Juliana moving into the master bedroom where 2 people died. And on the first, within a week, within the first few days of the crime happening, the little girl, somebody overhearing, that victim advocate, right? Overhearing the little girl saying to Juliana, so are you my mommy now? And Juliana said, yes. Who does that? Say, are you going to marry my dad? She's like, I wish. Oh, wow. So, just the timeline to remind you. February 24th, 2023, crime happened. October 2023, Juliana arrested. Then she starts writing these letters, okay, to Brendan Banfield because he's out and about, okay? He's moving on to the next one. He's living his life. I don't know why he wasn't an IRS agent anymore because she said that he was driving people. He became kind of like a taxi driver, an Uber driver. I don't know. Anyway, so I don't know if he was transferred laterally. It sounds like not laterally, transferred out of the department. So she wrote him letters for 11 months or so until he was arrested in September of 2024. And then in October of 2024, she accepted the plea deal. She was offered one in Feb. She said, no, thank you. And that would have been a misdemeanor. She said, nope. She still wrote letters to her man. And then when he was arrested, she flipped and she took the plea deal and testified against him, as we are here at this trial. Okay, Friday, April 12th of 2024. Yeah, see? Dear Brendan, I got your letters today and they were not what I was expecting. Oh, so I want to see his letters too. First, I understood why I had the feeling like something was off and asked you before if you were keeping something from me. Now I know. I want to first apologize for being so hard on you this whole time, for making you feel conflicted about sharing those things with me, because I said I did not want to know. After I read your letters, I felt bad because of everything you've been going through, and I didn't know, and I'm not there for you. It was hard because it made me realize how selfish and stubborn I can be. It's not that I don't believe you are struggling or sad or depressed. Deep down, I know you are going through a lot. I feel bad because of what I'm going through. This hell blinds me about what other people are feeling. Okay. But I know it's true. When I hear that you, your mom, my mom, and everyone else says they feel bad for me and they are afraid, I think to myself, nobody's more afraid and sad or upset than me. I'm the one facing life in prison. Even though we are confident and positive that we have a strong case, we don't know what's going to happen. I can be effed up forever. We'll be up to 12 people to decide. Well, Juliana, look at you. Now it's up to 12 people to decide on his fate. However, I'm not writing to talk about me right now. I'm so sorry you're taking medicine for depression. I hope it doesn't make you numb or any bad effects. I chose not to take mine anymore. I didn't like how it made me feel. And I think I deserve to feel all this, a way to torture myself. And I really hope whenever this is over, you won't need that anymore. I want you to feel good again. And I will be there for you and with you, doing my best to help you. I blame myself. This is a longer one. This is 4 pages. Now, let me also quickly, put a public record thing up here because it is public record. These are trial exhibits that were released by the court, okay? So, just so you know. We might even need a trigger warning up for mental health because she does sometimes discuss her mental health, his mental health, things like that, right? Okay, so it says, I blame myself for you being in the situation. Oh, really? Okay, maybe that because I was so hard on you and made you feel bad. Maybe the way I talk to you, many things, or I just make it worse. I'm so sorry, babe, I really am. I feel you when you said you can't express how you're feeling without crying and having a breakdown. Oh my, baby boy. I go through the same. I'm so sorry if I'm blind that I can't see your struggles. Know that I'm okay with you doing Uber. That's his Uber, right? He became an Uber driver. Oh, after the crime. The IRS was like, get your ass out of here, baby boy. This is looking bad for us. Again, sorry that I made it hard for you. And to even do that. Sorry that you've been waking up so early to go to work and then get V ready for school, talking to me during the day, working part-time, and all that. V is the daughter, right? Grizzly Cat redacted her name wherever she saw it. So thank you, Grizzly Cat, for doing that. I just glanced and saw this comment. Susie Will says, gee, I hope this trial does not put you off showing trials. I've watched a lot with you. Yeah. Have you met me? Like, I'm a stamina queen. Okay, I've been through a lot. This is nothing. This is tame. I will always be covering trials. Don't worry. This is our 25th one. Let's watch 250 more or 2,550 more. How about it? You better subscribe, okay? Because you don't want to miss out. We're going to be watching more trials and covering lots of cases together. Okay, then get me ready for school, talking to me during the day, working part-time and all that. I hope you know I'm very grateful and appreciate you, just like everything you've been doing, things I know and things I'm not aware of. Okay, I know you struggle. I know you're trying so hard, and I'm sorry if sometimes I make you feel like you don't do enough or that I don't recognize. I know you are sacrificing things for me and for us too. You are a genuine person, caring, loving, affectionate, responsible. I know you are committed to me, to us. I want you to know that if I don't get life or go to prison, I want to be there with you and for you, and we'll make it through together. I'll make sure you'll be yourself again, happy. Oh dear, we don't want to know how she plans to do that, right? We'll do it together, I promise you. I owe you a lot, and I love you more than anything to just give up on you or us. Thank you for loving me and being committed to me, for not giving up even when I give you reason. I'm sorry I take out on you my insecurities. I know they might be nonsense to you, but for me they're not. They're a gut feel. You know he's a cheater. He also cheated on his wife with you, and then also allegedly planned to murder his wife for you. So yeah, you're dealing with a major cheater. So you have every right to feel insecure, but also, yeah, you were part of it. Let me just have a sip of water quick. Okay, hold on one second. And yes, I mute it when I drink water. Pleasure. Okay. Also, I know, okay, wait, she said, I explained to you the reasons before. I just can't ask you to sit around and wait for me, not living or having fun, because I feel insecure of things happening, or insecure of how you look at other people or what you do, because you might be sex starved. Please let him be sex starved. Oh my word. Brendan. Well, now he's in jail. He's been in jail since he was arrested. Oh my. I shouldn't be worried about none of that, but I am. But you're right. You didn't give me any reason to break up with you. My reaction to the situation is all wrong, and I don't want to be more hurt, so I tend to push people away to avoid things. I don't want to feel jealous or upset if you're doing something and take it out on you, making you feel bad. You don't deserve this. So if we are going to be together, I want to make sure to get over these issues, to work on them so I don't make you unhappy. I think from here I can't do anything and get much better, because it's about so many things for me not being there. Imagine that, a long distance relationship from jail. It's not going to work out. And don't worry, it'll be the same way, because he's probably going to prison for a very long time. I love you with all my heart, and I will always love you. I do want to be with you and our dreams to come true. Have our family and things we talked about. Again, he had a family. He had a wife and a daughter. The daughter was only 4. You au pair. You had one job. You failed miserably. Okay. I never felt so sure of anything in my life as I do when it's about you and us. I never felt so sure about someone. You mean everything to me. I choose you every day. I choose to give you all I am. All myself to you. My love, my attention, my care, my desire, my affection, and loving you in a way I'd never love anybody else. In a way everybody wants to be loved. I don't think so. Nobody. Bonnie and Clyde. Yeah, okay. I am 100% committed to you until they offer me the next plea deal. Until your ass gets arrested, then you're out. And I'm proud of you, of holding your hands, of showing our love. After all this, I want us to go to sleep together and wake up together every day. I want to be your medicine to cure you from depression and anxiety, and that's toxic in itself. Lady, you cannot be somebody's medicine, okay? Each person is independent and needs to be independently fulfilled and happy by themselves without them seeing you as a fix. She says, I want to be your medicine. I know she's young, okay? I know she's young. I want to be your medicine to cure you from depression and anxiety. If so, you don't know her age. She was 22 at the time. She's 25 now. So at this point, 2026, so she was like, what, 23? Okay. I want us to, wait, just like you'll be mine. I want us to cuddle, go to sleep peacefully in your arms. Peacefully? After committing alleged double homicide. Wow. In the same room. Wow. In your arms, feeling your love and warmth, and 100% sure when I wake up, you'll be there. It's been 6 months, but nights are still tough without you. Cold, sad, lonely, and a lot of cry. I keep toilet paper on my bed, lol. So did Stefan Stones. I would never get, that was his pillow, right? I would never get used to anything without you, no matter for how long we've been apart. Everything I think about, I want to do, you are there included. Because I can't picture my life without you. I have everything I need in one person, you. Again, that's very, very toxic. I'm incredibility, sure. I am incredibly and 100% in love with you and attracted to you at the same time. Okay, I think he's the type of guy that needs to be reminded that somebody's attracted to him, because she keeps saying that, like, you're handsome, you're attractive. Okay. Man, so attracted to you at the same time. I hope I make it very clear every day. It's always been this way. You didn't even know, but I was all yours. You had me even before you knew it. Okay, premeditation, gold digging, freaking au pair. There's a catfish for you. I'm an au pair. I really care about children. No, you don't. You're trying to get a husband in the worst kind of way. You're trying to take someone else's husband and take them out at the same time. Wow. Even before you knew it, I'm here for you. And I want to always be. I want to call you my husband and tell everyone that is my kid's daddy and my handsome husband. I'll be very happy about that. I'm sure you will. I'm sure the hell you will. Never gonna happen. Thank you for letting me into your life. For letting me love you. I'm very lucky to have you, and I'll take care of you. And I hope these 3 months fly so I can be back in your arms. What? Why does she think she's getting out? You took it says, they took everything from me. They made me doubt myself, but there was never a day where I felt different about you. Okay, we've got to zoom out now again. Damn it, so we could see everything. I felt different about you, even wanting to push you away. They never touched my feelings for you. Truly and forever yours, Juliana Perez, Magales. J. B. U. Okay. Lots of little hearts. 1, 2, 3, 4, 5 hearts. Star. I also sent the cup cover. Gamble made. With a heart made of paper. Tried. Lol. And the other thing. Game. I forgot the name. And I couldn't be creative enough. Lol. Martal says gold digging freaking au pair. That is what she was. I mean, it sounds very, very premeditated, right? Dr. Wench said Juliana revealing her fetish for diapered adult babies. Now, there's a fetish that we might be on to. What was really going on here? Oh my word. That is how baby boy looks. He looks like he's one of those that's going to be in the adult diapers, isn't he? With the pacifier. She was trying to be his au pair. Oh, no. Stefan's like, hard. Yeah. Okay, so that's one of them. Let's go to the next one. Let's check the time. Ooh, 1:43. They're coming back at 2:05. Okay. So this says Juliana and Brendan sitting in a tree. Oh, sorry, not that song. Juliana and Brendan at the top here. Back the blue. Thank you for being here for 31 months. You said silent but proud Grizzly here. Thank you so much. April 14th, 2024. When was this one? Wait, this one was what? April what? 12th. Okay, April 14th of 2024. She said, love you. I know what I had said in the last letter. I know how I feel about you, about us. I'm really grateful for everything you've been doing for me, for us. Also, I know maybe you don't share all your struggles. Neither do I. I don't want to be vulnerable with you. I don't want to tell you all the times I cry during the day or every night to go to sleep. I don't want to share the times even the deputies call me in the hall to talk because they hear me crying, or because I just stay in my room even when we're not in lock-in and gamble. Like other roommates come to me asking, Juliana, are you okay? I don't want to share when we have video chat, and I try hard to keep myself stable at that moment because I don't want to cry in front of you and showing you how upset or sad I am for being here or for little things that happen that make my day worse and more anxiety. I don't want to tell you over and over again how I feel, my insecurities about you, my thoughts and insecurities for being here longer, and things about to happen on the outside, for you anyway, because I'm sure you know enough. And though I know things you told me you were keeping from me, I don't feel really confident or that I'm ready to just sit here and trust you with my eyes closed. You see, When the state showed her, you're not the only one in his life, Juliana. He's talking to other women, you see. Whether he was or not, if they just implied it, even planted a seed, oh, did that seed blossom. It really bugged her from that moment on, hey? You could see it in the letters. It's quite something. And then eventually she's like, you know what? No. Give me that plea deal. Okay. I mean, one could say good for you, but you can't in the scenario, because I wish she could be LWOPed herself. Okay. I don't feel confident. I'm ready to sit here and trust you with my eyes closed. I really wish I did about many things. Not only specifically the act of cheating, like physical touch. You mean like what he did with you? Cheating, as far as I'm concerned, goes beyond just kissing someone else. You mean like murder? However, I remember your letters and things you've said, and they were very sweet. But I still think the best I can do, and should do, if I don't get convicted, is going back to Brazil. That's her slowly raising that middle finger to him. Even though I don't want to have even though I do want to have a life with you and dream about so many things, that is not all. My family, everyone is there for me, waiting to be with me again, whenever this is over. And then on top, she gaslights and says, truly and forever, your heart, while saying this other stuff. In different handwriting. Just truly and forever. Love you, but also don't trust you at all. And also, you know what, screw you, I want to go back to Brazil. My family is more important to me than you, bro. Cheating, lying scumbag. Okay, anyway. She said, I owe them a lot. After so long, after everything that happened, I should be with them. That is not fair to them what happened. It's not fair that to pull that trigger, I didn't consider them. How about considering the guy who you shot? She said, that is not fair. Yeah, it's not fair you took his life. It shouldn't have happened. She said it shouldn't have never happened. That's a double negative, man. Like I always say, I don't regret you at all or everything we have done. Oh, really? And live together. I don't regret you at all, everything we've done. Like a bit of double homicide, and allegedly. And live together. I really just hope I have the chance to be with them again. Back home, I really do. I can't stand the thought of not being with them anymore for my own mistake. If I understand right, you said something about us moving, if that's what I want or something. First, that's not just what I want, also what I need. What my family needs me to do for them, to show up. Then is it not as easy as we think to move when you have kids? It's way more work, not simple. Easier said than done, even if you have the best intention. Even worse if we're talking about country. I do understand you saying you're willing, etc., but that's not all, though I really appreciate it. I won't ask you to live in Brazil with me, just because I know you love me and I love you. There are things I can't ask you or expect you to do or be. I can't be selfish. I mean, it says the most selfish one ever, right? Now, Jacqueline says Brendan's mother was with them on the New York trip and Christine was still alive then. She knew about the affair and that is already disgusting. I mean, I don't know if she knew about it. I think she trusted this au pair so much. Like she trusted the other one. The other one seemed really lovely, right? There was one before Juliana, you know what I mean? And she's all over Christine's Instagram page, which is still up. Okay. So this is kind of funny as well, because she's like, yeah, no, you don't come home with me. I can't show you off to my family. Okay. You stay in America, buddy. When I go to Brazil, it's just me going. Hasina, thank you for spoiling the mods with coffees. Like you could feel her distancing herself slowly but surely, right? Me3 says, dramatic reading lunches with Grizzly is the best time of day. Oh, thank you so much. Okay, so this, Brendan is her telling you, I'm not that into you. I'll come to the States. I'll be your au pair, and then we can do whatever to be together, and I can take over your house. Okay, you can marry me there, but you don't come to Brazil with me. I'm going to show you to my mom. Oh, okay. So she said, we want and need each other, but my family also needs me. I would never forgive myself if I couldn't see them after all this. Maybe you also feel scared of living a single dad life. I don't think he's scared of that at all. Okay, he was on to the next one. But I know it wouldn't be for so long until you find someone. Okay, at least she knows. Besides, your mom is always there for you and V. Like I said, you have it all. All you need, even if you don't think so. I wish you understood how hard all this is for me, where you need to choose. It hurts so much. Should I stay or should I go? Anyone got that song in their head now? But yeah, that is the realization that I do need to go back to Brazil. They need me. Then she says, love you, handsome, again in other handwriting. This is the gaslighting handwriting of Juliana, in my opinion. I don't want to make you choose life here or in Brazil. This is huge. I'll tell you, this is and will be very hard on me because I only have you. So intense. I feel so much for you that it's hard to imagine you feel the same. For me, you would always come first because I only have you, but I will never come first. Okay. Maybe I'm just not the right person or match for you, despite how great we are together, how we all feel for each other. Maybe we're like Amy and Jacob. She just wasn't right for him, didn't fit in what he needed. We'll figure it out. I just want to make sure my feelings or thoughts or struggles to choose to do what is right. I miss them so much, even if I don't really talk to you about it. I miss them every single day and feel guilty for making them go through this, afraid of losing them while I live my life here, for knowing they need me and I'm not there by my own choice. I love you more than anything, babe, and wish things were easier. I'll never stop loving you, ever. This is a breakup letter, isn't it? Okay, and never regret you. Understood? Oh, we go to past tense now. We've been through a lot and we know everyone is not everyone is like us. Yeah, you're criminals. Damn. We are unique to each other. And nothing will change that. I'll love you until my very last breath, Brendan Robert Banfield. She says his whole name like that. Oh man, truly and forever yours, Juliana, 826. Okay. This one, let's go like this. It's written April 19th of 2024. Okay. She says, and I'm checking the time. Ooh, 1:51 p.m. They're coming back at 5 past. Juliana and Brendan Hart, 826 Hart. What is this date? What is that date? The 26th of August, hey? I don't know. April 19th of 2024. We don't actually want to know, do we? What's going on here? Okay. Dear Brendan, now it's time for me to start getting ready for my trial. I just don't know if I will ever be. Ryan, her attorney, and I are talking, and he said I can decide later if I want to testify or not after we practice questions, evidence. Rewatch my interview with my statement. He said, one of the instructions from the judge to the jury is that they can't assume or making any decision if I choose to not testify, because there can be many reasons. It doesn't mean I'm lying or hiding anything. So I still don't know. She said, I still don't know. We shouldn't discuss on the phone whether or not you will testify or if I will, because they don't know yet. And if they know it beforehand, they'll already make trap for us with questions, theory, etc. If you're innocent, can they trap you like that? I guess some will say yes, but I mean, she sounds worried. She's like, we got to practice this, okay? She said, the prosecutor keeps telling Ryan that Juliana is not being honest with you. She knows more than she's telling you. Like what? Question mark, frown face. I told him that I don't even know who we can call as witness about the person I am, etc. Since I don't have any friends here, he might try Cannondov, but I doubt she will come. Or Beatrice. That in my last bond hearing, the prosecutor said she contacted them after what happened. I don't know about that. Then it says, he was asking a few questions that the prosecutor might ask about our affair, like if when we stayed at the hotel in New York or any other place, you paid with cash or card. I do remember using your card. About our dates in public, I said yes, going to the bar, etc. If we're ever afraid of getting caught, if I was dating other people at the same time, and yes, I was. Okay. Even how many people I think I had sex with, and I told him about sex in first dates, like the doctor or something. Sorry, what? What are you saying, ma'am? If I was dating other people at the same time, and yes, I was, even how many people I think I had sex with, and I told him about sex in first dates, like the doctor or something, because you know about it. Okay, who's the damn cheater now? Wow. He's trying to prove that we weren't a secret, not at least from my part, since I wasn't the married one. So my friends knew, but not yours, of course. On top, she writes, Juliana and Brendan Hart, truly and forever yours. That's the gaslighting. He asked how we got together and moved into your bedroom after what happened. We talked about it, and it wasn't hard since we had a type of relationship before. Okay. And we enjoyed each other. And I was going to stay in America no matter what happened before my birthday. Also that your mom advised us. That wouldn't look good after what happened, but was understanding and supportive. Okay. Amy Bitzer said, gee, you are the best. Appreciate all you do. Y'all hit that like button. Oh, thank you so much. Right. So that was an interesting little sentence. He asked how we got together and moved into your bedroom after what happened. We talked about it. It wasn't hard since we had a type of... It wasn't? After 2 people lost their lives in there. No problem, because you enjoyed each other. That's what she reduces that to. My word. Okay. Your mom advised it wouldn't look good after what happened, but was understanding and supportive. Why? He asked if you ever said you loved me. And I was honest about that too. But you never told me you would get divorced to be with me. I never wanted anything serious like family, relationship, kids. I had just broken up with Bruno for that reason. Ma'am? He literally... Oh, no, not literally. He allegedly killed his wife to be with you? He didn't want divorce. He said it's too expensive and he doesn't want to lose custody of his daughter. So that's what you said, right? But here you're saying you never told me you would get divorced to be with me. Yeah, because divorce wasn't an option for him. Murder was, allegedly. I never wanted anything serious like family, relationships, kids. You literally said to the little girl, yes, I'm your mommy now. And you said in all the other letters you want kids with him. Wow. Simply Lolly said, just looked it up and the fair started in August, so the 826 was the day they well started to, you know. I know, right? But I remember that, them saying that. But then her post to social media talk about being so in love and her in the bathtub and all that. Before that. So I don't know. That there must be something else significant on that day, hey. We don't want to know. Okay, so it says, he thinks a few questions the prosecutor might have for you, like, why did you let Juliana follow you up the stairs? Or about your guns being loaded in the house. Well, yeah, stuff like that. Ryan said, Ryan is her attorney. Ryan said one reporter contacted him because she wants to make an article about how and who I am as a person, contacting my friends in Brazil, etc. I'm still thinking if it would be good or not. I don't want more attention from everyone about my case. Well, you got it. Southern Caterpie said, we don't talk about Bruno. No. How dare she? Thank you for your sticker. It says, we are also thinking of having Juicy Mara answering questions and talking about me, but online, recorded, translated, etc. But we need to think about it. It would be good having people talking about me. And then she mentions people or someone else. Your mom said if we want to call anybody from the family would be good, but I don't think would be considered as friends. But then again, friends, I don't have any here. Ryan said with that they would try to call someone to say bad things about me. But I'm not worried because I'm sure they'll have someone or some people talking good about Joe. Okay. He said that in some cases they do mock trial. I guess that's how it's called. Where we spend some time with random 12 people and we present them the case and they tell their opinion and a specific person to pretend it's the prosecutor asking questions about the case. Oh, sign me up for that. Right? When it's people that are going to trial. I'll grill the asses. This says, you mean everything to me hard, Juliana and Brendan. Okay. It sounds a good idea, but we don't think it's necessary for this and would be very expensive. I think she means expensive, right? Like 50,000 to 100,000. I'm always trying to think about questions that the prosecutor would ask, etc., because I know and assume some of the evidences they have and how to explain then. You and John will start talking about that too, and I don't know if you will testify anyway. Ryan believes we are going to win the case. Maybe John thinks the same. Maybe other lawyers too. Maybe every defense attorney, no, I added that. Maybe other defense attorneys think that too. Don't worry, we're going to win this case. But as we know, it doesn't mean we will. Depends on how 12 people will view this case. Motive, if in fact he was incapacitated or not, about our affair, etc. However, I don't know what we'll do or how or what is going to happen. And to be honest, I'm afraid, scared. I don't know what's going to happen. Nobody knows. And I expect the worst to happen. I just want always to make sure to let you know how much I loved, past tense, and love you. And I will forever. It's good that you are creating new memories with V, having fun, etc. You don't need to worry because you'll never lose her. You will have her with you, just as it is right now. Nothing is going to change with this process. The Bensons started. No way. Yeah, except that when he gets arrested and you take a plea deal, right? Court Lurker says, I hate she says Joe like she was friends with him. Knew him personally. I know, right? That was terrible. Oh, man. True Crime Fan said the day they knocked boots for the first time, in my opinion. Probably. But maybe in a specific way. Because I think they may have been knocking boots before then. Maybe they did something very, very special that day. Okay, moving on. We don't want to know. It says, okay, Ben, nowhere. It will be good. No, it will be you and her forever. That's all you need. She means, don't you find another woman now. That's all you need. About us, you will lose me. Maybe you will lose me. She says, about us, maybe you will lose me. We'll find out in about 3 months. So it's good for you making memories without me. This said, I don't know if I've ever been good enough. I'm a little bit rusty, and I think my head is caving in. Now that's Matchbox 20, isn't it? Sometimes, I'm saying it like, I'm saying because I recognize it. Yesterday when people said the lyrics were Matchbox 20, I didn't quite recognize those because I do like Matchbox 20, but I think this is it, right? Okay, sometimes I just think to myself, like I can't believe I'm facing life in prison for someone. Then things weren't supposed to be this way, right? But people are stupid, including me, and make mistakes, act without thinking. That's all I did. Sure. If I don't get convicted, well, I don't know about us anyways. I don't know if we would be the same or something better than the relationship you had. Wow. There are so many issues, as we know. My issues, and also the thing about living here after this, when I also want to be with them, especially after this, they deserve it. I asked my mom for Bruno's phone number and other friends. She's saying she used to do my eyelashes. And Milena, we went to nursing school and graduated together. So if we decide the reporter can make an article about me, she can talk and ask them questions. If not, maybe Ryan can do something and use it in my trial somehow. Like I said, maybe you'll lose me. She's like threatening abandonment already. But at least we know you'll be okay because you have all you need, no doubt. So I'm glad you are doing things as usual with V. Things we used to do together. Now only you and her. And that's all it is. Oh, she sounds better. However, I think, she should be. Anyway, I think I just want to tell you, explain what's going on here. My conversation with Ryan, giving you a heads up. Yeah, do tell. It says, I think a lot about us. I think about you all the time, even if you don't think I do. Every little thing reminds me of you. Then I also think of my issue, insecurities. Again, I did not like that you were keeping things from me. I did not like trying to get the truth from you on the phone. Knowing something was off and you were still lying to me. Now I'm like, I don't know what is true or what is not true. Should I believe that or he is still keeping something from me? Because I still feel something's off. And though I might get upset about a few things you tell me, it'll be worse if you just keep things from me, no matter about what it is. Oh, you see, they most certainly got to you, huh? Okay. So let me just check the time quick. We'll finish this letter for sure. The time right now is 1 minute to go. Let's finish this letter. She says, I don't know if I've ever been really loved by a hand that's touched me. She said, it's not true. Should I believe? Okay, yeah, we went there. And though I might get upset about a few things you tell me, it'll be worse if you just keep things from me, no matter about what it is. I guess that is if, for now. You can keep me updated about whatever through Ryan. She's like, talk to my attorney. Okay, hope everything's okay out there. Never forget how much I love you more than anything. I miss you every single day. You mean everything to me. I love you with all my heart and always will, even when I can't, until my last breath. Love you, my handsome. Heart, heart, heart. The hearts are getting less. She said, I know you... Wait, we want to move this up a little bit. I know you're not a believer or nothing like that, but you always told me, and the Bible says the same. I hope we can live like that. I observed yet another example of something meaningless under the sun. This is the case of a man who's all alone, without a child or a brother, yet he works hard to gain as much wealth as he can. But then he asks himself, who am I working for? Why am I giving up so much pleasure now? It's all so meaningless and depressing. Two people are better off than one, for they can help each other succeed. If one person falls, the other can reach out and help. But someone who falls alone is in real trouble. Likewise, two people lying close together can keep each other warm. But how can one be warm alone? A person, you can put the electric blanket on, okay? Sorry. A person, not in jail though, sorry, you won't have that there. A person standing alone can be attacked and defeated, but two can stand back to back and conquer. Three are even better, for a triple braided cord is not easily broken. All right, Juliana, sure, if you say so. Now, let us see. Let me refresh the court feed and make sure we see the judge. Not yet, we see the seal, But they should be back now, it's 6 minutes past, right? Let's see how long this late is. Nope, they're back, damn it. Sorry about that. Let's close those letters and get this courtroom going again, shall we? They've just sat down, baby boys just sat down here.
Are you feeling bad?
No, I just,
Oh, sure you don't want to wipe it.
That's not really a hot mic. Hope you enjoyed lunch with me. If you haven't liked the video yet, do it if you like the lunchtime letters with me. The way he looks at the jury.
All right, your next question.
Thank you, Your Honor. Your Honor, the picture that's on the screen, may I just ask you what you have as that number?
I have that as 170,
Okay, that's what I have as well.
Okay.
I just want to make sure.
and it's already in evidence.
Yes.
Okay.
And now, Grizzlies, I'm going to have my stretching break. Okay, I'll be right back. I'm taking you with me. I'm here. I'm still listening and everything. I'm just not on camera. 20 squats, everyone. Do that. Someone said, we don't like live. Well, we do in some cases. This trial, I like watching it live. And when we have lunch break, why? Because we've got very interesting things to read during the lunch break. Okay, no one wants to twiddle their thumbs. But we like to read the letters during the lunch break, right? Otherwise, when else are we going to fit it in? There's so many of them. There's 70 letters. Are you ready to continue with the direct examination? Here we go. Look at the judge's face, okay? The judge's face is all of us right now. How long is this guy going to go on? I don't know, Judge. Long time.
Can it be published too?
Okay. I didn't know if you wanted to take it back to presentation mode.
Oh, sorry. I do want that. Thank you.
it's still,
You gotta click it. You wanna click it? It's not in presentation mode yet. You're on it, you just have to click it. You're there. Just.
Judge, may I use Mr. Lidsky's expertise?
Okay, sure. All right. So now we're back to 170. Okay, it's published.
Yes, thank you, Judge. Thank you. Sir, looking at the slide that's on the screen there, I think we've spoken about it, but just since we had a break, can you just explain what this slide and what the significance is relating to your digital forensic analysis?
These are 3 FetLife messages that were sent outbound from the account purporting to be Christine's, and they occurred still on February 20th in the evening. So in the window we've been discussing between 10 and midnight or 11 and midnight.
Your Honor, I'm going to move to the next slide.
170 is already in evidence. I mean, so
170 in evidence?
the 170 is in evidence.
Yes.
Okay. So what'd you ask?
Oh, 171.
171, okay.
Identify as 171.
All right.
I just said I was going to move to the
Okay.
next slide.
Gotcha. Thank you.
Sir, can you identify this slide?
Yes, I can.
Okay, and what is it?
These are additional Telegram exchanges, sort of an extension of what we looked at earlier with the green and blue chat bubbles.
Okay, and this is a portion of what has already been moved in the Commonwealth's case?
That is my understanding, yes.
Okay, and what's the significance of these messages and what specifically in those messages?
Well, so from a significance perspective, obviously it's communication between the 2 primary involved people or accounts. This evening is significant, as we discussed, because this is when Telegram really ramped up, and this is the evening of the phone call. There were the Telegram call between 2 parties, and this is an extension of the activity that we were visualizing when we started this. So it's, again, we're for me, significance is looking for, continuity or a break.
Okay. Your Honor, I'm going to move to the next slide.
172.
172. And what is this artifact and what's the significance of this in terms of your digital forensic analysis?
So this is an artifact from Christine's cell phone, her mobile device. It's again on the evening of the 20th, and it's just a continuation. This is now 11:52 p.m. I'd have to see the last slide to see where we left off in the chronology. But again, I'm always looking at multiple devices. I'm trying to get as much data about what all of the involved parties are doing on what devices all at the same time.
Your Honor, may I move to admit this to evidence in number 172?
Judge, I am going to object. I'm not sure that we have enough foundation to support the conclusion that this came from the cell phone.
All right, you can lay foundation.
Okay. Mr. Lidsky, this artifact, when you collected this artifact, what device did you get it from?
The portable case of Christine's from her cell phone.
And what, if anything, did you do in order to isolate this particular artifact?
I just did a screen grab of the artifact as it displays on my end.
Your Honor, move this in as one.
I mean, Judge, again, I would ask how he knows that this is from, what on this document tells this witness that this is from the phone?
Okay. I want to ask him that question.
What on this document tells you that it's on the phone?
I remember it. I remember doing it. Nothing here provides device attribution, but I know it from my review and analysis.
All right.
Okay.
All right, 172 in evidence.
And so, and you just mentioned something about looking back at the timeline because we just had that break. Is that necessary for you to be able to explain to the ladies and gentlemen of the jury what this is?
Well, sure.
I can't see what he's scribbling either. I'm trying to look like this guy tries to look. What you scribbling there the whole time? Do you think that he thinks if he looks at these like FetLife messages like, wow, that's what was being said, that maybe the jury would be like, oh, wow, he's taking notes of what was said. He has no idea what was going on. Okay.
And the content, as we can see here, I think would agree is, at least I assume, I take this to be unrelated to the scheme, but it is activity on a device that is occurring contemporaneous to activity related to the investigation, related to this case. So for me, this is important. If I can assign device attribution for this particular time, then I can draw inferences from that somebody is awake, that somebody is, in this particular case.
You just can't do that. It's a device that's being used. You don't know who's awake, who's sleeping, who's using it, okay?
It's researching office ideas that might give rise to pursuit of another investigative channel to see if there's other corroborating or refuting information elsewhere.
Is the slide that you were comparing to was the one immediately before?
Well, these, I believe, are chronological. So the one immediately before would be either just before it or even contemporaneous.
Okay, and is that something you want to reference?
We could look at the time. I see this one's 11:52. I didn't take note of the last message.
Your Honor,
from the
may
previous.
I move back to 171?
Yeah, you can move back.
Does that give you any indication?
It does, yes.
And this has previously been entered into evidence, Your Honor?
No.
Your Honor, move this into evidence as number 171.
Any objection?
Yes. No, Judge, this was from our
It's from your.
previously admitted. so
Okay,
no objection.
171 in evidence.
I neglected to move that in, so the jury didn't hear about that. So perhaps you could explain what you were just explaining with actually a slide in front of them.
Sure. I think I mentioned before lunch, there was a lot of activity this evening. There was Telegram. I thought FetLife as well, and now that's been confirmed. So this is a continuation of Telegram chats that were ongoing in this relevant period of time. So the beginning at 11:21 p.m. on the 20th with the first message and ending, at least for this screen, for this point in the conversation, at 11:47 p.m. on the 20th. In the lower left.
And these are in UTC time, correct?
These are in UTC time. That's just the way they were extracted from the device, which is default, so that's normal.
Okay. Sorry, go ahead.
No, go ahead.
And would that require, as you said, math?
Yeah, so we're doing a bit of math. So so even though the date reflects 2/21 at 4:45 in the morning, it's actually 2/20 at 11:45 p.m.
Thank you. Your Honor, I'm going to move to the next slide.
All right.
173, Your Honor, identify it. Sir, have you taken a look at this slide?
I have.
And do you recognize it?
I do.
And what did you retrieve this information from?
Also from Ms. Banfield's mobile device or cell phone.
And is there any significance with regard to the times on these messages?
This is just before and straddling midnight, again on the 20th, and of course, immediately into the 21st.
And, Your Honor, I'd move this in as Defense Exhibit 173.
No objection.
All right, 173 in evidence.
Explain to the ladies and gentlemen of the jury what the significance of this is in relation to your previous slides that you created.
It's a conversation between the Banfields. It's Facebook messaging initiated by Mrs. Banfield. I could.
Judge, I'm going to object. Calls for speculation. Again, we don't know who's behind the device.
I'll sustain the objection.
Okay. In the context of the devices, what can you?
Between accounts purporting to be from Mrs. Banfield to Mr. Banfield, it's a brief exchange about domestic logistics.
Okay. I'm sorry, and Your Honor, we already moved that in, correct?
Yes.
Okay. I'm going to move to the next slide.
All right.
And this would be identified as Defense Exhibit 174. Sir, do you see that exhibit?
I do.
And what, if anything, does that exhibit tell you about the investigation into the digital forensics that you've done in this case on this particular day?
This is an artifact from Mr. Banfield's laptop, her Lenovo laptop. It indicates that Telegram was started and in use between midnight and 12:42 a.m. On the morning of the 21st.
Okay, and Telegram, the three accounts that we're talking about, what are they?
There's the suspect Gmail account, the CBRN 920. There's the FetLife account, and there's the Telegram account.
Okay, and how do they link back up now that the Telegram account is involved?
Well, again, it's how they were used, that they sort of, one led to the other, which led to the other. So the way Telegram links up is it was sort of referred, like, let's move this conversation on FetLife over to Telegram. So it's an extension of what was going on in FetLife. It doesn't really stand alone to my, from what I investigated. And FetLife, of course, ties back to the Gmail account. So they're all just linked in that manner.
Your Honor, I'd move this in as Defense Exhibit 174.
Any objection?
No objection.
174?
Mr. Lidsky, the jury's going to see that now. Is there any additional explanation that you need to point out for them now that the exhibit's in front of them?
No, you might see the activity type, app use focus. That's just Windows' way of reporting which app is brought to the front when you're using a computer. So you can have multiple programs open or multiple windows open, and Windows records which one is where.
And so the duration that you're talking about, is that known based upon this artifact?
It is. So this was a 42-minute use episode of Telegram.
Your Honor, I'm going to go to the next slide, which would be Exhibit 175.
Okay.
And sir, have you seen this exhibit?
I have.
And in fact, is this data that you've compiled?
It is.
And Your Honor, I move this in as Defense Exhibit 175.
Judge, I am going to object.
Yes.
This lacks foundation. It appears all of the column headers have been removed, so I don't know what information has been filtered.
Sustain as a foundation.
Okay.
And that guy, he talks so much crap. Earlier with all the Google accounts that you can't have one device with many accounts signed in at the same time, where you can, and multiple devices, and now saying that they're linked in that manner. Really? The Gmail account, FetLife, and Telegram? They're not linked. That wasn't the right word at all. Because Telegram's an app. FedLife is browser-based. It's on a website. It's not an app. Okay. And then what else did he use? Gmail, FedLife, Telegram. Yeah. Okay. They are not linked in that manner, sir.
Sir, in compiling this exhibit, what is it that you did and where did you get it from?
This is from Mrs. Banfield's mobile device, and this is her Google Chrome, which is a web browser, Google's web browser, web activity. So site visitation, website visits between 12:09 a.m. and 12:27 a.m. on the early morning of the 21st of February.
Okay, and so Ms. Sands mentioned that she doesn't know what the columns are. Can you provide guidance as to what those columns are as to this document?
Sorry, pausing before you answer. True Crime fan said, why did they move it over to Telegram? Because it's encrypted, more private conversation. You said maybe because it's an app and easier to use from a phone versus laptop. I think just because it'll be a more private conversation, they can't then be tracked by the police. Allegedly. In some cases, they can get those. But generally, it's because it's a more private conversation compared to the website.
Sure, from left to right. It's the website visited, date, time, sort of the title of the website. Web pages actually have a title of what they are. I think visit count, how it was reached, whether it was typed or clicked on a link is what I mean by that. Whether it was native to the device or synced, and just talking about which what data point this came from at the end.
Your Honor, I move that in as Commonwealth Defense Exhibit 176.
175.
Oh, 175.
Judge, I do still have a foundation objection with regard to the date and time. I believe we're missing columns that typically appear in this view in the native software.
Date and time, foundation.
Is there any modification of date and time to this column different than what you received?
No, this is in local time. It's down to the second. That's all I can say.
I'd renew my motion.
And I'm sorry if I can clarify, it's not a modification of the data within the column, it's that there are missing columns for additional in-out activity, the additional columns of date and time of the cessation of the interaction.
Is it start time, end
Yeah.
time?
This just represents when the website was first visited, if that helps clarify.
No objection, Judge.
All right, 175 in evidence.
And sir, if you could, for the ladies and gentlemen of the jury, explain what this is.
This is from Mrs. Banfield's mobile device. This is website visitation from, as reported by Chrome, within the device. That occurred between 12:09 a.m. and 12:27 a.m. on the morning of February 21st, 2023. It's what I would call benign as to substance. I didn't see anything in here related to the case per se. It's more for awareness if there was some human using this device at that time, and these were the websites that they were browsing to.
A human.
Your Honor, I'm going to move to the next
Some
slide.
human was using it. Are you sure? Are you sure Brendan Banfield's a human?
That would be Exhibit 176. Sir, can you see that
I can.
slide?
Yes.
And what, if anything, is it showing and what's it from?
So this is from Mrs. Banfield's Windows laptop, her Lenovo laptop. And this is also a website visitation record. It's from 12:24 a.m. on the 21st. This correlates to one that was on her phone as well, identically with substance and time. And for me, that's informative.
And does this align with your pattern analysis as to her devices?
In terms
In
of
terms of time,
usage, well,
usage?
yes, this device has been in use for the entirety of this event so far since we began.
I'm
This.
sorry, I didn't ask the question properly. I think you testified before that you did a time analysis as to when she would use this device throughout the year.
And again, I'll withdraw.
That's what I was aiming for.
Yes.
You can tell the ladies and gentlemen of the jury.
With the historical pattern of life analysis that I performed on all of the devices, not just Ms. Banfield's, this would be one of those informative artifacts. It's in the window of time that I observed sustained over an extended period of months.
Your Honor, I'm going to move to the next slide, which would be 177.
All right.
Sir, can you look at the slide that's before you and tell me if you recognize it?
I do.
And where did you get this message from?
This is part of the telegram production from discovery in this investigation.
Okay, and is this a portion of the exhibit that the Commonwealth has already moved in?
It is. I should restate just for confusion. Telegram doesn't produce any records. This was obtained by Detective Miller as part of his device analysis.
Your Honor, I'd move this in as Defense Exhibit 177.
Any objection?
No objection.
177.
So if you can, once the ladies and gentlemen of the jury see it, what's the significance of this message chain in the context of the date that we're talking about?
So this is a continuation of the exchanges we saw earlier. The message on the top left, and if you recall the details of the conversations we saw earlier, there was discussion about being nervous in anticipation of a call, the voice call. So the first two messages are, just leading up to the call, and the third on the lower left reflects the call itself. It was an incoming call because this is from the perspective of Mr. Ryan's device, which was the origination of this material. So it was incoming from his perspective. And you can see the duration there is just shy of 42 minutes.
And Juliana said that Joseph Ryan said, "Oh, I don't expect you to have an accent." So she said she spoke to him on the phone. Sunny Way said, question, what ended up happening with the witness and setting up the video testimony? Oh, that's still coming. Maybe next month. We haven't gotten there yet, which tells me we're not going to get to him on the stand today, are we? I don't think so.
And all of these are UTC as stated.
So we need to do some math.
5 hours. One of them's easy.
Your Honor, I'm going to move to the next slide, which would be Defense Exhibit 178. Sir, what's the significance of this relating to your digital forensics analysis?
So this is Telegram app usage, again, from Mrs. Banfield's laptop computer.
And Your Honor, I move this in as Defense Exhibit 178.
Any objection?
No objection.
178.
Sir, can you point out the significant portions of this that made it your slide today?
Well, obviously Telegram is one of the 3 accounts that were instrumental in this investigation. Any usage of Telegram on Ms. Banfield's device or any of the devices is significant. This one happens to kick off again just after the phone call or the Telegram voice call. So we saw that kicking off almost at midnight on the nose, lasting for 42 minutes, just short, 42 minutes. This one activates or kicks off, the usage of Telegram again kicks off at 12:42 a.m. on the 21st, and it only lasts for under 3 minutes, or under 3 minutes. It's a very brief usage of Telegram.
Your Honor, I'm going to move to the next slide. And I believe that's Defense Exhibit 179. Sir, do you recognize that slide?
I do.
And what is the slide? What does this represent?
This is a continuation of the Telegram exchange.
Your Honor, I move this in as Defense Exhibit 179.
Any objection?
No objection.
179?
And what are the significant portions of this message relating to your forensic analysis of this day?
For me, the most significant aspect of this is the time and what it corroborates. So a moment ago, and this has been true about what we've seen with Telegram usage on the laptop corresponding with a conversation from another device. So on the slide previous, we saw Telegram.
Judge, I would object to the categorization of another device. There's been no foundation laid to suggest that this is coming from a separate device than the one that had the message indicating that Telegram had been interacted with.
I will sustain the objection.
Sir, what are the devices that you've analyzed as part
Judge
of?
asked and answered. We know how many devices there are.
I'll sustain the objection.
I'm sorry, I thought that the foundation was for devices.
He was talking about another device, so that's the question.
Okay. In your digital forensic analysis, what were the devices that you relied upon in order to?
Same objection.
Sustain.
what
Yes,
devices-
state. Please, state. Keep objecting like that, please. Asked and answered a million times over. We've been through this. We know the devices. Oh, my word.
that you're talking about?
The other device I referenced was from Mr. Ryan's cell phone, which I believe to be the source of these extracted messages that performed by Detective Miller.
And, Your Honor, may we approach?
Okay, sure.
The judge. Okay, sure, yeah. Yes, what are you doing? We're 2 minutes behind. We can go slightly ahead. Look at the judge. What are you doing? You still gonna have that other witness remotely or what? Stefan says, sit down, Carol. F off Lidsky. I'm fed up with you too. But they still have 57 devices to go over, Stefan.
Sir, based on the device that you just spoke about, is that part of this digital forensic analysis relating to this slide?
This, yes, my understanding is this data was contained in that device.
Okay. Now,
This data was contained in that device. Okay, successful now. So thank you. I could not watch this boring trial without your happy, cheerful approach. You really are terrific. Thank you so much. I'm one of those that's always, is the glass half full, half empty? Who cares? You can refill it, you know what I mean? Always going to have a positive attitude, do our best on every day. Some days are harder than others, but we will get there. We will get to closing arguments. We will get to verdict watch one day. And hopefully we will see justice for Christine Banfield and Joseph Ryan. I really, really hope so for their families.
we've gone through a series of slides. Your Honor, move this in as,
It's already in evidence.
is it in evidence? Okay, sorry. In terms of the Telegram discussion and the timeframes leading up to it, based upon your digital forensic analysis, did you reach any sort of conclusion? as to what was the communications during this evening?
It's a weird
I
question.
reached a few potential conclusions, yes.
Okay. And was it based upon your analysis of the digital forensics that you've analyzed to create this evidence?
Yes, it wasn't exclusive to Telegram, however.
Okay. Can you opine about what your conclusions are?
How about no? Look at him. He's like, Zenja not said, so this data is coming from Joe's device, not Christine's. That's a good point as well. Right? Okay.
I can, is it possible to go back to the fourth slide?
Absolutely.
It might help for contextually.
I'm going to just go back, sir, and just tell me where to stop.
Judge, can we identify an exhibit number, please?
I don't know which one it is yet until the rolling slides stop.
Is that the slide?
If you could go back one or two more, please,
Back, same direction? or
Yeah.
The other way?
towards the start. Okay.
Baruka Saltbaum says, here's a telescope, so we might see the end of this questioning. It's been difficult in this trial to see light at the end of the tunnel, but don't worry. We just keep taking one step at a time, and we'll get there.
Is this the slide you're talking about?
This one and the one immediately after this.
What exhibit number is this?
Your Honor, I believe this would be 162.
No, Judge, this is 160.
160.
I'm sorry, say it again.
160.
160.
Sir, you're referencing a defense exhibit number 160?
Yes.
And what's the significance of that toward your conclusions?
So for this and the next 3 or 4 slides, the respective devices, I can't speak to the people holding them, but for a time at the beginning of this event window, the main devices of the 3 involved parties were in 3 different places, is one of the inferences I draw from the data that I analyzed. That is important if you advance, maybe one slide, please.
$161.
Yes, thank you. So that's important because at this particular time here with this slide at 10:58 and 24 seconds, Ms. Banfield's computer is logging in to her email, an email account associated with Mrs. Banfield. So at this time, neither Mr. Banfield's nor Ms. Magalhaes' devices are present in the house. So the conclusion I draw from that is that there was only one related party to this investigation at home at the time.
And using a work account, okay?
So the laptop
Judge,
is,
objection, calls for speculation.
Sustained.
We'll just leave it at that.
Okay.
Is there another, do you wish for me to show the other slides?
you can move forward 1, 2, sorry.
2.
Yeah, if you can go 1.
That would be
sorry.
164, I
Well,
believe, Judge.
One more, my apologies.
One more back?
No, keep going forward.
Okay. 165?
No, one.
Dawn Marie says, I think I speak for everyone to say that face. Happy 2-year Grizzly versary. Thank you so much for your support. Susie Allen says, OMG, I can't believe this. I know, right? We're all just watching and going, can we really believe this? Is it really happening? Still, yes. Stefan's like, speculation. Mm-hmm.
More.
Is that one, I'm sorry, Trish.
That's 164.
Okay, so 165.
I'm sorry. I'll let you know when we're there. There. If you go back to the blue screen, please.
Yes,
So-
sir.
166. That's 166.
Yes.
Okay.
Is that what you?
Yes, thank
Okay,
you.
166, thank you.
Sorry for the journey. So again, bless you, this tells me that we have, what I see is Ms. Banfield's laptop is in use with a remote access to a website associated with her work. The activity on this device began while other devices weren't in the house.
Judge, I'm going to object. That calls for speculation.
Sustained, we need to stick to devices.
Okay.
I thought I said devices.
You said other people in the house.
I thought I said other devices in the house. My apologies.
Well, let's just say what you meant to say, and then we'll.
So this is a current time when other relevant devices are not in the house. And the
And Judge, I'm going to object as to foundation. This slide indicates that the website is a Chrome last tab. The witness is assuming that it's being interacted with, but that is inaccurate from the information on the screen. I do not believe he's laid any foundation to suggest that there is an actual interaction with this website occurring at 11:07.
Foundations.
Okay. Sir, what was the basis for, this is already in evidence, correct, Karen?
It is.
Yes.
What is your basis for your assertion that this was a login and access?
It's a fair point. I can't tell what happened past this. I cannot tell if a user went forward with accessing the site beyond just visiting, just getting to the page.
Okay.
Talking lots of bullcock up there today, hey? Thank you so much for making coffees rain a little bit. Is it coffee raining hour? I really appreciate all your support. There's another one. Thank you.
Continue your.
Yeah, so the last inference that I drew from this evening is, again, this particular device, the laptop, activity began on it at a time when other relevant devices were not present in the house. That activity continued on through.
Judge, I'm going to object to his mischaracterization of the evidence. His previous testimony was that the phone belonging to Juliana Perez Magalhaes connected to the home network at 11:06, which would be 1 minute before this interaction. So other devices were in the home.
Sustain the objection, if you want to clarify.
What time did the?
He's like, but ma'am, you could just see when the state is like objection, he looks like a naughty boy. Okay, sorry, I knew I said it. He looks like he's caught out. The witness, I mean, he's like, oh, okay, sorry about that. We tried. Come on, man.
Phone, Juliana Perez Magalhaes phone connect.
If you want to back up one slide, I think we'll see that at just shy of 11:07. And if you want to back up just one more, please.
It's 165, and now we're looking at 164.
Sorry.
Too far.
Back one more. There.
Yes, Stefan said his speculation is getting pretty close to lying. Mm-hmm. Like, what on earth?
Is that right?
Yes.
Okay.
What exhibit number is that for the
That would
record?
be exhibit number 160.
161.
161.
160.
So the activity, not particular to that website visit, but the activity, the laptop was in use prior
No way.
to the arrival of other relevant devices.
No way. How could that be when it was Christine's laptop? How could she use her laptop on some nights? Her own device. Come on, man.
So a human,
The bigger question is, why are the other two at the gym? What are they up to? Were they really at the gym, huh? What kind of workout were they doing, huh? I want to know. Someone, thank you for supporting the mods with coffees. Okay, although we don't know. Objection, speculation on myself. We don't know which two were at the gym, which one was at home. We don't know.
was using this laptop
How do you know it was a
while
human?
other humans' devices were not, while other devices were not present. So I see the session, the use session, as an extension. So from where it begins to where it ends, what I'm looking for in this particular investigation.
And Judge, I'm going to object to the testimony. I don't believe that it calls for speculation. I don't believe that he can identify when the use ends.
All right, I'll sustain as a speculation. Next question.
How can you determine when a session ends?
Well, for the period of activity that I analyzed, perhaps it's when I ended it or I stopped noting it versus when it actually ended. But we just look at, cessation of user-driven activity.
And is that what you relied upon in arriving at your opinion?
It is. I don't believe I marked in this demonstrative when that, I can't say for certain the last activity that I put into this demonstrative corresponds with the actual last user activity.
And so in this demonstrative, it says 10:58:24.
Well, this is on the front end of the session. And I guess just to get to the point, if I can, the activity begins, we have device separation, activity beginning, activity continuing without what I would consider a break.
And
You don't
objection
know
calls for-
that. You literally don't know that. Dude, really? How much are you getting paid to say all this crap? Imagine all the detectives watching this, like, no. Wow.
For foundation.
Sustain as the foundation.
What do you look at when you're determining whether there's a break in communication on the device?
A period of inactivity, and that's, that's subjective, as I said earlier, right? 10 or 15 minutes could be significant enough for what we're talking about. But if you scroll forward, and I apologize, I'm just gonna have to stop you when you get there. There.
Okay.
What exhibit number is that?
Your Honor, I believe this is 169, 168.
I have 168. Okay,
168.
okay.
Yes, sir. This is the slide
Stop it, you guys are making me laugh.
that you wanted to go to?
Yes.
Okay, and what's the significance of this slide?
So we can see the start and end times here.
Objection, perjury, lying, whatever you want to call it. What is the significance of this slide? Zilch, zero, nada, nothing. Get off the stand.
This instance of Telegram began at 11:09 p.m. and ran right through up until midnight, which is the time where the voice call occurred and a different session was engaged. So this I see as a period of sustained activity.
Again, objection, foundation, Judge. He
Sustain.
can't say who was interacting. The message was received.
Sustain.
Thank you.
How can you arrive at that conclusion? What did you review and what do you base your opinion on?
Well, we saw from the Telegram conversation snippets that they occurred within this window. So that is the activity I was referring to.
Wow.
And those are the items that were introduced into evidence?
They were.
The green and blue slides that have been introduced into evidence?
Correct.
Do you need to reference those?
I don't. If we want to confirm they were within this window of activity, that's fine, but I believe they were.
Okay, let's move to 169. Is that one of the conversations?
It is.
Show us his conversations with the au pair, please, seeing as you're bringing up all this. Just, can we see some of that session activity? The two of them. We want to see birthdays, Valentine's Day, Christmas, the day of the murders. Show us some of their text messages. How about that? We'd like to see those sessions. Would we, though? I don't think we do.
Move to 170. Is that one of the conversations?
Yes.
And can you see the timing there? Does that fit within what you've been testifying to?
It does. These are all between 11:09 and midnight after the math.
You're identifying 177?
Just say no more questions. How about that?
Is that one of the
Please.
conversations?
This, there is. This is as well one of the conversations. The top left conversation is at 11:52 and 56 seconds, 11:53 p.m. So it's in that window of 11:09 to midnight that I referenced. The second two are in different instances of Telegram's activation on the laptop. And I think they're either right before or right after this slide. I think before. Right, so
Yeah, LP says genoeg is genoeg, which means enough is enough.
179? Is this one of the conversations?
it is.
And Your Honor, has this been moved into
Yes,
evidence?
179 is in evidence.
Okay. And sir, would you like me to show the other conversations?
Well, just that for the corroboration effect, we can see the blue conversation bubble occurred at essentially midnight, 12:44 a.m. on the 21st. If you go back one slide, you'll see the associated Telegram activity when the Telegram app was open on the laptop.
Okay. And that's what you've just described on this particular exhibit is in UTC time.
Correct. So it's just corroboration. We have Telegram activity on the laptop, and we have a Telegram conversation occurring contemporaneous to each of the instances of activation of Telegram use.
And I can go back to
A lot of fluff in that sentence.
the other slide that you were referencing.
If you think it would be helpful, I'm fine.
Sir, what were your conclusions based upon your digital forensic analysis of February 20th, 2023?
I didn't see anything here to suggest device takeover. I didn't see anything here to suggest misattribution.
I don't see anything here to suggest expert opinion or anything like that. I don't see anything here to suggest that Brendan Banfield is innocent. Okay, thank you so much.
Sir.
took all his strength to open that water bottle. Did you see it? Not the contagious sniffles.
Your Honor, I'd identify this as
Stop identifying anything or moving anything into evidence. Stop it. Sharon M says, is this going to 5:30 today? Asking for a friend. Even me, I'm asking for a friend. I don't know. The judge didn't specify. It's 3 o'clock local time now.
Defense Exhibit 180. Sir, can you identify this slide?
This is a screenshot or a snippet of responsive material provided by Google related to the suspect alleged email account.
Sir, have we gone through this?
I believe these may have been shown to Detective Miller as well.
Okay. Now, Your Honor, I move this in as Defense Exhibit 180.
I believe it's already in evidence under Detective.
I know we've seen it. I can't recall if he held off on admitting it, though. And we absolutely spoke about it with Detective Miller.
I'm just going back to see if I can.
I'm not certain that it was admitted, Judge, but I definitely recognize it.
I think it was 116 is what I have for it.
We're gonna have to round.
Does that look familiar to anybody?
Judge, I have 116 as the screenshot of CBRN 921, 923 emails with subject lines. So yes, I think this has been
This is
admitted
116.
as 116.
It is already in evidence. Yeah, it's 116, so it's already in evidence.
Okay. Mr. Lidsky, this has been identified as Defense Exhibit 116. Your Honor,
It's in evidence, yeah.
can we?
It is.
Okay. What, if anything, is this that we're seeing here?
This is account activity in the alleged suspect Gmail account. It represents 3 emails sent from the account to the account. And there were a number of photos as attachments to those emails. This activity was performed about 20 or 30 minutes after the account itself was created.
I think that was Brendan Banfield.
Your Honor, I'm going to move to the next slide. I think that's 117.
Stop doing that. Moving to the next slide. Stop it.
And sir, what is this slide intended to show? And was this part of your analysis of the digital forensics?
It was part of my analysis. This is a chronological listing of all of the account logins to the suspect alleged suspect Gmail account, beginning with the top, which was the initial login. We also have some device attribution here as well that Google captures.
And what can one conclude from looking at this?
Well, the first activity, as we've discussed already was January 9th at 11:10 PM is when this Gmail account was created. It was done so on a Android model, or I'm sorry, a Samsung Model G991U device running Android 13 operating system.
And are you able to identify the device that's SMG991U?
I am aware of that device, yes.
And whose device is that?
There were two of those devices encountered only, or I think analyzed, one of which was a government device that did not contain data, and the other was Mrs. Banfield's device.
Judge, I'm going to object to the statement based on foundation stating that the IRS phone did not contain data, I think is a misstatement.
All right, sustained as a foundation.
Okay, what makes you say that the IRS phone did not contain the data?
I should have qualified with relevant data. Government phones, and this was true of mine at Department of Justice, are highly restricted.
Judge, I'm going to object as to testimony about his phone. This phone,
All right,
Mr. Banfield's IRS phone, is the one we're talking about.
This phone had a number of restrictions in place. It was limited to the number of apps that could be installed and what was installed.
And
Which gives us even more reason to believe why he used his wife's devices to make all those accounts. Yeah, instead of just buying another phone, which he did later for himself and the au pair. But, you know, he's trying to be so smart.
how did you conclude that this was Christine Banfield's phone based upon that?
The conclusion is that this was a Samsung model phone consistent with both Mrs. Banfield's and Mr. Banfield's IRS phone.
Look at him, he's looking nervous there. Wait, what? Yeah. Save Our Water says, gee, how much time between the setup of the FedLife account and the incident? The FedLife account was set up on January 17th of 2023, and the crime occurred on February 24th of 2023. So just over a month.
And is there, in terms of the contents of the IRS phone, actually strike that question. Is there anything else that differentiated the two phones for purposes of your analysis?
Their usability is highly different. They're both phones, but again, the government phone, the IRS phone in this case, was restricted to certain apps and permitted usage.
And how do you know that?
From records provided by the IRS.
And in those records, did they give you any detail as to how it was restricted?
I remember seeing a list of both permitted apps and installed apps.
And was that as to this phone or just IRS?
That only applied to the IRS phone, not to Mrs. Banfield's phone.
Okay. You're going to move to the next slide?
Judge's like, all right. Normally she's like, okay. So, all right. Moving to the next slide.
That would be 118.
Shame, the poor jury.
Okay,
Sir?
it's already in evidence.
Yes. Have you had an opportunity to see this before?
I have.
And you were here when Detective Miller testified relating to this?
I was.
Okay, so what is the significance of this relating to your analysis?
This is just a continuation of the login activity from the prior slide. I believe this is the complete universe of logins from January 9th to the last one on February 23rd. Aside from the first one, which was from a mobile device, the rest of these are from a computer, a Windows computer. And all of them on the previous slide and this were from the Banfield's home IP address.
You're going to move to the next slide, which would be 119.
119, which is in evidence under seal.
Sir, can you describe for the ladies and gentlemen of the jury what this is?
So this is I believe it's a
Now,
partial.
If you'd like, I can enlarge it and then move it around.
No, it's fine as it is. This is a partial visualization of the message activity that occurred within the account. Aside from or it's inclusive of the 3 messages we saw on the first slide, this is close to 290 messages that were received by the suspect alleged account, or the alleged suspect account, and these are varying in dates and times. I believe these were all recovered from the deleted box of the Gmail account.
And these are items that you recovered?
These were provided by Google in response to the Fairfax County Police Department search warrant.
And in terms of the deletion box, would you consider that account maintenance?
I would consider that maintaining the account, cleaning it.
And to arrive in this form, what would one have to do from the inbox?
Log in and select messages for deleted. I don't recall if these were read or unread, but it would require, generally it requires logging in, selecting messages, and deleting them.
Like as if no one knows that, right? Miss Sue, thank you for your sticker. Katie Key, thank you for your sticker as well. Sure. I'm going to speed it up slightly because now we are at 5 minutes behind the live feed. Okay, thank goodness.
Okay, thank you. Your Honor, I'm going to, so that was a portion of what we showed to Detective Miller.
Okay.
So I'm going to have to jump to the other numbers.
Whatever, 180 now?
We're at 180.
Right.
And I'm just going to move 2 slides. 3 slides. This would be identified as Defense Exhibit 180. Sir, what is that?
These are 2 login events from a Windows computer to the alleged suspect Gmail account on February 17th, about 4 minutes apart. The first at 11:19 p.m., 11:20 p.m., the second at 11:23 p.m.
Your Honor, move that in as Exhibit 180.
Any objection?
No objection.
180?
And I'm sorry, could you please repeat that for the ladies and gentlemen of the jury?
Judge, I don't know why it bears repeating. Objection asked and answered.
Sustained.
I'm sorry.
Asked and answered. I'll sustain the objection.
Okay. What if any significance to this
None whatsoever.
slide to your investigation for digital forensics for this case?
Well, obviously, the Gmail account has significant relevance to this particular case. The use of the case, as discussed earlier, requires awareness that the Gmail account exists and knowledge of the password. So to log into an account, a Google account or a Gmail account, you have to first know to go find it, to go look for it, and have the password to log into it.
And how important are these kind of details as to trying to attribute device behavior?
Well, knowing where and when
Judge, I have to object, asked and answered. I think we've been over why this is relevant. We can move on.
A million times.
Okay.
And also, if you need to know what the Gmail even is and know the password, how did Juliana then know about it, huh? Because she testified to it, knowing it, logging in, what they deleted, what they said, how they worked it. She sure knew a lot. The jury won't forget that, I don't think. Candy Temple, thank you for your sticker.
I'll move on to the next slide.
Or just the next witness. How about that?
Sir, have you seen this slide?
I
This
have.
would be identified as Exhibit 181.
I have.
And what, if anything, stands out in making this slide?
The timing, it's also on February 17th at 11:24 and 11:29 respectively, PM. And these are two outbound messages from the account purporting to be Christine Banfield.
Your Honor, I'd move this in as Exhibit 181.
No, again, if we can, right.
181.
And so the timing significant in this situation?
Yes, this is FetLife activity contemporaneous to the Gmail account activity we saw on the prior slide. Looks like within a minute or two. So overlapping basically at the same time.
What is this? What is going on here? Oh my goodness. Okay, we're going to see some messages here that I would say Brendan Banfield and Juliana wrote. Okay. Carmen Ruby says, why is he calling him alleged suspect and not defendant? Are they best buds or what? I think he's literally wording it so badly that he's calling this email the alleged suspect email. He means the email is suspect. The suspicious email. He means this email that no one knows exactly who made it and when and why. Oh my goodness, but every time he says suspect, I think we're all looking at Brendan Banfield. Because he's the suspect, he's the guy on trial. 4 counts of aggravated murder, 1 count of child endangerment, 1 of using a firearm in the commission of a felony. That guy, the suspect. So when you go alleged suspect email, all we're thinking of is Brendan Banfield, right? Isn't that what your brain does? What a way to phrase it. Okay, now, trigger warning, because it looks like there's some dirty words in here. Let's see. I'm doing great. How about you? I'm an ICU nurse. Hey, I understand everything in life is a cycle, and at some point, we end one to start another. But that's nice. Thank you for sharing. Okay. Oh yeah, I heard a lot of people telling me how excited they got or get seeing a nurse in the scrub. A lot of corn videos about that as well for people that enjoy that. Finally Friday, I work days. All right. All right, Juliana.
Move on to slide 182. What do we have here, sir?
So this is a snippet from the Google geofence warrant return. It's
Oh no, snippets.
provided to indicate the location of a target device. In this case, it was Mr. Banfield's device.
And Your Honor, I move this in as Exhibit 182.
Any objection?
Yes, Judge Foundation, there are no identifiers on this document.
Foundation?
Explain how you created this slide and what specifically those items are.
So the responsive documents for this particular set of records is a spreadsheet with maybe tens of thousands of rows. The data that in this case Google collects is recurring. It can be every minute or two, and it's over a period of months in this particular instance. So all I did was take a screen grab of relevant rows pertaining to this date and time from that spreadsheet.
And what date and time are you referring to?
So again, this is provided in Zulu time. So the relevant period is February 17th, 2023. Around these particular records begin at 11:19, have 11:21, 11:27, and 11:29, which correspond back a few slides to the login of the Gmail account and the FetLife activity we just observed.
And Your Honor, I renew my motion to enter this into evidence?
Judge, still, if we're to rely upon this document, it is absent on its face of any connection to the source device.
Sustain the objection.
Sir, can you describe the first column there, what that contains?
Judge, I'm going to object to the witness reading the denied exhibit into evidence.
I think he's just going to identify the column.
Yes.
That's fine. Overruled.
The first column?
Sure, date and time for the starting of the logged data session or logged activity.
Okay. And that's for all of, for each of those 4 times, that column is related to the date of the start, the time of the start?
Yes,
Okay. The second column, what is that related to?
the end of that particular data capture or data logged event.
The third column, what is that for?
It's the latitude, it's the geographical position in latitude
And the fourth column?
is the longitude.
And what does the fifth column indicate?
That's an accuracy measurement in meters, and depending on how the data was sent to Google will vary and depend on how accurate they are. If it's coming from Wi-Fi, it can be very accurate. If it's coming from cell, it's usually less. GPS can be dependent.
And is that the final column there as to what the source was?
It is.
Okay. Is there anything different about, well, Your Honor, I'd move this in as 182.
Judge, same objection. If we're to rely upon this evidence, it needs to have clear indication as to where it's from.
Sustain the objection at this point.
Do you have the entire?
Whippet Mama, thanks for being a member for 17 months. That is factually false. I started late by 45 minutes only. Thank you so much for being a member for so long, for all your support. And damn, without you guys and your entertaining comments, would we make it through this? I don't think so. Wow, it's still, I mean, we still just, is this going to be all day? So no remote witness then? I mean, the judge thinks they might only come back on Thursday, if that, because of the snowstorm. They might as well just cancel everything next week and start the following week. Because Thursday the dream would be for the judge closing arguments. That's not going to happen. I think that the defense attorney will have his remote witness, which will be then in person on Thursday. Then maybe Brennan will take the stand unless he chickens out, which I think is possible. Then the state has 2 rebuttal witnesses, and that sounds like Thursday already sorted. And then we'll have to go to the next week. It is on the schedule till February 6th. So let's see.
Access to the entire document that you grabbed this from?
I do.
Where do you have that?
It's probably on my laptop. It's certainly on hard drives.
Okay. Your Honor, we'll hold off on moving that in, and I guess we'll produce a massive document for Ms. Sands.
Oh dear.
Sir, do you see the picture on the screen there?
I do.
And does that relate to the previous document?
It will.
Okay. We'll identify that as number 183.
All right.
And when we can produce that document, we'll move that into evidence, Judge.
I mean, do you have any objection to 183 at this point?
No, just to the map itself,
I think
no.
we can move
Okay.
183 in.
Okay, let's move 183 in.
All right.
I'd like to move the defense attorney into evidence, please. Okay, evidence of Brennan Banfield's guilt. This is way too much, overdoing it completely, right? Okay, moving on.
Sir, can you identify what is contained in this slide 183?
Yes. This is just a map image of the Reston-Herndon, southern Reston-Herndon area. You can see Dulles Airport to the far left. The Banfield's residence on Stable Brook Way is approximated by the picture, the icon of the blue house towards the middle lower left. On the far right,
Objection, foundation. Judge, may we approach?
Okay.
Please approach and snark your asses off at them. Are we now going to talk about
This
the
next
windows?
slide
Thank you.
Is that related to the two previous? That would be Exhibit 184, Judge?
I'm still on sort of a continuation of the map.
Okay, of the map from the previous slide?
It's,
Judge, it will draw the same objection.
Is it ID 184?
Yes. Sir, let's move on to February 13th. Is this would be 185, I believe, Judge, identified as Exhibit 185. What, if anything, does this indicate relating to your investigation of the digital forensics on this day?
this is another 2 logins to the Google, the alleged suspect email account, the Gmail account, CBRN 920. These took place on the morning of February 13th. Both, one at 7:33 and one at 7:48, 7:49 a.m. It was a bit anomalous because most of the activity that I observed in my analysis of this account took place at night, frequently late at night. Both of these came from the Banfield residence, both of these events from a Windows computer.
And what are the relevant times there? And what's the significance of that?
7:33 a.m. and 7:49 a.m. And they were, anomalous from most of the other activity
Anomalous.
that I observed.
Sorry, I'd like to move that in as Defense Exhibit 185.
Contemporaneous and anomalous. Okay.
Before you start explaining, I wanted to make sure the jury saw it. So can you explain to the jury what the significance of these 2 artifacts are relating to February 13th?
Judge asked and answered.
Yeah, so here are the 2 logins I just described. They are, bless you, they are from the home IP address. We can see that at the top of both. They're logins to the alleged suspect Gmail account. We can see that towards the bottom of each.
Alleged suspect Gmail account. The absolute worst way to phrase that, and not what an expert would say. The alleged suspect Gmail account. Oh my word.
Highlighted section. The date and time, they're both in the morning of February 13th, 2023. The first at 7:33 and 12 seconds a.m., the second at 7:48 and 41 seconds a.m. From the details, we can see the nomenclature of the device-ish. We can tell from this case that it was a Windows-operated computer, not a mobile device.
Your Honor.
This is private counsel, and apparently his parents are paying. I think. Juliana was saying in her jail letters that she heard from the state that Brendan got life insurance when Christine died. I hope not. I hope that wasn't the case, but either way, somebody's paying for this private attorney, and he's sure gonna rack up his hours. So, Brendan, if you bankrupt your parents, that should be another crime,
I'm going to move to the next slide. Sir, can you see this slide?
I can.
Okay. And is this something that you created?
No.
Is this something that you found through your digital forensics?
This is just a screenshot, a portion of the FetLife records.
Okay. And those are the records that have been moved into evidence?
They are, and these particular ones correspond to this date and this time frame on the morning of the 13th.
Now, Your Honor, I move that in as Commonwealth's Exhibit 186.
Any objection?
Nothing.
I'm sorry, Defense Exhibit 186. I keep saying that.
186, yes. Defense 186.
Sir, what's the significance of these messages as it relates to the investigation of February 13th, 2023?
Just the timing, that it was contemporaneous or basically at the same time that the Gmail account activity was occurring.
Your Honor, I'm going to move on to the next slide. Do you know what this is?
I do.
Okay. And what, if anything, What's the significance of this in terms of your investigation of February 13th?
So this is a demonstrative I created to show Mr. Banfield's devices relative position to the activity we just discussed at the residence.
That would be identified as 187. All right, I'd move to admit that into evidence.
Any objection?
There's more to this. It's got,
So perhaps maybe we move through to the completed item, because at this point, it's just a map, so I'm not sure how it's relevant.
All right. Do you object to the map coming into evidence then?
No.
All right, 187 in evidence. Let's keep going.
Your Honor, I'm going to move to what will be identified as defense 188.
All right.
Sir, what do we have here?
these are the times of the FetLife communications, the outbound FetLife communications from whomever was using the account purporting to be Mrs. Banfield, with an arrow pointing to the approximate location of the Banfield residence in Herndon.
Your Honor, I'm going to move on to Defense Exhibit 189.
I'm sorry, was this being offered in evidence, or we're just moving on?
Oh, I'm sorry. Your Honor, I move Defense Exhibit 188 into evidence.
And Judge, we would object as an improper exhibit and foundation for the same reason that Ms. Graff's
All right, I'll sustain this.
demonstratives didn't come in.
Barbara says this whole life insurance thing, has there been info? I haven't seen any info on that. It might just be something the state told Juliana, for all we know. Because they were like, see, you're not the only one in his life. He's talking to other women. He's with other women. She was like, and I do think it made her think it affected her, where she's like, wait, what? He's cheating on me? The cheater is cheating on me? No way. And he benefited financially? No way. And then over time, the minute he was arrested, I mean, she's like, give me that plea deal. So interesting. At least we'll never forget the patience that this trial took to get through. And each and every one of us who watched the whole thing, we will earn our trial completion certificates for this one. If you didn't know, this is our 25th trial. After each trial, I make a trial completion certificate. There's a whole collection of them on Patreon. And I'm going to make a gold one for this one, hey.
Sir, do you see the exhibit on the screen identified as Defense Exhibit 190?
189.
189, I'm sorry.
I do.
What are the reference points? Your Honor, may we approach before I ask the question?
Kick his ass, Judge.
Mr. Lidsky, have you had an opportunity to look at this slide?
I have.
And this is identified as Defense 190. And explain what this shows and how you came about this in your investigation.
This is another login to the alleged suspect Gmail account, the CBRN 920 account, occurring on January 23rd, 2023 at 11:22 p.m.
Your Honor, move this in as Exhibit 190.
Any objection?
No objection.
190.
And what are the significant portions of this other than the date of 123?
The date and time, the home login address, but we saw from the slides prior that all of the logins occurred from the residence. It was from a Windows computer, which we've seen before.
And this was an artifact that was obtained through a warrant return to Google?
It was.
Your Your Honor, I'm going to move to what will be Defense Exhibit 191. Do you recognize this?
I do.
And is this something that you received in your investigation into digital forensics?
It is. These are part of the FetLife responsive records. These are outbound communications from the account purporting to be that of Mrs. Banfield's, occurring on January 23rd, 2023, about the same time as the Gmail logins we just discussed.
Your Honor, I would move this in as Exhibit 191, and I think it just should be sent to the
191.
to the jury.
Sealed.
As I guess Judge has a sealed document.
I didn't tell me that before. Is this a sealed I don't think it's a sealed document.
I wonder if Mr. Carroll was like this throughout his career in every trial. Do you know? I mean, I would think so. I'm just wondering. Damn, he's got stamina. My goodness.
Judge, the entirety of the record is in evidence, not sealed.
Okay, I just was trying to. And sir, what exactly is, tell us about this artifact for the ladies and gentlemen of the jury.
Yes, so as stated, these are two outbound communications from the account purporting to be that of Mrs. Banfield's, both on January 23rd, 2023, the first at 11:28 p.m., the second at 11:35 p.m.
Okay, let's have a look. Angelina said, sir, do you see defense item number 3099 on your screen? OMG, just say no, Judge. Yeah. Okay, this says, I'm new on TIS website. Right. Okay, Juliana, sorry. How has your experience here so far? There's like words missing. Hey there, thank you for messaging me. Who's writing this? We don't know. It's just devices. I'm just trying to figure out the blue bubble and the what. Okay, hi, I'm new on TIS website. How has been your experience here so far? Hey there, thank you for messaging me. Yes, I am new on this website. I'd love to hear a bit how has been your experience here so far. Okay, I'll say it again. Okay, Juliana. I've had experience in a previous relationship, was it Bruno? Oh, sorry. Where I enjoyed my partner pinning me down, spanking me, doing things forceful. Hey, okay, disclaimer. I'm reading something on the screen. You naughty people just listening. Okay. Reading a trial exhibit, okay. Okay, so somebody writes, I've had experience in a previous relationship where I enjoyed my partner pinning me down, spanking, doing things forcefully, tying me up, effing my face, stuff like that. I'd love to have this experience again, so I'm looking for someone aggressive, dominant, who is really willing to do this. What about you? Okay, on the 23rd of Jan, 2023. Was that entertaining, everyone? Janet says that was spicy. Oh, my word. Should I read it again? No.
And Your Honor, that's been moved into evidence, correct?
Yeah.
We'd like to call Bruno to the stand, please. If you don't know who Bruno is, you missed lunch. We read Juliana's jail letters, and she talked about an ex called Bruno. Shame. Sorry, Bruno. Would like you on the stand, though, please. We'd like to ask you some questions.
Okay. I'm going to move to the next slide.
Yeah, you see that, baby boy? That's what Juliana liked. Not you. I don't. Yeah, shame. You couldn't do that, hey?
This will be identified as Defense Exhibit 192. Is that right? Sir, can you identify this?
Yes, I can. This is more Google geolocation records associated with Mr. Banfield's mobile device.
Okay. Is this part of the document that you clipped out of?
It is the same spreadsheet.
I'll hold off on amending it, Judge.
Why don't we go ahead and take our afternoon recess, and then maybe you can get that document for me?
May I
Yeah.
speak to him about the document?
Yes, you can speak
Okay.
about the document. Is any objection to that?
No,
Just
Your
so
Honor,
you
it's
can-
specifically, he's not asking about this document. He's asking to retrieve the
He's-
base document for this
Right, he
data.
says he has the base document for all of
Understood.
these.
No objection
So
to
if he could
that.
talk to him about that, so he can get that.
Yes, ma'am.
Okay, perfect.
Thank you.
All right, let's take our 15-minute recess. Not talk to anybody, don't do the outside research. We'll see you back at 3:45.
Of course, thank you, Judge.
Okay, in 5 minutes from now. Janet says, effing my face? What the hell? I have questions. License to Deal said, BB's mommy is going to have to pay for my Invisalign replacements. I'm grinding through these. Biatches. Is that it? Biatches. Thank you for your sticker.
Talk to him about getting the large geo-tracking document, okay?
Of course. Do we want the FetLife documents?
I don't.
Those have been
You
admitted.
can talk to them about that. I'm not in.
Okay.
Okay, 3:45. Okay.
Thank you, Judge.
The judge is like, no, none of those. We don't want that. Oh, look at him, everyone. He's a very good boy. He would never talk like that. Never. That's how he's going to blame it on Juliana. What? I would never. I'm a good boy. I'm a real boy. Oh, my goodness. Okay, they showing a picture, but they said 3:45, right? 4 minutes. Let's go. Let's go. 4 minutes, people. And what does that mean? We've got time for something like this. Okay. Ti amo. What does it say? Juliana to Marina. Hi, Mom. My love. I just got back from the hearing. It was quick. This is a letter from jail. Jail letters Juliana wrote. Okay, this one's to her mom. Anyway, yesterday my lawyer tried to call me, but I don't know what happened. We couldn't talk. The call wasn't working. He had told Mimi, that's Brendan's mother, that he was going to try and schedule the trial for the first week of October. However, at the hearing, he didn't mention anything about October. The option he gave was November, December, and January. I was so pissed. I started to yell and cry. Why does she write yell like that, okay? I hate this. He said he was going to try October, and for no reason he offered January? F him. Screw him. And to that I say, Juliana, you wish. Okay, sorry. He said that he was going to try October. Oh, yeah, sorry, F him, screw him. He said he would come and see me today at 12:30. Let's see, because he says he will do so much, and he doesn't do shit. I don't even know why I'm paying a lawyer. Well, you're not. Brendan's mommy is. Who doesn't do his job in a timely manner. You can't pay for nothing, Juliana. Anyway, just let everyone know, okay? And is Grandpa drinking? I hope that no. How is everyone there? And no, Mom, there's no chance at all that I'm going home. I have to wait for the trial. I'll be here the whole time because there is an immigrant agency that if I'm released, they will deport me to Brazil. They won't take that risk. Anyway, I'm just disappointed at my lawyer who should be doing a better job in holding to his word. They scheduled the trial for November 12th. They say it's 2 weeks of trial. Later, when I am calmer, I will send you a message and maybe, Mom, we will call. Let the folks at home know, including Grandpa, okay? God bless you. I love you more than anything in this world. Hey, we might even just read like maybe 2 or 3 letters and just be like, oh no, we missed 5 minutes, and then speed it up, right? Do we like that? This says, te amo. Oh, they translated it, okay. Hi, Mom. This one is what? 7/1/2024. Hi, Mom. My lawyer came to see me. He said he scheduled it for November because my female lawyer was not available in October and he can't do it without her. Anyway, this made me even more pissed, but what can I do? I can't do anything. It's too late. I didn't even want to talk much to him today. I'm so pissed off. If you want, we can call you in a little while. I'll be home too. Better to talk to him. Kisses. I love you more than everything. Okay. So they're translating these ones, right? Are these 2 friends? I want to read the ones to Brendan. Do you also? Complaining about the lawyer. Okay. Jew, I'm happy to receive your message. I think she's writing to friends here. Right? I don't want to read those. We're on 22. Hold on. Yes, close all the tabs and open new ones. 22. Let's open 23. There's 70 of them, just remember. Shame, the poor friends. Hold on. Oh, damn. We want more to Brendan. Stop it. Really, these are all just complaining about a lawyer. Oh, my word. Yeah, I'll show you. Look at that. Oh, hey, Mom. Okay. I don't know who she's writing to. Sorry, I want to make sure we read good ones. They're not bad ones. I kind of feel sorry for the friends and the mom in a way. You know what I mean? Her mom. Okay, wait. Sorry about that. 140, 41, 42. We're going to have to go to the bottom. 54. Nope. Oh, they know more to Brendan. What's going on here? 16 pages. Oh, my word. Ooh, the Netflix stuff. Okay. Don't worry. I can put these all on Patreon as well, on the public or free post. Okay. You don't have to pay to get it. I love it when you do join the tiers to support the work I do. Thank you so much to everyone who's on there. But I will post them as well on there so you can see all the ones I'm speeding through now. Is that, like, what else did she write to Brendan then? Oh, my. I don't know what's going on there either. Wait,
All right.
they're coming back. Shh. Stop it. Okay, let's at least read one. Let's see this one. Hi, Mommy, my love. I love you more than anything in this life, too. I'm happy that Grandpa's doing well, Mom, and that you forgave him. And you, with the help of God. My heart feels warm, especially because you need each other, you know? If love and care waiting for me to return. That's right. Pray for real, okay? I pray the rosary of mercy every day, too. It's never too much. Let's see if my lawyer shows up today. He makes me very frustrated. I'm never happy or satisfied with his work. He says he will do things, but he doesn't. He's delayed my entire process. Says he will come and see me and nothing. Doesn't make an effort, you know? I should have changed lawyers a long time ago, but now it's too late. I trust and believe that God will guide him, and I hope he succeeds and pays for the bike, right? Because he gets himself into all sorts of situations related to money. If God wills it, it will create judgment and improve, lol. It's good to exercise. I feel good when I finish. At least it passes time, right? Yesterday, the phone wasn't working. The website wasn't working. So I didn't have my appointment. I couldn't call Brendan, nothing at all. So far, the phone is still not working. Have you heard or seen something from Bruno? There you go. Later, I'll send you a message, Mom. God bless you and all and your day. You see, I die of longing that I can't even explain. I love you more than anything in this world, my love. Okay. So those are letters to her family and friends that we saw there quickly. Let us go back to the court feed, shall we? We should be about a minute or two behind now. Okay, are we ready? Here we go.
It's for this device.
If you want to see the whole thing, part of the return.
Yes, that is what we're trying to isolate, is that it's that device.
Well, here's the, gotcha. Now, where his mouse is. I mean, there's the folder
Okay.
from the return, but if you
Can
need
you,
more.
can you clip it with the headers included so that it tracks?
Ooh, we do like a hot mic, right?
They're doing, I don't need narrative, Mr. Carroll.
Not in the remaining
Okay,
break.
so if you could get back to the stand, that's fine. Are you satisfied with what you're still missing some information, okay. Mr. Carroll, how much more do you have with this witness? Because you have a remote witness that has been sitting there all day,
Yeah.
waiting to testify. And you had to
I
take
just-
him out of turn.
I just talked to him, Judge. And I told
really?
him we may not be done. You know.
But I would like to do that witness.
Would you?
Even if
Okay.
we have to take him out of turn. I assume her cross-examination is not going to be long. I just need to get you through your direct.
Okay.
So,
Have you already notified him?
no, we haven't notified him,
Yeah,
but
that's fine. I'm fine
I
with
just
that.
want, I mean, he's been sitting there all day, and I'd rather get him done. He's worried about, I think, losing.
Judge? No. You know what? He plans to take a full day with that other expert witness. Don't you see it? He's not going to get it done today at all. He doesn't mean like a quick expert witness. He means this guy all day. Maybe some more next week. We're not even going to get through this guy, let alone a remote witness. As if. I do appreciate the judge being like, read the room. But no, he doesn't read the room at all. He doesn't do that.
Electricity next week. I mean, there's just issues that
Right.
I don't want to
Okay.
stress your witness out and try to get them done today.
That's fine, Judge. I literally just talked to him and said, I'm not sure yet. So that's fine.
Okay.
I'm happy to do
Well,
that.
How much more, how many more questions? Or how many-
Well, we have a couple of days to go through, Judge, so we're probably
Days.
maybe hour.
Objection relevance. Why are you going through more days? What are you doing? Stefan said he's called the Thursday, Friday expert. Yes.
a half, 2 hours for him?
Well, then we need to stop with him. And do
2
the remote
hours.
witness, if
Okay.
that's okay with everybody?
Guys, he just said 2 more hours with the PI. 2 hours. And it's 10 to 4 in the afternoon. Sir, what is wrong with you?
Right, you can have a seat. Let's go ahead and get the remote witness.
And
Let's go ahead and get him up before we bring the jury back in, and we'll just tell them we're taking them out in turn. And that way, by whenever we come back after the snow, maybe you'll have all your exhibits in line, streamlined, and you'll have all the geo-tracking information that's needed for that
and
foundation.
he'll be able to work on that.
Okay, so we can do that, so he can finish after that. I assume this witness we can get done before 5?
I believe we can.
Okay. Do you have any objection to that?
No.
Ms. Sands?
Thank you.
Okay. I'd rather just do that because this remote witness is, there might be a lot of ice in their area, and so they don't know if they'll have electricity, so. Okay. And I'll just explain it to the jury once, or do you have any exhibits to show this witness online? Well, I'm just asking if you have exhibits. Okay, we'll just get somebody from IT here to help you
2
doing that, to do that. So your witness can
hours.
see does your witness have a copy?
So whenever they come back next week, 2 hours of direct examination with that private investigator, non-expert dude. Oh my word, I can't, like Seashell said, definitely milking it. This guy, in my opinion, in many of our opinions, am I right? Don't sue me, sir, is milking it to the highest degree. Sir.
Copy of your exhibits? Have you emailed?
Yeah, they were what he
So he would already know which ones you're referring to, correct?
yes. Yes.
All right. Can you pull the screen up, please? This one? Yeah. No, it's over here.
Yeah. Candy Temple said 2 hours equals 8. I mean, if the defense says 2 hours, could be 2 weeks. Unbelievable. So, yeah, this guy's not going to take the stand today. Well, now we know it. He's going to take the stand, according to the defense attorney, just not today. I think it's naughty. I think the defense, he has a right, to present his case, but shouldn't there be boundaries, limits? You can't, because then there'll be an appeal issue. But man, this is so excessive that it's, as someone said earlier, cruel and unusual punishment. This poor jury. I'm so sorry, jury. Excuse me, what's going on now? Oh, we're waiting for the remote witness, okay. Wow. Brandon, make it stop. Stand up and say I'm guilty. Just do it. Do it now. Go and get it probably anyway. Do you think you have a chance? You think it? He's thinking about it. He's actually also zoned out. Okay. Gerardo says, why did he lie about the amount of witnesses he has? Right? I mean, maybe he meant 3 or 4 that day. Maybe he didn't mean total.
He's in, Paul. What's your witness's name, Mr.
Here, I can show you.
Barreiro?
Barreiro.
Mr. Barreiro, can you hear me, sir?
Yes, sir.
Okay, all right. We're just gonna wait for the jury to come in, and then I'll swear you in, sir, okay? And once I swear you in, we'll change the position of the monitor so you'll be able to see Mr. Carroll, okay?
Okay.
All right.
Cricket Pie said trying to figure it.
Want to bring the jury back in? We ready for the jury?
Wait.
Yes, sure.
Okay.
Trying to figure out if he's intentionally stalling so Brendan Banfield would have several days to prep and jury to forget all testimony until after the winter storm. I mean, I don't know. I think he's just earning his big bucks, if I had to guess at this point, because the jury's going to forget nothing, in my opinion. Stefan says, I'm swearing already, Judge. 2 more hours. Whenever they come back next week.
All right. Afternoon, ladies and gentlemen. What we're going to do is we're going to, sometimes things happen in trials. We need to switch things up a little bit and take things out of turn. So what we're going to do now is we're going to come back to the last expert that you had the next time we meet, okay? And we'll come back to his direct testimony and we'll go through the rest of his testimony at that time. What we have now is a remote witness that has been waiting all day, and he's in an area that is going to be impacted out of state with the weather. So I wanted to make sure we got him today. Not that I'm hoping he doesn't lose electricity anytime in the next few days, but we just want to make sure we got him in for you. So we're just going to take him out of turn, okay? All right, so you want to call your next witness?
Yes, Your Honor. I'd call Nick Barreiro.
All right, Mr. Barreiro, if you could raise your right hand for me. Do you swear or affirm to tell the truth under penalty of law?
I do.
Mr. Barreiro, can you hear me? This is John Carroll.
Yes, sir, I can.
Okay. Sir, can you state your name, spelling it for the court reporter that we have here?
Yeah, sure. It's Nick Barreiro, Nick. Last is Barreiro.
And sir, what is your area of discipline as an expert?
I'm an audio-video forensic analyst.
And can you give the ladies and gentlemen, the jury, an idea of your background that allows you to become an audio-visual analyst?
Sure. I spent 15 years in law enforcement in California before founding my own media forensics firm, and I've been doing this type of work full-time for the past a little over 5 years now.
And do you have any training, specific training that allows you to be an expert in this area?
I do. I've attended a lot of specialized trainings. I received my certification as a certified audio-video forensic analyst through the Electronic Technicians Association. I've also done training with the FBI. I'm a member of the Digital Imaging and Video Recovery Team through the FBI. I've done training specifically on all of the software that I use in my work, both for enhancement and analysis of any sort of recorded evidence. I've taken a lot of classes through the University of Colorado at Denver, which is kind of the gold standard for media forensics training, and lots of other vendors. I've done a lot of specialized training.
And how long, and let me ask you this, are you part of, I think you mentioned an organization that you're part of? Are there any other organizations that you're involved with related to your specialty?
Yes, I'm an active member of the International Association for Identification. I'm an active member of the Audio Engineering Society and the Electronic Technicians Association International, who provided the certification for the audio-video forensic analyst certification.
Now, do you, with that experience, do you train other people that are in your discipline?
I have trained law enforcement professionals in the proper way of handling and analyzing digital evidence. I've trained security professionals. I haven't trained anybody specifically that does exactly what I do. I haven't trained any of my competition, if you will, but I've trained a lot of other related individuals.
Okay, and have you testified in court relating to your findings and analysis?
I have.
And
I've
how many times
testified
would you estimate?
I've testified in court since I left law enforcement. I testified many times while I was a police officer and a detective, but since I left law enforcement and I've been doing this full time, I've testified about 30 times. About half of those were in depositions, and about half of those were in trials like this one or other sort of court hearings.
And have you been qualified as an expert in those courts that you've testified?
I have.
And how many times have you been qualified in the courts that you've attended?
All of them. All of them.
Okay.
I've never not been qualified as an expert.
And what states have you been qualified in?
Oh, I wouldn't be able to give you an exhaustive list off the top of my head, but a lot of states.
Okay, have you ever been qualified, well, you're in Tennessee, correct?
I am.
Have you ever been qualified in Tennessee?
I have been, yes.
Have you ever been qualified in Virginia?
I believe so, but don't quote me on that. Again,
Okay.
I don't recall. A lot of my testimony
Judge, if I
is
may.
remote like this.
We'll stipulate to his qualifications
Okay.
as an
All
expert.
right, do you want to move him in as expert in
Yes.
audio-video analysis?
Yes, Your Honor.
All right.
I'd move Mr. Barreiro in as an expert in audio-video analysis for the record.
All right, so moved.
Mr. Barreiro, calling your attention to the case that you worked on for, or the Banfield case. What specific
Yes, sir.
digital evidence did you receive for your examination?
I received 2 digital files. One was a 911 recording. It was just a short recording, an audio recording of a 911 call. And then I also received a longer recording. It was an exemplar recording titled Lily 3 Original, and it contained sounds of a dog, barking, whining, that sort of stuff.
And can you explain to the court what an exemplar is?
Sure.
And the
So
ladies and gentlemen of the jury.
Yeah, absolutely. So in forensic analysis, often we are using exemplars as a comparison. A known sample, such as this Lily recording, is an exemplar because it's a known recording of this dog named Lily.
Judge, at this time.
That is now.
Excuse me, sir, I'm sorry. I would object to the testimony of a known recording. I don't believe he's laid any foundation to show that he knows anything about the recording.
All right, I'll sustain the objection. if you
Okay.
want to.
Did you hear that, sir?
I did.
So what I was just asking you is what an exemplar was. And
Yes. So
go ahead.
Sorry, yes. In general, an exemplar recording is a known recording of known origin that can then be used as a point of comparison against an unknown or a questioned recording.
Can you briefly explain what a hash value is and why it's important for forensic integrity?
Yes, a hash value is like a digital fingerprint for a digital file. It's a unique value that is calculated on the file. It's not part of the file itself. It's calculated using every bit of data that's in the file. So because it's a really complicated mathematical algorithm that is done to the file, if any one single bit of data is changed within the file, the hash value changes. So hash values are what we use to uniquely identify digital evidence like this, and I calculated the hash values for the recordings in this case so that we can just verify that I used the exact unaltered copies of the original evidence that you have there in court.
Okay, thank you. If I could just ask you a little bit about your methodology.
Yes, sir.
What are the terms critical listening, waveform, and spectrographic analysis? Can you explain those terms to us?
Sure. Critical listening is it's a very detailed, repeated review of the audio data using high quality professional headphones and on a professional forensic workstation. And that's done usually it's done in conjunction, kind of hand in hand with waveform and spectrographic analysis. And waveform and spectrographic analysis it's a way to visualize the audio data that you're actually hearing in the headphones. So the waveform, I think most people are familiar with what the waveform looks like. It's a squiggly line going from left to right across the screen, and it represents the volume or the amplitude of an audio signal over time, whereas the spectrogram does the same from left to right. It represents the same sort of a timeline, but it also adds a third component, which is the frequency or the pitch that is present in the recording.
And sir, what does a spectrogram show us that our ears might miss?
So the spectrogram visually separates the sound that your ear hears as just one continuous sound. The spectrogram visually separates that sound into its frequency components. So higher frequencies are at the top of the spectrogram, lower frequencies are at the bottom of the spectrogram. And it allows us to kind of see past the noise or overlapping sounds in a recording. You can look at it like the difference between taking a bite of cake and you taste cake. You know, most people know what cake tastes like.
Do you know what cake tastes like, guys? Do you know what it sounds like when a dog barks? Huh? Well, that's where we were at. Do you remember? Which trial was it again? Where the defense attorney had the whole cake baking analogy. Do you remember that with all the ingredients? Okay, it's something like that. All right, here we go.
But this allows us to not only taste the cake, but it allows us to separate that into its individual components, right? The flour, the butter, the sugar, all the ingredients.
No, you
That's kind of
didn't.
what the spectrogram does, is it separates out the audio signal into its component frequencies.
And in preparing your report, did you create figure or examples of this?
I did.
Okay.
Spectrograms for both the exemplar recording and for the 911 recording.
And do you have your report?
I do.
Okay, is that possible to share your screen? I don't know how.
No. Do you have his report?
I do.
Then you can share your screen.
Okay. Sir, I'm going to open up your analysis and report.
Okay.
Judge, just to move things along, we are going to object to the witness's report being offered into evidence. If there are specific photographs or diagrams he wishes to reference, those would be fine. The report, no.
That's what I'm referring to now, Judge.
I know you're referring to the report, but I guess the question is, what are you going to glean from referring to the report? Because she's saying that she's going to object to it coming into evidence.
Well, there are examples of what he's speaking about that would be instructive.
Well, I'm sure he remembers his report, and if he doesn't, he can refresh his memory by looking at it.
I was just, okay. Mr. Barreiro, what is fundamental frequency?
If you could turn your laptop off, or just so we can.
So that that'll go off.
Turn it off.
That's okay. That's fine. Go ahead. We're good. Go ahead. Go ahead. Ask your question.
Are you there, Mr.
Yeah, I'm sorry.
Barreiro?
Go ahead. Yes.
What is fundamental frequency?
And I'm sorry, I missed it. Are we able to show any diagram or any of
No.
the images?
No, we're
not able
going
to
to
show the images.
We're going to rely upon your recollection.
Okay. So if you were able to see the spectrogram, again, you have the higher frequencies at the top of the screen, lower frequencies at the bottom of the screen. the fundamental frequency is basically the lowest line in that spectrogram, and it represents the kind of the baseline pitch of any sound. So I don't know them off the top of my head, but every musical note on the scale has a specific pitch that is the definition of that note, and that is the fundamental frequency of that note, and that's symbolized as F0 in diagrams that you'll see of a spectrogram. F0 is the fundamental frequency.
Okay, sir, have you listened to the items of evidence that you received for examination recently?
I have.
Okay, and would you, if I play them, would you recognize those?
Yes, I would.
Okay. I think you had referenced the Lily 3 as an exemplar recording.
Yes, sir.
Okay, I'm going to play that for you now.
Is that already in evidence?
No, it is not, Judge, and we would object.
Okay, so let's mark it. And what's the objection?
Foundation.
All right, we're going to mark it. There's an objection to foundation.
Yes, Your Honor.
What's next? 193. 183, I'm just going to, I'm sorry? 193. 193, okay, I'll mark it as 193. But the objection is foundation.
Yes, Your Honor. Sir, did you hear the exemplar 911 call?
Sir, you can't play it. Sir, you want to approach Mr.?
Willow has come to say hi, but she sees what's going on the screen and she doesn't like it. Let me try to show you guys. Willow? Say hi to the Grizzlies like this. Look at her. I see the lights are bright for them. She's not amused. She's not amused by any of this. Hey. You're making it glow. She's a very big kitty. Look at her. Okay. Okay. Sit a little bit. I'm really gonna. Oh no, shame. Look at her. She doesn't want to see any of this trial. Definitely not. She never does this. You hate the trial? Shame. It's okay. We'll spare you. We'll spare you. Okay. I'm quickly going to take her outside again. Hold on. Oh, Lord. Well, this is not awkward. Sure, more approaching. I went forward.
Are you familiar with the exemplar 911 concatenated wave?
I am. Yes, I created that file.
Okay. And did you create that off of the 911 call that was provided to you for examination?
Yes, it's a concatenation. It's a combination of the 911 call and the exemplar.
Sir, we're gonna play the first exemplar of the first 911 call, or the only 911 call that you received.
Is this Exhibit 1
This would be,
or Exhibit?
it would be Exhibit 193,
No,
or
I mean,
194.
I thought we were playing the 911 tape that was already in evidence, Exhibit
Oh,
1.
it is the same
So
one.
all right, then we can play Commonwealth's 1.
If we can be completely clear, the witness just testified that he made a concatenated recording. That's the overlay of the
Okay.
not admitted exhibit on top of the 911 call. If counsel's asking to play Commonwealth's Exhibit 1, the admitted 911 call, no objection.
Okay. Are you going to play the Exhibit 1?
I'm going to
911
play
call?
the first 911 call. If-
Not something that he created, but
Not
the
something he
original-
created.
The original
something-
911 call.
Something that was provided to him from our discovery.
And that's what you're going to play now, is
Yes.
just that one?
Yes.
Any objection?
As long as the one that he provided to his witness is the same as was admitted in evidence, no objection.
Well, I'm happy to play the one that's admitted in evidence, but this is the one that I received from discovery, so
It
I
should
would
be the same
assume.
one then.
Should be the
Okay,
same.
so Commonwealth's 1. Let's play Commonwealth's 1.
Sir, can you hear this?
If we can't hear it, he can't hear it.
Everybody, it's time for a hearing test. Can you hear it?
It's the audio file. I've got it too. Yes, please. Thank you, sir.
So I'm trying to play this file. He's on there.
Careful now, he's getting someone else to do it, and they'll be like, whoops, I played the manipulated one. Which will prove that it was a dog in the background and not the other victim, Joseph Ryan, who had been shot once but was still alive. Is that the point of this? Yeah, you guys are like, no, nope, not hearing it. Let's keep going. No one can hear a damn thing.
I mean, I have IT here to help him as well.
Oh my word. Honeybee says, OMG, Grizzly, your new thumbnail for the stream. Oh, not right. Jail letters. I have to put something interesting on there. Jail letters, and the defense is dragging ass. Oh, sorry, what? Have you considered unplugging it?
32. Fairfax County 911, where's your emergency? Hello, Fairfax County 911.
February 24, 2023, 7:47:39.
Sir, were you able to hear that?
I was.
Okay. Now, that 911 call was the comparison to Lily 3 that you had received, correct?
Correct.
And what, if anything, did you do with just the 911 call?
So the 911 call can be broken up into three separate parts. The beginning is the dispatch, well, it's an automated voice talking about the date and time, and then it's the dispatcher's voice answering the call. And there's a little bit of background noise during that when the dispatcher's answering. And then there's this brief, it's about a second and a half. I think it's 1.4 seconds of what could be a groaning sound. And that is really the only portion of the recording that I did anything with. So I ignored the automated voice at the beginning and the dispatcher answering the call. I used the 1.4 seconds after that before the end of the call, which is the dispatcher asking again if there's somebody on the line, and then the automated voice again, and it ends. So it's really just that 1.4 seconds in the middle of the call where that apparent groaning sound is that I focused on in that recording.
Okay. There's been a foundation objection relating
move your
to...
microphone back up? Move your microphone, thank you.
There's been a foundation objection relating to the Lily 3 file that you've received. So...
I'm telling you, man, is that where he's going? Is he going to try to say that the noise you hear in the background is really a dog howling or something? Is that where we're going? Because damn, bro, seriously, how much did you get paid? Oh my goodness. Also, the 10th LTR said he's reading. It does look like he's reading. Oh dear.
We're going to have to get evidence as to the foundation before we can continue on with your examination.
Okay.
I'm not certain when that will be, but are you willing to get back on at the appropriate time?
Yes, sir.
My goodness. Also, True Crime Fan 2026 said that the dog was in the basement with a bowl of kibble and a narrow bone in Babygate. It was on the body cam. Brendan Banfield moved the dog outside before the police arrived. Brendan said it on the later 911 call. Like, this is so the defense strategy is gaslighting. Okay, I get it now.
All right, is there any cross-examination based on?
Not at this time.
All right.
Your Honor, I would, at this time, continue on with our previous examination and have
All right.
Mr. Barreiro come back
On
in
call.
when the
Okay,
time's
Mr.
appropriate.
Barreiro, we'll call you again when we need you, okay, sir?
Okay,
Thank
thank
you.
you.
Your Honor, if you could admonish him that he's subject to recall and can't discuss his testimony.
Right. You are subject to recall, sir. You're kind of in the middle of your testimony at this moment, I guess, in a way. So you really can't talk to anybody in the case to include the defense team at this point, because it seems like he suspended your testimony, okay?
Yes, Your Honor.
Okay, thank you. All right. Thank you, guys.
I mean, how does the defense
Your
plan
Honor.
to get that into evidence? You can't. He's like, it's okay. We'll call him back another time. Why? You can't. Okay, anyway.
In terms of speaking with him, can I speak to him about the timing of when he may be testifying again
Well, yeah,
without?
we'll take care of that.
Okay.
We have his email now and everything, so if you could let us know, we can contact him and make sure he's set up.
Okay,
Okay?
thank you.
Just give us enough lead time to do that.
Yes.
All right, want to come back to Stan in a moment? Can you get that back off?
I'm hoping.
You want to give it a second to finish?
Yeah, don't get hit by the
You're going the wrong way.
max header.
Guessing they're going till 5? It's 25 past 4. The jury's in the courtroom. Oh, we're never going to forget this trial. But for different reasons than others. Yeah, Stefan says, so what happened to the what happened to the cake? Remember that the defense attorney said that he wants this private investigator to continue on for about 2 hours. So even if he goes now for 35 minutes, he's coming back for 90 minutes next week. And then he wants to recall that other expert to what? Testify that that was a dog in the background? Are you crazy? You really gonna do that? And then we still want to see Brendan Banfield on the stand, which we were all so hopeful that it's happening today, because the defense attorney said yes when the judge asked, will he be taking the stand? He said yes. Clearly the yes was like, oh yes, but not today. Probably in February. Grizzlies, that's our private jet. Let's go. We out of here. Brendan Banfield, if you're asking yourself, is this how all trials go? No, not at all. Definitely not. Thank you, someone. Say, keeping Grizzly. Great job, mods. Thank you for spoiling the mods. Cricket Pie said, let's not forget, once the defense rests, the state has the opportunity to present rebuttal evidence or witnesses. After that, the defense can do a... Really? Can they do that? The state says they've got at least 2 rebuttal witnesses. Oh, my. Oh, my word. If we're 1 minute behind, I'm skipping 1 minute forward.
Number 20.
What exhibit number?
Here, I believe this is 190.
Judge, I have 190 as the January 23rd, 2023 login to CBRN 920 at 11:22 p.m.
That's not 190.
Thank you, someone, for the snarky coffee. Orange Cat Wrangler says this PI has grown a beard since taking the stand. Can you believe this defense attorney? Like, really? Wow. At this point, it's quite fascinating to watch. Like, wow, really? Just going to go on and 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 on for eternity. February 2027, you guys. Guess what we're doing for the rest of 2026?
I think it's, I don't know.
No, 193.
184?
Yeah, that's it.
You got 189?
189.
No, well, he just, no.
Why does he never
that has
get the
4 more
exhibit
blocks.
numbers right?
It's not that one either.
Like, never.
That one was when they added blocks to it. So
This is 184 that he's got.
it's 184.
Yes.
The one on the screen right now.
184. It's not in evidence.
Correct.
Sir, can you see the slide that's on the screen designated as Defense Exhibit 184?
I see a slide on the screen, yes.
Okay. And what is that?
This is a Google map with overlay points that I put on to show 5 locations relative to the Banfield residence.
Okay, and.
Map time.
What, if anything, did you do in your digital forensics analysis to create this?
I reviewed the Google geolocation records that we discussed earlier. Also, T-Mobile provided locational records related to, in this case, Mr. Banfield's device. T-Mobile records with location information were obtained by the Fairfax County Police Department, both related to all calls and data sessions. So those were also consulted and were inputted in where appropriate. I don't know if these particular points are from the Google records, the T-Mobile records, or a combination of both.
And, sir, this is the document that was created relating to those returns that we were looking for from Google and from T-Mobile, correct?
I was searching for the Google records. I wasn't asked to search for the T-Mobile records.
Okay. Well, just in anticipation of that. Your Honor, I'm going to move on to the next slide, which would be designated Defense 185. Sir, do we have those records?
You haven't moved. What? We're still on 184.
Okay. Your Honor, the records are still be supplemented. He was
I understand,
working.
but you said you were moving on to 185, but this isn't 185. This is still 184.
I'm sorry. Sir, this would be 185, Your Honor?
No, Judge.
That is not. That looks like
185 was the
180.
213-23 records.
So I'm saying that the defense is trying to, create a lot of distance between Juliana's testimony and the whole defense case. But then, if the state calls her back as a rebuttal witness, then what? Like recalls her? Can they? Can they recall her? Did they say they release her or what? I think they could recall her. Christine, thank you for the 5 snarky coffees. Can you imagine the state's like, put Juliana back on the stand. Let's just recap there. So let's talk about your letters. How about that? Okay, anyway.
What number is this one? I have it as 180. Is that correct or no? No. I have artifact information. No, that's a different one.
Judge, I don't believe we've yet discussed January 30th.
I don't see it anywhere. Would you like to? We have not seen this one. So would you like to mark it as 193?
Yes, ma'am.
All right.
Sir, look at what defense exhibit that has been marked as 193. Do you recognize that?
I do.
And what is the basis to create that slide?
These are 2 login artifacts from the alleged suspect Gmail account, the CBRN 920 account, both on January 30th, 2023, one at 10:36 and 38 seconds p.m., the other at 11:03 and 25 seconds p.m.
Testing, YouTube testing, mic check. That's more interesting than the testimony, right?
Both from a Banfield residence, both from a Windows-enabled device.
Your Honor, move this in as Defense Exhibit 193.
No objection.
193?
Sir, can you explain to the ladies and gentlemen the significance of these artifacts?
These are 2 additional logins that occurred from the Banfield residence, again on January 30th, 2023, at 10:36, 10:37 approximately p.m. and 11:03, approximately 11:03 p.m. as well, both from a Windows computer, both into the CBRN 920 account.
Oh no, you guys, you mean I'm having technical problems and I have to go? Ooh, you can't hear me. Can you see me? Hello? Say no, say no. You can't see me or hear me. Oh no, the stream is shutting down. Please. Please, can that be the case? Whoops. Suddenly we have no internet. Oh my.
Your Honor, I'm going to move to the next slide.
All right.
Sir, do you know this slide?
I do.
And how did you create that?
This is FetLife messages, again, from the FetLife, the complete FetLife message set. This is limited to 2 messages that occurred on January 30th, 2023, around the same time of the Gmail account logins we just spoke of, one at 10:47 p.m., the other at 10:58 p.m., both outbound from the account purporting to be that of Christine Banfield's.
No way. Noni SA said, time to move on. Ay, ay, ay. All right. Or we could say, ay, ay, ay. Yeah, time. It's time. But we're not gonna. We're not going to move on. We'll finish in February of 2027, okay? Southern California says, gee, don't do us like that. Yeah, whoops. Technical difficulties. Bill Gates does it again. And I'm out.
And, Your Honor, I move this in as defense
No
exhibit
objection.
194.
Oh, you,
No objection.
okay, 194.
Should it be? No.
No.
And sir, can you describe how you acquired these messages?
These were acquired by the Fairfax County Police Department with a search warrant. These were provided in discovery in a spreadsheet, and that is what I used to create this subset here.
Your Honor,
We're gonna
we
see the
move on
maps.
to the next slide. This would be marked as Defense Exhibit 195. What are these records from?
These are Google geolocation records, again, related to Mr. Banfield's device from January 30th, 2023. 2 records, 2 geolocation points. In the same time frame we've been discussing, one of these is at 10:50 p.m. on the 30th. The other is at 10:52 p.m. on the 30th.
Okay, and were you able to identify the entire record that makes up this screenshot?
I was, yes.
Okay, and that's something to provide for this and others that you did screenshots on?
Yes, this is part of the massive spreadsheet that has all of the records.
Okay, even the witness is getting tired of this. I could see it. The witness is like, let me out.
Sure, does this relate to those records as well? This would be 195, 96.
I believe it does once the plots are pointed, but yes. For now, it's just a Google map of the Reston Herndon area.
Judge, we won't look to move that into evidence until we get the document to Ms. Sands. And same with this situation, with this particular slide?
Yes, these are the 2 aforementioned Google geolocations, approximate location on the map.
Okay.
So Judge, that would be 197?
Yeah, that one's
197.
197. Thank you.
Who will be the Grizzlies? Who will stay till the end of the day? And are we all going to need a break this weekend or what? No, I never really take holidays. I feel like we all need one after this. Don't worry, I'll be here. I'm just saying.
Judge, this would be identified as Defense Exhibit 198. Sir, have you seen these records?
I have.
And is this something that you created based on the artifact information?
This is just the artifact information copied out and pasted as a solo artifact for display.
Okay. And this is a different date than what we just previously looked at, correct?
This is February 7th, 2023 at 10:02 PM.
And what are the significant parts of this exhibit?
This is another login to the alleged suspect Gmail account, also from the Banfield residence, also from a Windows computer.
Your Honor,
Do you recognize the alleged suspect in the courtroom? Yes, yes, I do. Can you point at him, please? There he is.
I move that in as Defense Exhibit 198.
Any objection?
No, ma'am.
198.
And I'm sorry, the notable portions of this were?
The date and
Judge,
time.
asked and answered. I think we've
Sustained.
identified its value.
Next question.
Your Honor, I'm going to move to the next slide. And sir, are these documents that you used and created in your digital forensic analysis in this case?
This is a screen grab again from the FetLife larger production. These are 3 outbound messages from the account purporting to be that of Christine Banfield, all on February 7th, 2023, one at 10:08 PM, one at 10:12 PM, one at 10:15 PM.
Your Honor, I'm going to move to the next slide. Actually, I'm sorry. I'd move to admit Defense 199 into evidence.
Any objection?
No objection.
199.
Your Honor, I'm going to move on to the next slide.
Could you move on to the next
So
witness?
what are these?
These are additional Google geolocation points provided regarding Mr. Banfield's device. These are for the same time period. This is February 7th after the conversion. These are in Zulu time, but February 7th at 10:04, 10:06, 10:08, 10:10, 10:12, and later in 10:12 with their corresponding geolocation coordinates.
And you have the supporting document from where you got this screen grab?
I do.
Okay. Your Honor, identify that, and we'll move to put it into evidence at a later time. I'm going to the next slide. This is what will be identified as Exhibit 201. Do you recognize that?
I do.
Is that related to the screen grab that was just in the last slide?
It does. This is the map that will be used to depict the geographical coordinates.
Okay. Your Honor, we'd identify that as 201 and move to admit into evidence after we provide the main document. Moving on to the next slide. Is that the same
It didn't.
situation?
It is with,
the 202.
Is that still 201? Or no?
well, now that,
Oh, we've added the icon.
yes,
added the icon.
one of the geocoords is there.
And that relates to the same Google search warrant records that you received?
It does.
Okay. Your Honor, we'll ID that as 202 and move to admit once we provide the main document.
Let's test my mic while I read this out. I don't know how to say your name correctly. Kirsten, okay, trying to buy coffee for the mods. My ears are bleeding and I'm fed up with the defense. Get to the effing point. Thank you for your sticker.
Sir, do you see the screen in front of you?
I do.
you identify this document?
Again,
Okay. And how did you create this document and what does it contain?
this is a screen grab of timeline data from Ms. Banfield's mobile device or cell phone.
Your Honor, I move that in as Exhibit 203.
Any objection?
Judge, again, the document lacks column and row headers. I have no idea what.
Foundation is the objection.
Yes, ma'am.
Sustain the objection.
Sir, this particular document, is this something that you created?
I captured the screenshot, but this is information
Sorry.
that is presented to me in the forensic software that I use to review the artifacts from within the subject device, in this case, Ms. Banfield's cell phone.
And are there headers and other such things to go with this document?
There are. This one in particular came from a timeline view as opposed to an artifact view. So this is a point in time, in this case on February 23rd. This one's in UTC. February 23rd, beginning just before 9 p.m. through around 9:28 p.m. And because it's a timeline view, it's everything that was going on the phone at the same time. So it's not just emails, it's not just website visits. This one begins with an instant message, goes to an email, website cookies, and then back to messages.
Okay.
Yeah, cookies.
I think the foundation of it is something that we're going to have to provide in order to be able to introduce that into evidence. Do we have those documents?
Well, this is part of this is from the portable case. So it's, millions of documents all in one thing.
Millions?
I can.
Can we go through, are we going through the millions? Where are we at now? Oh my. Balmoral Springs says, what's the point of this testimony? If only we all knew. Just to speculate. There's really no point to it. No significance at all. Anywho, I'm very proud of you all for sticking here with me. Damn, there's still just over 6,000 people here. That's amazing. Thank you for being here with me still. Joanne Dorazil said we'll never need sleeping pills after this trial. Never. Never.
I can try to replicate this with the column headers if that makes it easier, and we could.
Now, the portable case, I think we've gone through that before. That's a tool in digital forensics, right?
It is.
And would there be header columns in that portable case as it shows?
Yes, there will be.
So it's possible to provide that for purposes of the Commonwealth's objection?
Yes, that can be.
Your Honor, we'd identify that as Exhibit 203 and move it into evidence at a later time.
At a later time. It's 12 minutes to 5, guys. Local time.
Sir, do you recognize that?
I do.
Identified as Defense Exhibit 204. Your Honor, move that in as Commonwealth's Exhibit 204.
Objection, foundation.
Foundation objection.
Do you have the foundation for this or where this came from?
I do. This is a similar view, a timeline view of the activity on Ms. Magalhaei's phone from about the same period of time, February 23rd, 2023, beginning at about 8:56 p.m. through approximately through approximately 9:09 p.m.
All right, Your Honor, we'll identify that as 204 and move it into evidence at a later time.
Mr. Carroll, do you have any evidence that you can go forward on that you don't have to get other supporting documents for? Because we're just spinning our wheels right now, because we're going to have to go back to all of these. And so
I understand.
I'm just not interested in wasting the jury's time.
Yes, Judge, say that.
I have these presentations based on days, Judge, but based on the Commonwealth's objection of foundation, we need additional information in order to satisfy that foundation.
All right. That's fine. So you don't have any other questions? Without foundation.
Well, I can certainly check, Judge, as I go
right.
through. I'm just identifying these so that,
I know, but you're just identifying them, and we're going to go back, and it's not saving us any time. We're going to have to all do it again.
I can go ahead and see if there's anything that we can
All right?
work with now.
Okay.
You could just rest. That's another option. Just put him on the stand. We'll wait. I mean, really read the room. I can't think of any other reason the defense would do this other than just earning a lot of money. I don't know. Getting paid by the hour. Private counsel, like what? Why would you do this? This is so wild. I hope does he sleep well at night? Is he exhausted? Like, oh my word, I can't believe I did all that. Like, what does he do when he gets home at night? Like, is he like, oh, that was wild. I can't believe I went on for so long.
Sir, do you recognize that?
I do.
And what is that?
This is an artifact from Ms. Banfield's laptop, Lenovo laptop.
And is that something that you utilized in your digital forensics analysis?
It is, yes.
Your Honor, I'd move that in as 205.
Any objection? All right, 205.
Sorry.
Lisa says Zurich strong before going into any severe US storm. Take care of for your kids, cats, dogs, and all beloved ones. Thank you for your sticker. Deborah McGee, thank you so much for yours as well.
That's fine, 205.
205?
205.
Yes, thank you. Sir, can you tell the ladies and gentlemen of the jury how this is a part of your digital forensics analysis?
So again, this is timeline activity, as I explained. I like to look at what was happening before a significant event, after a significant event, during all of the time periods around a significant event on relevant devices, the laptop being one of those. This is a file opening or file page access for a Word doc or a Word document, a Microsoft Word document, docx file from an Innova website. And this occurred on February, again, apologies, this is in UTC time. This occurred on February 23rd, 2023 at 9:33 and 52 seconds, so 9:34 p.m. Approximately 9:34 p.m.
Your Honor, I'm going to move to the next slide. Sir, do you recognize this?
I do.
And what is this?
This is an image from an Instagram page.
Whose device is it taken?
This is from Miss Muggle High's device, her mobile phone.
Your Honor, I move this in as Defense Exhibit 206.
Any objection?
Judge, I'm not sure if it's just my screen, but it appears to be truncated. I think there should be more data below.
Oops,
Wait a minute, we lost it there.
I was trying to reduce it.
Is there any data behind, after the fourth line?
There is not, ma'am.
There is?
There's not.
There's not?
No,
There's not, okay.
just to save Mr. Carroll.
That's all there is. Any objection to 206?
No, if the statement is that there was no other data on this page, then
There may be data, if it was there, that was definitely truncated, so it's not something he's going to be able to find. I'd have to check and confirm whether or not that's the case.
objection,
All
foundation.
right, I'll sustain to foundation.
I don't know. Has he had any water?
Your Honor,
Maybe in the
move on
break.
to the other slide.
That face at the end. Maybe
This would be
during the
identified
breaks.
as, Defense Exhibit 207. Sir, have you had an opportunity to look at that?
I have.
And is this something that you work with in your capacity as a digital forensics analysis?
It is.
Your Honor, I move this in as Exhibit 207.
Any objection?
No, Judge.
207 in evidence?
Can you describe for the ladies and gentlemen of the jury, what is this artifact, and what's the significance of it for February 23rd, 2023?
So this is a visualization of, it's two artifacts of the same thing, and this is an example of corroboration. So on the top half, we have the artifact of a Google search and website visit from Ms. Banfield's laptop computer. And that was on February 23rd, 2023 at 9:34, approximately 9:34 p.m. On the bottom half of the screen, the second artifact is what Google provided in their responsive documents to the search warrant. So we're able to just visualize the same search, but how it appears on a Google response versus how it appears from within the computer itself. Obviously, the Google portion is in UTC and differs by a second, which is not uncommon.
Your Honor, I'm going to move to the next slide. This would be identified as Defense Exhibit 208.
We've never not wanted to see Uncle Google until today. We're like, you could see yourself out, sir. Based on what the defense has, we don't want to see what their Uncle Google has.
8. I'd move that into evidence.
Any objection?
It's a duplicative of the last slide, or at least half of it.
I'm sorry, I didn't hear.
It's duplicative of 207,
That's the bottom of 207.
correct?
Right.
Is there any reason, is it true this is duplicative?
It is, it can be
Okay.
skipped.
And we'll disregard. Actually, we won't, it's 208.
It is
So,
208.
Your Honor, I'm going to go to the next slide.
Sure.
Sir,
So the witness is now uncomfortable too, Mr. Carroll?
do you recognize this slide?
I do.
Okay, and what's the significance of this slide?
This is from, this is an artifact from Ms. Banfield's mobile device, but lacking the requisite header information, I guess.
Shame at this point. This witness is really like, he's lost all enthusiasm now. EVG70, thanks for being a member for 31 months. You said, love all you do, G. Thanks so much.
We identify this, Judge, as 209, I believe.
All right.
Sir, can you see what has been identified as Defense Exhibit 210?
Again,
Okay.
What is that?
this is Instagram activity from Juliana's mobile device.
And what's significant about this Instagram activity?
The time and date.
Your Honor,
A shame. Now see the guy who likes to talk so much, he's now giving 1 or 2 word answers. That's got to tell you everything. Jana Frieslander, thank you for your $20 sticker.
move this in as Defense Exhibit number 209.
210?
I'm sorry, 210.
No objection.
210 in evidence.
Mr. Lidsky, is there any further explanation of what this is beyond what you've already done?
It was activity occurring on the mobile device belonging to Ms. Magalhaes on February 23rd, 2023 at 9:34 and 24 seconds p.m.
Your Honor, I'm moving on to the next slide. What, if anything, is this?
This is an annotated artifact of, obtained from Ms. Banfield's Windows laptop.
Okay, and is that in UTC time?
It is.
Okay. And is this something that you relied upon in your digital forensics analysis?
It is.
Or I move this in as Exhibit 211.
Objection, speculative and testimonial. It has additional information on it that was created by the witness, not by the device.
All right. I'll sustain the objection.
These annotations, sir, are those something that we can modify so they're not on there?
Yes, I suspect the successive slides will have similar annotation.
Okay.
That should have been removed. My apologies.
Sir, this is identified as defense 212. Do you recognize this slide?
I do.
And is this part of your digital forensic analysis?
It is.
And Your Honor, I move this in as defense exhibit 212.
Any objection?
No objection.
212?
And sir, can you explain for the ladies and gentlemen of the jury, once it comes on, as to what is contained in this? And
These are two telegram messages being sent from the account purporting to be that of Ms. Banfield's. These are in UTC time. These were both on February 23rd, 2023, the first at approximately 9:35 and 47 seconds p.m., and the second at 9:36. Both one way from the account purporting to belong to Ms. Banfield to Mr. Ryan, or to the account purporting to be that of Mr. Ryan.
Your Honor, I'm going to move to the next slide. Sir, do you recognize this slide?
I do.
And where does that come from?
It's a continuation of the telegram conversation.
Your Honor, I move that in as exhibit 213.
Any objection?
No objection.
213?
And what is that for the ladies and gentlemen of the jury?
These are two additional messages, the same direction from the account purporting to be from Ms. Banfield outward. On the same evening, 2023 at 9:36 and 27 seconds p.m., the second at 9:36 and 31 seconds p.m.
Your Honor, moving on to the next slide. This will be identified as
Skybird 56 says, for sheer perseverance today. Thank you so much.
defense exhibit 214. Sir, can you identify that record?
Again,
Okay, and is this something that you utilize in your digital forensic analysis?
I did.
Your Honor, I move that in as exhibit 214.
Objection subject to additional foundation.
All right.
Sir, can you describe for the ladies and gentlemen of the jury as to how you compiled this timeline?
This is from the portable case data from Ms. Banfield's laptop. This is the timeline view, again, from the evening of February 23rd, 2023, from about 9:37 p.m., all within the 9:37 p.m. timeframe for website activity and application activity that occurred on her device at that time.
Your Honor, I move that in as defense exhibit 214. 214.
Judge, at this point in time, there's still absent information. It's clear that the screen grab has truncated the entirety of the destination website.
All right, I'll sustain as the foundation at this time.
Mr. Lidsky, is that something that we can have the complete picture within that slide?
It is.
Okay, Your Honor, we'll just identify that as 214.
214. Did you want to stop there?
I have one more slide, Judge, if we'll
Perfect.
see where that goes.
He's like, one more,
Sir,
one more.
Can you identify this slide?
Again,
This would be defense 215. And how did you create this slide?
this is another timeline view from the device of Ms. Muglahais.
Your Honor, I move this in as defense exhibit 215.
Objection, foundation.
Foundation objection?
Sir, do you have the foundation? It sounds like the columns and where this originates from?
I do.
Okay, can we provide that?
I can.
Okay. Your Honor, I'll just identify that as 215, and this is probably a good time.
Okay, all right. Ladies and gentlemen, we'll go ahead and release you for weekend and beyond. I'm not sure exactly how long it's going to be. I will
Yeah.
tell you, we will make a decision if, well, first off, if the county closes, the county government closes, Fairfax County government closes, we're closed, okay? So that's easy. They might make the decision as early as tomorrow. So if you hear that Fairfax County government is closed starting tomorrow for Monday, we're closed, okay? So if ever the government is closed for Fairfax County, then we're closed, okay? That's easy. If they don't close, if they have liberal leave, then we make our own separate decision, okay, at that point. So if you only hear liberal leave, wait for our decision. We're going to make our decision by Sunday evening. And we have all your contact information, and we will let you know at that time, okay? Other than that, let me just give you your warning instruction for the weekend. And
Okay, so we will just keep an eye on all that as well to see if they're coming back on Monday. I hope everything will be okay with the storm and that they do, because we're going to need the whole of next week to get through just the defense case alone. Kira Cooper, thank you so much for your $20 sticker, and I just don't want to miss this other one. I always try to read them out, when I get them, otherwise I miss them. Mama Mia said, you really have to respect this prosecutor. Her objections are all valid in ensuring no rot gets through as evidence. Yeah, she's wide awake today. Moonchild said, thank you, Grizzly and mods. You are all awesome. It's been a long week and your Grizzly snark kept me attentive. Thank you all for being here. Let's hear the rest of this.
A couple days after, just to make sure you understand that you're still under your the court's orders. As far as this case goes, you're not to read anything about this case. You're not to watch anything about this case. You're not to listen to anything about this case. This applies to television, newspapers, magazines, the internet, and any online sites. Further, you're not to read, watch, or listen to anything about this case on any social networking site or streaming service. In addition, you must not communicate with anyone about the case, whether in person, over the phone, by email, text, or instant messaging, or by any other electronic or non-electronic means. This also includes your fellow jurors, friends, family, coworkers, acquaintances, and strangers. I also instruct you that you cannot do any research or make inquiries about this case, whether online or by any other means. For example, you cannot look up information on the internet that is related to this case or related to the persons involved in this case or any places that are mentioned in this case. Nor may you consult dictionaries or use any other reference materials. What you learn about this case, again, is limited to what you learn in the four walls of this courtroom when the proceedings are underway, okay? So I'll release you for the time being, and stay safe and warm, and we'll see you next week.
Stefan says, I might re-watch the last 2 days over the weekend. Stefan, why would you do that to yourself? Why? Just get AI to summarize it. Say, should I watch this? Anyone who missed it, you're only joining now, yeah, check it out. And let me know in the comments section what you think.
Again, sir, since you're still testifying, you cannot discuss your testimony with anybody to include the defense team at this time, okay? You can have a seat. All right, so we'll start at 10 on whatever day we come back. A couple things. Please use this extra time to reboot a little bit and get more organized.
That's right.
The wheels were coming off there, and I don't want to waste the jury's time anymore, or witnesses' time, or for that matter, my time. Just remember that you are responsible for your record to keep it clean, not me, not Shannon, okay? So please be wary of your exhibits and your numbers and what you are. Moving forward, I expect, and this is what I expect from all attorneys moving forward, I want all exhibits pre-numbered and in electronic format separately in separate files with the exhibit number already titled on that file, okay? And make sure you have all your witnesses lined up and ready to go. Does that make sense to everybody?
It does.
Okay, we've got it. And make sure, Mr. Carroll, I think we need all your exhibits from today. Did we get the video to you?
Judge, your clerk kindly provided the one item. I am still missing all of defense exhibits today.
So we need to send all the exhibits in those same separate files by exhibit number to the Commonwealth and also to us. When you send the exhibits to us, if they're not in the separate files are numbered, Shannon stays here for 2 hours to get it all done so she can take care of it, because she can't leave until all of that is taken care of. So you have to get it to us as soon as possible to take care of, but I just need more organization. I really do, okay? Does that make sense? Everybody get it? All right, see you next week.
That means you, Mr. Carroll. You get it? You got it? You good? Number your exhibits, get organized, get a move on, catch a wake up. Oh, sorry, too much. Oh, shame the judge. She reached her limit there. She's like, oh my word, we are done with this. That was quite something. The last 2 days, I am so proud of you for being there with me. And at every painful moment, we all wondered what's going to happen next. And we watched all of that for hours. Can you imagine? If you missed it, go check it out. Make sure, though, you are subscribed, okay, with your notifications on. And make sure that your phone settings allow you to have notifications if you want YouTube notifications, right? So that when we meet again for this trial, you'll definitely get the notification. Also, if you want reliable notifications, Patreon is a great place to get those. I'll let you know what's happening. I'll keep you posted there. You don't have to join the paid tiers, although I really appreciate it when you do. You could join the public or free tier, and then if it's something like this, like, hey, the trial is actually going to happen today on Monday, for example, I will let you know. I will keep you posted. I will see you, though, this weekend. Okay, you've got plans. Moonchild55, thank you so much for the snarky coffee. Grizzly Cat says thank you. Thank you, Grizzly Cat, for the exhibits and things. Really appreciate that. Really helped for our lunchtime. Hey, Annie Pops, thank you for your $2 sticker. I would not have been able to do this without you guys, and I'm glad we could watch this together, and we're going to watch it to the very end. And I hope that you guys stay safe, that your internet stays on, right, with a snowstorm, wherever you are. And stay warm as well, and well fed, and all of that. And please, everybody, get some rest, because we're all going to need it. We're going to need rest, especially if they're coming back on Monday. We're going to need rest. There's at least 90 minutes left of the private investigator. Then they might recall that other remote witness. Then Brendan Banfield says he's going to take the stand. So, well, his defense attorney said it for him. Okay, when the judge asks, so we shall see. Now, I'm looking forward to read your comments on all the days. Go watch the replays if you missed it. The timestamps are there for you. The playlist is there for you. And I will see you again very soon. If you want the update on the Tepe case, go check out my community tab, because I posted there for you today. The dude was arraigned, Michael McKee. He pleaded not guilty to all counts, and he waived his bond. That's the only update. The hearing lasted all of 90 seconds. We do like that, don't we? Rather than this. All right, everyone. See you very soon. See you in the comments section. Bye.